Be cool, be kind, be classy. A cupcake so sweet and sexy. Have fun, enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. Not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions and lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Sack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Meshegas. Ridiculousness that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcake's sweet and sassy. Not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good morning. Good morning, my friends. Happy Tuesday. Today is Tuesday, February 25th of 2025. And thank you so much for coming to spend part of your morning with me, or maybe even the whole day with me. We'll see how it goes. Today we're going back to Dedham. We're going back to Dedham, Massachusetts for the hearing on the grave concerns of Judge Cannone that she expressed last Tuesday when she decided to cut the hearing short, suspend the hearing, and tell everyone to come back today because of the grave concerns she had, because of some things she learned or some things she received from the Commonwealth that gave her grave concerns that may have a profound impact on not only the defense, but also the defense counsel. Let's take a look at the walk-in. Tom and Boston Mike have the walk-in. So here are Mr. and Mrs. Reed.
You can feel free to sign it if you want.
Good morning. How are you?
Good morning, guys. Good morning.
A lot of people out there for a cold day. It's cold in Dedham today. Helena Rafferty is in the courtroom.
Emma, thanks for becoming a member.
Today, the eye opening. We're very strong. Bureaucratic system is what it is. We're fighting. We know the truth, and you've seen from ARCCA, the science, the physics don't lie, and when you go with that, it's difficult to refute any of the other information. So we're encouraged. We're dying to get in there and hear it.
The reaction to the federal investigation?
Well, they let my daughter go to trial a year ago. So, we're grateful for what they have produced, for sure. I mean, ARCCA and the vile text from Super Michael Proctor was all courtesy of the federal government. So we're eternally grateful for that insight, and so are the lawyers. And I don't understand, where the federal boundaries lie vis-a-vis those of the state. So I can't comment. But, this is still America. And look at this group of people out here. These are folks who will take back this government, this one-party system we have in this state. There's no checks and balances among political leaders and the like. And so we need to take it back. We need to have a two-party state. So let me go in there, okay? Thank you, Sue.
Somebody asked, who is that guy? That's Karen Reed's parents, Mr. and Mrs. Reed.
Yep.
Here comes Karen and the team. It's 49 degrees in Dedham. Feels like 42.
Where's your hat?
So great.
Karen, I spy
And
There's good reason not to.
no, believe that's good information.
From the horse's mouth.
That's good. Have a good day.
Big stupid shit.
Tommy, watch out, buddy.
Aaron, you got it.
Everyone smash the like button on your way in. There's Alan Jackson, David Yannetti, Bobby Alessi, fan favorite. There's Esty. And that was the walk-in.
I can believe it. Let's think. Just
Good morning. Everybody's here today. Alan Jackson is here today. For those of you who are wondering whether or not he would show up, he is here. He is there, rather. In Dedham. I am not in Dedham. I am with you here in my home studio. How is everyone this morning? Jeannie Lynn, thank you for becoming a new member. Henny and Inky's Meow Me. Thank you, Jojo B, for becoming a member. Colleen Elizabeth became a member, and Tracy Walker has gifted 5 memberships. Thank you, thank you, thank you so much to Tracy Walker and to the 5 of you who were randomly selected by YouTube. Welcome, welcome. We're over 6,000 strong today. Make sure you hit the like button, and even if you're a troll and you hate watching me, hit the down like button because, you know, engagement, kind of like Twitter, right? Thank you, Tracy Walker. I appreciate you so much. She's really lately been the queen of gifting memberships. She's gifted, I don't know, at least 200 memberships in the past couple of streams. So Tracy Walker has not gone unnoticed. You're amazing. Thank you so very much. Let's put the feed up anyway, so at least we have it on. And you guys don't freak out. We're not missing anything. It is yet to be determined whether, in fact, it's up, camera's up. Look at that. Whether, in fact, the federal investigation is over. In my opinion, it's not going to change the trial for Karen Read at all. It just means that if it is over, the federal investigation, that perhaps there will never be true justice for John O'Keefe. Because it has been my opinion, and is still my opinion, that John O'Keefe was not hit by a car, and a car did not hit John O'Keefe. Therefore, something else must have happened to him, and therefore, whatever that is may never be determined. And that, my friends, is very, very, very sad. In my opinion, very sad. But it has been reported that the chief of police, Helena Rafferty, is in the courtroom. My sources inside the courtroom tell me she came in and hugged Peggy O'Keefe. She came in through a side door. I don't know if she's in uniform or not. And it has been reported that some of the McCabe's and Alberts are also present and will be present in the courtroom. So this should be fiery today. Fiery. There's Mr. Lally. Good morning, Mr. Lally. Good morning, Mr. Lally. I'm so sorry about your demotion. There's Mr. Brennan. I'm going to see if everyone gives him the cold shoulder today. Yesterday, we did 2 streams, and during one of them, we went back and we watched the end of the hearing, and it seemed to us, well, it was clear that Bobby Alessi said something to Brennan on their way out of the courtroom, and it looked like he was saying something like, "What did you do?" Or "What did you say?" Or "We gave you those materials," or something like that. We couldn't read his lips, but he was not happy, and he wasn't having any of it. I see Karen talking to her father. That is Karen's brother, Nathan. The media is sitting over here at the high top today again. They're back at the high top. They had been sitting right here at the bottom of your screen in the jury box. This is the same courtroom in which the case was tried. It's a very, very tiny courtroom, very wonky layout, because the victim's family sits right here where I'm pointing, behind where Miss Dianetti is standing in front of the media. And so they stare down Karen Read the whole entire time. And then Karen Read's family sits behind her over here, where she is talking to her dad. And the media sits at the high top. There's only 10 seats available per side. So 10 for the victim's family, 10 for the defendant's family and friends, and 10 for the media. So it's a small courtroom. I don't see the chief Rafferty. I see Sue O'Connell over there. She's a local reporter. And we'll see. Christina P. became a new member. Hello. Hey, Mrs. Bouquet. Thank you so much for your super sticker. Did I bite him? Yeah, I bit him. He's been here for 7 months and loves being here. Thank you so much. My mods are the best on YouTube. Absolute best on YouTube. Thank you to the mods. Amy Z says a coworker of mine had the nerve to schedule a meeting today at 11 a.m. What? Don't they know I'm busy? We'll be playing catch up later. Prayers to Karen today. Thank you, Amy Z, for your super chat as always. Love to see you. Charles is here from South Africa, and it is his 66th birthday. Happy birthday, Charles. Thank you for tuning in. The world is watching. South Africa in the house today. And he says, tonight is my present. Happy birthday, Charles. So glad to spend it with you. Amy says in Massachusetts, even though it's still cold, it felt warmer. Yeah, it's 49 degrees. Well, what did I say? 42? I don't remember. I already forgot. It's too early. Iced coffee is here. K-Wags is here. Thank you so much for your super chat. I can never imagine when I tuned in for you to go over the pretrial motions over a year ago that we'd be here. Oh, girl, don't I know it? It's so sad if you think about it, Free Karen Reed. It is so sad if you think about it. It's so sad. It has been over 3 years that Karen Reed has been dealing with this. She has sold her home. She has liquidated her retirement accounts and her 401k. She has spent every dime that she has. And she did not hit police officer John O'Keefe with his car. It didn't happen that way. Physics, science, injuries, none of it makes sense. We are in the land of the upside down. We are in Narnia. We have dug our way through the back of that closet, opened the door, and we are so deep into Narnia and the Matrix that it is not even funny at this point anymore. Sage says, if they're there, does that mean it's true and actually over? That makes me sick. No, I don't think Helena Rafferty being there means anything other than she's obviously there to show support for the O'Keefe family. If she came in and hugged Peggy O'Keefe, and if she's there with her uniform on, that's also interesting because the judge made an order prior to the last trial that no law enforcement were allowed to wear uniforms in her courtroom. So rules for thee, but not for me, I guess is the way it goes. As you know, in Norfolk County, Tracy Walker gifted another 10 memberships. Thank you so much to everyone who is so randomly gifted and so generously gifted. Thank Tracy Walker. If you were gifted, thanks, Tracy. Samantha Jones is here from Sex and the City, my favorite character, and says, good morning, all. Just here to thank and listen to it. Oh, that is a very sweet compliment, saying I'm beautiful as always. Thank you so much, Samantha Jones. Who doesn't love Kim Cattrall reference?
Participant ID followed. Please enter the meeting passcode.
All right. If the court volume is terrible, we will modulate volume as always. So just don't worry. Karen is here and she's giving me a super sticker. Thank you so much, Karen. Appreciate you. Al Dente is here from Canada and says, could Rafferty be there so Brennan can showboat saying O'Keefe McCabe's are being harassed and threatened and need security? Could be. Could be. Interesting thought. Thank you, Al Dente, for your Canadian super chat. And Tara is here and says, I'm so nervous trying to sneak and watch at work right now. Shh, don't tell. Shh. Look the other way. Shh. For those of you who were not with me yesterday, we went over the decision on many of the motions that Judge Cannone issued yesterday. And basically, the defense gets nothing. No metadata for you. No chain of custody logs, no evidence logs, none of it. Because if it doesn't exist, the Commonwealth should not be burdened with having to create it. And metadata is not important. And no, you're not going to get it. You're not going to get any chain of custody for all these rando Canton Sallyport videos that are all of a sudden coming out in a trickle, piecemeal. Many of the Canton Sallyport videos from January 29th of 2022 have been turned over after the trial ended. After the trial ended. As of perhaps last week, the week before, the defense was just given a video from the exterior camera at the Canton Sallyport of Karen Reed's vehicle backing into the Sallyport, which Alan Jackson said in open court is exculpatory. Why? Why didn't they turn it over before the first trial? Why didn't they turn over the video of Brian Higgins talking on his phone outside the Canton PD at 1:30 in the morning before the first trial? Why? Because that motion that was made before the first trial to get the cell phone records of Brian Higgins that was denied, and the preservation order for him to preserve his phone, which was eventually denied, caused him to destroy his phone, crack his SIM card in half, cut through a military base, and throw it in a couple of different dumpsters. So, there's that. But before he did that, don't worry. He went to visit his friend Matt Kelch at the FBI headquarters, and Matt Kelch taught him how to use the kiosk. So he was able to extract and cherry pick some text messages between himself and Karen Read and then print them up and bring them with him to the Massachusetts State Police for his interview, which was, I think, several days after the 29th of January, 2022, and turn them over willingly. But again, none of his actual real data could ever be retrieved because cracked his SIM card. Lady Zelda Kelly is here. Thank you for your super chat, my dear. Says, in my opinion, this was a distraction with the Fed's, quote, announcement for Karen to be rattled. It won't work. Thank you for all you do. You're so very welcome. Lady Zelda Kelly has a channel. She reads tarot cards, and she's got a lot of videos on the Karen Read case. Thank you so much for your super chat. Let the circus begin, says AJ's full-throated motion. The full-throated motion, the motion to dismiss for egregious or extraordinary governmental misconduct has not yet hit the docket. We were waiting for it all day yesterday. We know it was filed on Friday. It's my opinion that it's intentionally not scanned into the system yet so that we couldn't talk about it and look at it before today's hearing, because it is my opinion that perhaps there are so many things in that motion, which will probably be heavily redacted, that are so egregious that the government has done, and that things that the defense has been able to discover through the document dump of DA Michael Morrissey's personal email and cell phone, they just don't want you to know about it yet, maybe at all, if ever. So it's still not there. We can't get it. We can't access it. Everyone just take a deep breath. Thank you, AJ's full-throated motion, for your super chat. And Lady Zelda Kelly gifted 5 memberships. Thank you so, so very much. Big Boy says, love you, Flossie. Okay, shout out to Flossie. Thanks, Big Boy, for your super chat. Parachuting matron saint of Karen Read. Well done. Well done. Became a YouTube member. That is my nickname for Dr. Russell. I started calling her the patron saint of the Karen Read trial. And then in the motion that we read one of the last streams, Hank Brennan said, Dr. Russell parachuted herself into this trial. So well done. We have a sort of a unofficial competition here for people changing their screen names to match the trial. And Universal Truth is here and became a member as well. And that is one of my favorites. Love Nelly. Thank you. Love Nelly. Watching from Northeast England. It's like a dystopian movie. So much strength from Karen. I know. This is a version of The Handmaid's Tale, in my opinion. Fabulous as ever. Thank you so much. Love Nelly. And I appreciate you tuning in from Northeast England. The world is watching. And look, here's Karen. She's watching from Austria. Thank you for letting me be a part of all of you. Thank you for wanting to watch this. Thank you for being interested in this. The world is watching. The world is, there's over 10,000 of you here right now. 10,576 of you. I would really love it if you would hit the like button. It helps share the stream out. It helps people be able to find us and find out the truth about what's going on in Norfolk County, Massachusetts, because this will outrage you if you are not already outraged. Thank you, Karen, for being here from Austria. And I'd love to come there and go skiing sometime. Fire on Acid is here and says, hashtag we ain't got no quit. Thank you so much for your super chat. Samantha Layton is here and she's gifted 5 memberships. So there are a lot of new members today. Welcome, all of you. I think you're going to like it here. Dove's House is here. Thank you for the super chat. Given the circumstances, you would think AJ could ask for an evidentiary hearing on the videos despite being past the deadline. Yes, I do. And I think that is going to potentially have a lot of these people called in as fact witnesses, such as Adam Lally. Where did you get the video? Chief Rafferty, this mysterious retired detective who apparently downloaded all this video onto his private hard drive. First, it was in his private iCloud. Then it changed to his private hard drive. And now the hard drive is allegedly in the Canton PD. And he happened to be there when Hank Brennan went there. If the judge is not going to let them have a chain of custody or evidence logs on all of these videos, then people are going to need to be questioned about it. Witnesses, in my opinion, are going to have to testify about it, and they're entitled to it. And could an interlocutory appeal be impossible if needed? I am not familiar with the rules, and I'm not sure if that is one of the things that they could interlocutorally appeal. It's an appellate issue. I don't know if they can do it, though, in the middle of the trial. What the Duck has gifted five, or even right before the trial, because I don't think it would be heard in time. What the Duck gifted 5 attorney Melanie Little memberships. Thank you so much, What the Duck. Because again, that's what we're saying all the time. What the Duck, What the Duck. Mary Rothman is here. Thank you for your 10 and says, show me the metadata. No, sorry, Mary. You're not entitled to it. No metadata for you. Look the other way. Marsha's dreading this hearing. Don't worry. Take a deep breath. It's all going to be fine. Hallie Faye is here. Thank you, Hallie Faye, for your super sticker. Kyle Cowden is here. Thanks for the 5. I don't have many emotions. Some say I'm cold, but I have one feel, and it's all twisted up over this. Praying hard for Karen Reed and anything to stop this. Well, I mean, come on. There's one thing you know, Kyle, and that is that Alan Jackson does not come in without receipts. He just doesn't. Here comes the judge. Here comes the judge.
You are unmuted.
22117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves, starting with the Commonwealth?
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin.
Adam Lauer for the Commonwealth.
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Okay. Sound stinks. I'm going to modulate my volume, so just give us a second. If you're ahead on another stream, please, no spoilers. But we need to do this because the court audio is often really, really, really bad. So I'm going to turn my mic down so that you can turn your volume up. Okay, that's me.
Good morning, Mr. Brennan.
That's court.
Good morning, Your Honor. Alan Jackson from Ms. Reed.
Good
That's me.
morning,
That's
Mr.
court.
Jackson.
Better?
Your Honor, Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Good morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Mr. Alessi.
Good morning, Your Honor. David Dianetti for Karen Reed.
Good morning, Ms. Giannetti. Good morning, Ms. Reed. All right. So last week, upon hearing of a previously undisclosed.
All right. Well, people are saying it's still low. Let me just turn mine down a bit. Okay, that's me now.
Relationship perhaps between defense counsel and the ARCCA witnesses. I took a recess here. We suspended. I had heard about email communication, detailed communication, memorializing a conversation regarding an engagement letter and a promise of retainer on March 20th and 22nd of last year, roughly 2 months before the ARCCA witnesses testified. There is another email that was 2 days before the trial and 2 days or after the voir dire, 2 days before the trial with a list of cases. The Sunday before the witness testified, there's a proposed script of questions and answers and suggestions. And after the trial, there is an invoice or a bill, not just.
This one's going to be better. Hang on. This volume is better. Let me stop that. Hang on.
With counsel in the court regarding if it's travel and trial, there is to talk.
This is Boston 25. It's better. Hang on.
To reflect, to talk to each other about the opportunity.
Here we go.
with counsel in the court regarding the Rule 14 obligations. And frankly, I didn't think it was fair to have defense counsel stand up and have to answer to that without the opportunity
Worried about fair.
to reflect, to talk to each other, to look at transcripts, to consult with people, and that it made sense
People
to
like
give
your
you some
lawyers.
time to do all of that, because what the Commonwealth raised does raise serious issues, not just the rights of counsel, but Ms. Reed's right to a fair trial and all that that entails. So it made sense to me to suspend first and foremost for that reason, so counsel can be prepared to make any comments if you choose to. Second reason is what the Commonwealth told us is inconsistent with my memory. So I wanted to make sure that my memory was right. So in a way to do that, I went back and reviewed the transcripts again. I started with the June 10th transcript of the discussion with Ms. Giannetti, where I raised my skepticism about defense counsel in a murder case calling not one, but potentially 3 witnesses that you never talked to. I looked back at the June 8th.
They don't need to talk to them when they have their report and they know what they're going to testify to because they know what their findings were. John O'Keefe was not hit by a car and a car didn't hit John O'Keefe.
18th voir dire hearing, the June 24th trial testimony of the ARCCA witnesses, and the June 25th closing arguments of counsel. So after reviewing that, and my memory was pretty good about that, but what concerned me most is the memory that I had of a discussion here at Sidebar on February 6th, so 3 weeks ago, not last June, outside the hearing of everybody in this courtroom.
Mm-hmm.
And at the time, I was operating under the assumption that counsel was unable to provide the Rule 14 discovery because of a federal protective order. And the discussion at Sidebar clearly revealed that, and counsel did nothing to disabuse me of that. So I asked the trial court to expedite a hearing, a transcript of that hearing. Mr. McDermott's going to mark it as evidence. And at that point, Mr. Jackson,
She's talking about stuff that we haven't heard because it
you
was
didn't
sidebar.
answer me at first.
Sidebar, so we don't know what it's about. But she's got the transcript there. And now she's going to tell us what it's about.
You did, you said, I can tell you this. The Commonwealth is saying, pursuant to Rule 14, and you know, exclusion and preclusion of a witness is a punitive sanction for Rule 14 violations. Ms. Reed has not violated anything. Why should she be penalized when the Commonwealth has the exact same batch of information that we have about these witnesses? So I don't have any more information. I don't have any additional discovery. I didn't hire them. I didn't ask them to engage in additional protocols. So I've got nothing else to give Mr. Brennan. He's got the same information I got, and he got it at the same time. So that was concerning to me. Jim, do you have a copy of that there that you can?
Concerning?
And I made sure, so the transcript is of the entire hearing because I don't want anyone to think anything's out of context. So we will mark that as an exhibit.
I don't want to think you're biased or...
And the third reason I paused is because, frankly, I needed time to reflect. I don't know what may flow from this. Obviously, I have to make findings, whatever they may be. But I wanted to explain why we recessed. I sent that one-page notification out last week about what we would be discussing. So I will hear from defense counsel if you want me to hear from you. If you don't want to say anything, that's fine too. But if you want to be heard, I will hear from defense counsel.
Your Honor, thank you for the opportunity to be heard. I am going to be responding on behalf of defense counsel to all of your concerns. I have a notebook that I've given, albeit just now, to Mr. Brennan. It's got exhibits, but it's everything that everybody's already had. It's similar to what you're doing, transcripts, documents, probative issues. And if, with your Honor's permission, I'd like to provide you with the notebook so that you can follow.
That'd be great.
And should I hand it to someone here to have it handed to you, bring it up?
A court officer will take it for you.
Okay.
I appreciate that, Mr. Alessi.
You're welcome.
I love it when they give the judge handouts. Fantastic.
There's another notebook to follow along. And with that, Your Honor, I'm going to go to the podium and make my presentation.
Bring it, Bobby.
You know what? Actually, I'm going to take 5 minutes to just quickly go through this.
That would be excellent. Thank you, Your Honor.
Actually, she's going to take a time out and go back and review it. Actually.
You are muted.
Alessi is bringing it. He has brought it. He's prepared. We can catch up to real time. She's taken her little 5-minute time out to go back there and read it, consult, take a phone call. Who knows? She's taking a powder. Yeah, are you kidding? The grave concerns over something that happened at a sidebar that we were not privy to. Okay, she wasn't prepared for them to be prepared. She even said, you know, if you want to speak, well, gee, I don't know, Judge, do you think I'd want to speak when I was blatantly and not even absolutely blatantly accused of ethical violations? When Alan, the defense is looking for all the materials that the ARCCA witnesses reviewed that they were given from the feds to do their investigation. Alan Jackson is not in possession of those materials. The defense is not in possession of those materials. And Brennan knows that because when he sent his 2-year request in February, or whenever he sent it, I think maybe it was in December, they were non-responsive. They gave him nothing, the feds. So Alan Jackson is not lying to the court when he says we don't have any more to give them. We don't have the materials that the feds gave the ARCCA witnesses to do their accident reconstruction. We don't have it. We have nothing more for them. Yeah, I'll slow the chat down. Hang on. And so is she going to say that because on February 13th, the defense turned over an email or two and an invoice that somehow Mr. Jackson was lying to her on February 6th? Because if those materials were after February 6th, like the invoice, which Brennan doesn't even say was dated or not, she's making a big deal about something that could potentially be nothing. So we're going to wait and see, and we're here for it, and we're live. We're on real time now, so that's a good thing. All right, it's on slow mode. Slow mode.
Feel like you're on a boat?
You said you feel like you're on a boat?
Why does it still not look right? I know.
Hot mics are here. You guys, is the volume better? Volume is definitely better on Boston 25, and my volume is equal. I mean, if my volume is equal to the court volume. Yeah, no, she's not letting us hear the hearing classic clipping, and that's why everything in this case has been done at sidebar. All objections were heard at sidebar. Everything's been done at sidebar because they don't want the world watching, you guys. Sorry, but it's true. I did slow the chat. Thank you so much for your suggestion, Leah Lou. It's slowed down to 60 seconds. There's 13,000 people in here. So if you want to slow the chat down on your own, you can put your finger on it and it'll slow it down. If you're on a laptop, you can put your cursor on it.
They're right up there. They're right up there.
You are unmuted.
Tracy wants everyone to pray.
No, you got the other side.
Michelle is here. She was, here she's back. Timeout is over.
All right, so I apologize if that wasn't quite 5 minutes. I just wanted to see what it was that you had there.
Are you comfortable with what's in the notebook?
Yes, if I haven't read everything, but I know what each of them are.
Then maybe you should have read
Yes.
it. Erin O'Keefe, Paul's wife, is not in the courtroom today. Shocker. Not really. Thank you, Emma, for gifting a membership from Ireland.
May I proceed, Your Honor?
Sure.
Thank you. May it please the court. I understand the moment. The moment has categories and components. And in my presentation today, Your Honor, I am going to go through those categories in this order. I am going to start with the notebook that I handed to Your Honor and to Mr. Brennan this morning. The notebook is purposefully in chronological order. The notebook is in chronological order because I believe the best explication of the facts and what those facts mean come from a proper chronological presentation of the facts. I also believe that the chronology is going to address many, if not all of the concerns as I understand from Your Honor. Your Honor, of course, will be the ultimate arbiter if they successfully address those concerns. But my intention, Your Honor, is not to obfuscate, not to conflate issues. To the contrary, my intention is going to be to elucidate and to illuminate so that Your Honor can make the proper determination. That is my genuine goal for my presentation. As I go through, and I know I don't have to say this to Your Honor, you can feel free to interrupt, pressure test me on anything I'm going to say. I would welcome it, but I believe if I can get through the chronology, my hope is that the facts will speak for themselves. But that brings me to my second component of understanding the moment, which is going to be to also add to the fact is what happened at the last hearing, on February 18th. And I have the transcript for that, and I have that in the notebook, because I believe that is also critical to the proper elucidation of the facts.
So that's the only thing I have not previously seen.
The February 18th transcript.
Yes.
There are 9 pages that I'm going to go through, Your Honor. And because of the stakes here, I am going to go through it hopefully efficaciously and efficiently, but it's going to have to be methodically.
All right, so you were addressing this in chronological order as well, right? So if you can tell me those pages now, I'll likely recess because I do want to see them before you talk about them,
Sure.
but I'll hear you going up to that point. So what pages are those?
And you're referring, Your Honor, to the February 18th transcript?
Yes,
Yes,
your
I will
number.
tell you exact
8.
pages that I'm going to refer to. And Your Honor, get to this is tab 8,
Right.
the notebook.
Mhm.
And specific pages that I'm going to reference start on page 53.
Okay.
And those are 9 pages that proceed all the way to really the substance ends on page 62.
Okay.
And I appreciate that Your Honor wants to take a look at them because I think it's incredibly important for putting in context what happened at that last hearing. And I think it helps also do a compare and contrast to what the actual facts are and to what the statements were that were made on the 18th. So am I understanding, Your Honor, that you would like me to suspend
You
my
can,
brief or keep going?
no, you can keep
Okay.
going and we'll stop so I can read whatever I think I need to read
Sure.
at certain points, but we should be good to at least start.
Thank you.
And can I just ask, when was this put together?
What do you care?
Started,
When was this put together? None of your business. Why? Sorry, I apologize. There's no captions on Boston 25, but the volume is better, so that's what that's what we're going with.
About a day and a half ago and was completed this morning.
Okay. All right.
When was
Go
this?
right ahead, Mr. Alessi.
Thank you, Your Honor. So I start with tab 1, which is the March 22nd, or excuse me, go to the bottom, please, the March 20, 2024 email. And this is an email between Mr. Jackson and Mr. Wolf. It was sent from Mr. Jackson to Mr. Wolf. It was entitled Engagement. And so what I'm going to do is, that's where the notebook starts, but I want to go backwards to start in terms of something that is well known. And that is the federal investigation and the products of that federal investigation produced the ARCCA report. And that was in February of 2024. So what preceded this communication was a production of materials from the federal government, about 3,000 pages. Contained in that 3,000 pages was the ARCCA report of February of 2024. There was no index of the 3,000 pages, and the defense came upon that report. They got to reviewing the documents in March of 2024. And as Your Honor will recall, the trial 1 started in April of 2024. So it was pretty close to when that trial started. And I know Your Honor knows from both your judicial experience and other experience that when you're entering into a trial of this significance, there's a lot going on. And so what happens is that report's produced in amongst 3,000 pages, it is located, it is read, the significance of it is immediately discerned. The report, basically the findings of the report that the vehicle, and this is, the substance is important, Your Honor, because it really informs a lot of the emails. The substance of the report speaks to the issue of whether or not the motor vehicle of Ms. Reed made contact at all with the decedent, and whether the decedent's injuries at all reflect a contact with that report. Those findings in that report was set in cement in February of 2024. What do I mean set in cement? It means they were never changed, nor could they be changed. So that report was provided to the Commonwealth and to the defense. Next step, important also. Any party, the Commonwealth or defense, had access to ARCCA. They had the opportunity to contact ARCCA. There were restrictions that I'm going to get to on that contact. But either party had the opportunity to contact them.
That's right.
Now, only the Commonwealth knows why they didn't take that opportunity. It may be because of the findings. It may be for other reasons. I don't know. But I understand the facts to be that the Commonwealth didn't make contact with the ARCCA experts. The defense surely did. So that is the background. That is the information that we have. And so what happens? The defense sees the report, sees that the information in it is completely exculpatory to Ms. Reed. Of course, any attorney, lest they want to risk malpractice, is going to make a communication with that expert, which was perfectly legal and perfectly contemplated by the rules of the road, if you will. Now, as Your Honor also knows, the rules of the road with regard to the ARCCA expert were not set by this court. They were set by the US Attorney's Office. And I'm importantly going to articulate with objective evidence what those rules of the road were. But the one key point is those rules were not set by this court. So the contact was made. This is one of the most unusual situations I've ever seen in my practice of law, meaning you have these experts, you have great exculpatory information, but there are significant constraints on how it is you can interact and utilize those experts in a complete unorthodox situation. Why do I emphasize that? I emphasize that because lawyers in trial practice are used to doing things a certain way. And when there are certain constraints that are imposed upon them, it becomes more sui generis, more ad hoc. And then there has to be sort of new ways of addressing the situation. That now brings me with that important background to tab 1. And to repeat, the communications start with a report from the ARCCA experts and their findings and their conclusions that never changed. They never changed from the report they generated until the first communication in tab 1. It may seem self-evident, but given the moment, I'm not going to take anything as self-evident. The defense had zero input into the report and therefore had zero input into the findings. And in fairness to the Commonwealth, nor did the Commonwealth. So with that, we come to the emails on tab 1. March 20, Mr. Jackson to Mr. Wolf. Please note that there is no CC to Mr. Yannetti. Why is that important? When we get to Massachusetts Professional Rule of Conduct 3.3A1, that fact is going to become extraordinarily important.
Because Yannetti is overseeing him.
We have a communication.
As a pro hoc vice lawyer, David Yannetti is sponsoring Alan Jackson to practice in Massachusetts, and therefore David Yannetti may be held vicariously responsible for Alan Jackson's actions if he knows of them, if he's aware of them. That's the distinction I think that he's making here.
And it needs to be read in its entirety. Fortunately, it's short. Dear Dr. Wolf, thank you so much for taking the time to get on the phone with me this morning. Pursuant to our conversation, please feel free to forward an engagement letter to this email address. I will get that countersigned and returned to you forthwith, along with your retainer, as required. I have the good fortune of dealing with experts probably every week. And this is classic form parlance. If it's going to be required, you always hope for your client that they're not going to require a retainer. But the language is as required, as. Also, if you could attach a copy of your Dr. Rentschler's and Mr. Klein's CV, I would appreciate it. I look forward to speaking to you and your team soon as we iron out the logistics for your participation in the trial. At that particular point in time, there was no conclusion, no agreement, no knowledge that these folks would actually be testifying. There was certainly the hope, there was certainly the desire, but there was no agreement that they were going to be testifying. That was the hope.
Was the federal protective order that was referenced by Ms. Giannetti that said it was, and it was specifically outlined and ruled that they could not prep with us for trial. Was that in effect at the time these emails were sent?
The answer is, Your Honor, and I'm going to get to it, but I want to answer your question directly.
I'd like you to answer my question.
Yeah, I wanted to say.
Excuse me, let me interrupt you and ask you questions like we're in appellate court and, ruin your flow, but she's not going to ruin his flow. She's not throwing a wrench in his flow. You can see that he is easy. He is ready to pivot. He's got a binder. He's ready to go. He's off the cuff. He's not reading a script like Adam Lally would be. And yeah, she's going to interrupt him. She wants to know if that federal order was in effect. And here's his answer.
But answer it directly. What Mr. Yannetti articulated is the rule of the road, not PrEP, was not a rule of the road. That wasn't the rule of the road, and I have objective proof of that. The rule of the road was there would be no substantive conversations with the ARCCA experts. Okay, that was it. But the answer to your question is I do not know whether the ground rules were in effect, but I can get you that answer, and I will get you that answer hopefully in moments during my presentation, but I do not know the answer.
All right, go ahead.
And it's an important question, and it's an important answer, I understand. But I'm going to give you information that's going to indirectly answer that question, but I'm going to get you a direct answer as well. So you see that there's an attempt to iron out the logistics for your preparation in the trial. Then we get to the email up above, and that is merely 2 days later. Again, Mr. Yannetti is not copied on the email. And my understanding is Mr. Yannetti is not knowledgeable about these communications. So the email reads, "Hi, Alan, subsequent to our conversation on Wednesday, the U.S. District Attorney's Office has asked that we pause on any further conversation until we receive additional information from their office regarding our involvement moving forward. I will provide you an update when we have it." Your Honor, this is not a direct answer to your question, but this is, to me, going to corroborate my point that if there was an agreement and if they were going to be testifying, subject to whatever constraint, this email would not have been sent. There would not be a pause until we receive additional regarding our involvement moving forward. The involvement is clearly in code at that point. Why would Mr. Wolf be saying, until we receive additional information from their office, the U.S. Attorney, regarding our involvement? This is just talking about mere involvement. So what happens is I call this the pause email, and it's regarding engagement. So Mr. Jackson on the 20th tried to get matters started. He's communicating to see if ARCCA is willing, if they're ready, if they're able, etc. And then we have the pause. The next tab is tab 2, which is the very important June 10, 2024 excerpt of the transcript. But the time in between, Your Honor, the March 22nd pause email and the 6/10/24 transcript is also exceedingly important. What happened between that? Well, to state the obvious, the trial had started. The trial started in April. Mr. Yannetti gave the opening argument for the trial. Do you recall, Your Honor, that Mr. Yannetti never mentioned the ARCCA experts in his opening?
I did not review the openings. I reviewed only for the non-evidentiary transcripts I reviewed was only Mr. Jackson's closing argument.
Certainly fair enough, Your Honor. Why do I underscore this point? Mr. Yannetti did not even mention the ARCCA experts because the defense didn't even know if they would be testifying.
Interesting.
The two most powerful witnesses in support of the
I'm sorry, what was the date of the openings?
I do not know. I do not have it. It was in April. We can hopefully get it.
It's like a pop quiz. She knows when the trial started. The trial started in April. You know that. It started way before June 10th, Your Honor. You know that. Come on now.
I can find it. I didn't know if you had it.
So, but clearly, Your Honor, it was between March 22nd and June 10th.
Yeah.
And so the most powerful exculpatory information from what we consider some of the most powerful witnesses were not mentioned because the defense didn't even know if they would be testifying. If there was an agreement that they would testify, that would have been in the opening. But the uncertainty about it is the reason why it wasn't in the opening. We didn't know what would be happening. So that pause continued through the opening.
So they didn't even know if they were going to be allowed to call them, even though they are exculpatory and extremely important to Karen Reed's defense. They were not mentioned in opening. Nothing happened between those two initial emails where Alan Jackson said, we'd like to retain you. Send us your engagement letter. 2 days later, Wolf writes to Alan Jackson, we have to pause. It's called the pause email because the feds told us we have to pause. And the next thing that happens is June 10th, which is at the end of the trial, close to the end of the trial, because the mistrial was declared on July 1st. Not even mentioned in opening because they didn't even know if they were going to be allowed to call them.
That to me is so key because I think it's antithetical to an agreement. Now we come to the June 10 transcript. And as I said, I am going to hit head on these areas. I start with, Your Honor, something that's not in the excerpts, but Your Honor may recall that there were a lot of Rule 14 discussions. And Your Honor and Mr. Brennan read this on February 18th at the hearing we just had, that Your Honor was making the point, which I appreciated, that with this very unorthodox situation, the defense was exclaiming, you were saying, I think you're in violation of Rule 14. They said, we've given everything we've got. We don't have anything more. Well, I know you can't, but you're still in violation. So Your Honor fashioned a remedy. Your Honor fashioned the remedy, the Rule 14 remedy, that there was going to be a voir dire, and that the ARCCA witnesses were going to have to come up from Pennsylvania, and they were going to need to sit for a voir dire. I will get to the significance of that, but that's what started, is the predicate for the discussion I'm now going to focus on. It starts on, this is tab 2, page 2812. Line 5, the court. Now, regarding the 3 experts from ARCCA, so I've read that report. I can't tell who does what or what the basis of their opinion is. So what have you provided? You're referring to the defense, of course. Mr. Yannetti, Your Honor, we've provided everything that we know. We mentioned to this court at sidebar, these experts did not arise from us finding them. The court, I understand that. Mr. Yannetti, these experts were hired by the federal government and they provided a report to us pursuant to the TUI request. And it was specifically outlined and ruled that they could not prep with us for trial. Court, and it's important not to stop there with what Mr. Yannetti said. There's more to that statement. There's an elaboration of it that is important.
Because you know who stopped there? Hank Brennan stopped there. God save the Commonwealth and God bless Bobby Alessi.
So I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. And I want to key into your words, Your Honor, because I want to be fair and precise. Your question—
That's exactly what I said.
Pardon me?
That's exactly what I said.
Yes. And I want to key in on you've never spoken, right, to and putting them on the stand. Now, no one ever said from the defense they never spoke to them. But that was what Your Honor was concluding from what was stated. So what did Mr. Yannetti do in elaborating on his answer? I didn't go back to the video to see if there was Sometimes two people speak at the same time. I don't know. I'm going to assume it wasn't, and this was just a natural flow. So Mr. Yannetti says that's essentially it. But what follows is really probative. We've spoken to them only for the purposes of coordination of their testimony and their background.
Right.
And I've got definitions.
Right, because there was a phone call between Jackson and Wolf, because Jackson says in his email, pursuant to our conversation. So they had a conversation. But as he's saying right now, it was only with regard to scheduling. Hold on.
Of their testimony and their background. And I've got them only for the probative.
We've spoken to them.
We've spoken to them only for the purposes of coordination of their testimony and their background.
Okay. Then
And I've got definitions
we spoke to them
of coordination and background that I won't provide, but those in Merriam-Webster's dictionary have specific meanings. But I don't have to parse that at this point. So I want to continue. We have not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have. And I know the immediate response might be there. It might be at this point, wait a minute. You haven't had time to interview, et cetera, et cetera. But what has been the communication up to that point? It's been the first communication from Mr. Jackson, mentioned in the March 20 email, and then the pause email. That statement of Mr. Yannetti, as best as I can gather, is 100% accurate. It is not merely a response that stops with line 14 to 18. He goes on and explains exactly what the interaction had been up to that point.
And he didn't lie.
The statement of Mr. Yannetti is 100% accurate.
Mm-hmm.
Now we get to the court. See, I don't see that as being the report. I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify, and you have not complied with your Rule 14 obligations. We can't, Your Honor, and this was what I was pointing to before. So you can't, but you haven't. So I'm left with you haven't complied. So we need to get everybody here for a voir dire that can testify yes. Well, we need to do that in advance of their testimony. Okay, that's fine, Your Honor. So the defense is now fighting with bringing them in for a voir dire. That's Mr. Yannetti says that is fine. So I said I'm not going to conflate issues, but there's overlap of issues. So here you have a Rule 14 issue. Your Honor has concluded there's a violation. Your Honor has fashioned a remedy. The remedy is they're going to be subject to voir dire.
Mm-hmm.
The defense doesn't fight it. That is the Rule 14 remedy. But I'm going to get you how that interacts with the Model Code 3.3A1 in a moment. So we have then the voir dire. And what I'd like to, if I could, Your Honor, have you turn to tab 3, which is excerpts of the voir dire.
Page?
It's tab 3. And it's the June 18, 2024 voir dire examination of Dr. Wolf. And before I get to the specific parts of it, I know this is well known by Your Honor, but it's important to set the predicate for the elucidation of the points I am making. We all know voir dire is the opportunity for anybody to ask virtually any question they want of the witness to be voir dire. Your Honor set no limitations on the topics of voir dire at all. In recalling Your Honor's concerns, right? I don't know who even is opining on what. I went back and looked at that, Your Honor. Pretty fair comment, if I could, from the bench. It was hard to see. But please recall that wasn't the defense's making. We got what was sent in cement, the reports. That's the way they came. We didn't create a report that blended experts as to what they were going to say. That's what got dropped in our lap. So the voir dire was the opportunity for the Commonwealth to ask whatever questions they wanted to ask. There were no limitations. So up to this point, Your Honor, I'm going to use some words of others because I'm going to come back to them after we talk about the February 18th hearing. There was no compensation as of June 18th. There was no promise. There was no reward. There was no inducement unless one tries to define inducement as being the hope that you'll get to have these experts testify on behalf of the defense.
Right.
There was no...
Because at the time of the voir dire, they didn't know what the judge was going to rule. They weren't going to pay them. They didn't know if the judge was even going to let them testify.
Favoritism, because the Commonwealth had the opportunity to interact with the ARCCA experts. They had the opportunity to call them as witnesses. Right. And we sure know that the Commonwealth knows how to conduct a rigorous voir dire. Please simply recall Attorney Brennan's voir dire of Dr. Russell.
Yeah, but this was Lally.
That was the opportunity. They had a Dr. Russell opportunity with Dr. Wolf. What they chose to do with that opportunity, of course, is fully the discretion of the Commonwealth. The Commonwealth did not ask numerous questions that someone with the benefit of my hindsight in Monday morning quarterbacking would have asked them.
Because you're a pro.
But I would have asked them a lot of questions, especially given the unorthodox situation and given that the defense quickly jumped on the opportunity, right, to interact and call these witnesses. But they didn't take advantage of that opportunity in the voir dire. They didn't ask those questions.
It's getting fired up.
Had they asked those questions, they would have gotten answers. Now, Your Honor, I don't say that that in and of itself addresses the Rule 14 issues. I'm going to get to those. But I want to get to the prejudice and I want to get to some of the other important issues. I'm going to highlight, because I'm going to come back to it, Your Honor, page 1-67. We heard at the February 18 hearing, and again, I'm going to come back to it when we go line by line for those 9 pages, not line by line, but many lines. If I could draw your attention, please, to line 12. It starts with line 10 to put it in context. What about human factors? This is the voir dire, direct voir dire. So Mr. Jackson is asking Mr. Wolf the questions. What about human factors? What does that discipline entail? What is human factors? Answer. Well, to give you an example of that, so I do a lot of nighttime visibility work.
There it is.
And then it goes on where, for instance, let's say a pedestrian is coming down to the roadway at night. There's also going to be, that I'm going to get to in chronological order,
I think perhaps Hank Brennan should have read the voir dire or went back and watched it on YouTube before he made his arguments last week, that he thought it was the smoking gun, that it would have been nice to know, that he did nighttime visibility work and that he thought that most pedestrian accidents occur at night. Would have been nice to know. Well, if you were familiar with what happened last June of 2024, when they were, I think, voir dired for an entire day, you would have known that it was brought up and that it was talked about. So they did know it. Sorry, you're the new guy, but ignorance is no excuse. Sorry, not sorry.
Wolf on direct, talking about nighttime visibility work, etc. But if Your Honor could just please note the absolute raising of the issue of nighttime visibility and pedestrians affirmatively in voir dire.
They knew.
So that was voir dire, no restrictions, opportunity to ask whatever they wanted to ask. And as a highlight, the voir dire brings out nighttime visibility work. If Your Honor could please turn to tab 4. Tab 4 is the June 22nd, 2024 email, but it's important who it's from and who it's to and who's not on. From Daniel Wolf to Alan Jackson, subject Wolf qualifications. No David Yannetti on this email. And Your Honor, because I've said it so many times, Mr. Yannetti not being on the email, I can tell you from my own experience in this second trial, but this was, I understand, the first, there was a division of labor. There was a lot going on. This is now June. This is in the middle of trial. Everybody's got responsibility.
You see what he's doing? He's insulating David Yannetti so that even if she chooses to kick Alan Jackson off the case, she would have no reason to kick David Yannetti off the case because he was not privy to these conversations and they were in the middle of trial, and a trial is a living, breathing thing and everyone has their jobs and everyone is focused and it is a very stressful time and things may have fallen through the cracks and maybe Alan Jackson didn't tell David Yannetti, but David Yannetti didn't know. He's insulating him.
For their witnesses. So there's not collaboration going on. It's not the luxury I usually have at my law firm, where you're sitting in a nice big conference room and all the attorneys are sitting around the table all the time, let's say in March, etc. But clearly in June, the trial's going on. But they're dealing with their own witnesses at that particular time. So let's read it because it's short, but it's important. I'll repeat again. This was an email from Daniel Wolf to Alan Jackson. Alan, I spent this time this morning putting together a brief outline of my qualifications. I've also attached my D&T deposition in trial, in the trial parlance. I know it's nothing compared to Andy. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary. I will try to work on some direct examination questions tonight. So I want to start with, without getting tech geeky about it, some basics, because these basics were not brought up and I believe led to confusion on February 18th. If you look at the attachments, every email, as we know, has a lot of information on its face. And one of it is you can always tell what goes along with the email. So this is attachment Wolf Qual's document. But what's the most important points, I think, to be gleaned from this objectively, Your Honor? Mr. Wolf prepared the document, not Mr. Jackson.
No, I was well aware of that.
Okay, so he prepares it. He sends it along to Mr. Jackson. And it's on qualifications. The next is, if you would just please turn to the attachment, which are the qualifications, etc. There's a comment, and these pages aren't numbered, but the questions are. If you look at 19, nighttime visibility work. And there was a comment, and this was referenced on the 18, but I'm going to come back to this. If you don't want me to say that, that's fine.
What's he referring to?
That very testimony in that very point was elicited by Mr. Jackson on the direct that we're going to get to. There was no hiding of it.
I read that as well.
Good. Thank you, Your
Yeah,
Honor.
you're gonna shut him down. You don't want the world to know, so you're gonna stop him right there. Because the way that Brennan made it sound was that if you don't want me to say that, I won't say that. But he did actually say that. So Brennan, again, would have been nice to know. Again, Mr. Brennan, you should have went back and watched the testimony. Sorry if you didn't, but it's not our problem. Alessi wasn't there during the first trial, but you know what he did? His ducking homework. Don't duck with Alessi, says Nina.
The next tab, and of course, it has the D&T of Dr. Wolf's experience in testifying in court, et cetera, et cetera. I will indicate, Your Honor, that the information in terms of quals, et cetera, all of that, to me, would be basic questioning in a voir dire. But those questions, to the best of my knowledge, were not an issue of concern for the Commonwealth with regard to voir dire. I mean, inquiry, but again, that's what voir dire provides the opportunity for. So next we have tab 5. June 23rd is Sunday at 2:59 p.m. from Daniel Welp to Alan Jackson. Subject Wolf Direct, attachments, Wolf Direct. So it's clear, and then if you turn the page, that is the attachment, is something that has no labeling on it, but I don't think anybody is going to misunderstand that this is what's being referred to in the attachment Wolf Direct. So all the topics that are in this direct were all in the report of ARCCA.
When he says direct, he's talking about direct examinations. Wolf is giving him a list of questions for direct examination.
Frozen in concrete report of ARCCA. And we will get to this, but what I did was I went and compared this outline.
I did too.
Well, let him
Your Honor,
finish.
there's one thing I've learned in the short time I've had in this courtroom is that Your Honor is on everything. And the reason
Oh my gosh, he's buttering her up. He's buttering her up. Let me see some smooth as butter emojis because we may have to use smooth as butter for Alessi too because she's buttering him up. You're on top of it, Judge. If there's one thing I've learned since I've been in this court before you is that you are prepared and you do your homework. Let's listen to that again.
Your Honor, there's one thing I've learned in the short time I've had in this courtroom is that Your Honor is on everything. And the reason I am underscoring this is because it's going to come to an application of all the legal principles. So I very much and genuinely very much appreciate that Your Honor has, seems like with an exacting eye gone through and looked at all of this. So all of this is what's in the report that everybody already has. Why do I make that point? Because the rule 3.3A1, it has relevance, but it's got more relevance to the rule 14. And we heard on the 18 a very long buildup in an emphasis on the Commonwealth not having access to information, being surprised, et cetera, et cetera. So the point here is, additionally, if you compare the direct examination that actually occurred with this outline, there's not a very close resemblance. The topics are covered. I make that point because of two things. First, Mr. Jackson did not prepare this document. One of your questions at the February 18 hearing was, what's the day, et cetera, and I'm going to get to it, and I'm going to use words, not characterizations. That's why I don't want to go into it too much here. But there was a certain impression made about who had prepared this document. But I want to underscore it was Dr. Wolf who prepared it. and sent it to Mr. Jackson. Now I want to get to the timing because I think this is very important for the Rule 14 issue. This is Sunday, June 23rd at 2:59 p.m. The trial resumed the next day, which is going to segue me eventually to tab 6. And if Your Honor would look at the first page on tab 6, it's June 24, 2024. The very next day, probably less than 24 hours after this outline goes to Mr. Jackson, Dr. Wolf is on the stand. If anybody thinks that Mr. Jackson was waiting for an outline from Mr. or Dr. Wolf to be able to prepare one of the most important direct examinations of the trial until he got it, I think that person would have to have quite a fanciful imagination.
I think there's anybody here who thinks that.
Thank you.
So, well, Mr. Brennan apparently thinks that, doesn't he? Mr. Brennan thinks that, Dr. Wolf was giving him the goods. 3 o'clock on a Sunday, the day before he's about to testify. You think Alan Jackson's even looking at his emails? I doubt it. He's neck deep in this trial, and it's almost over, and these are the final witnesses.
The other important point to underscore is that this was something provided by Dr. Wolf, not drafted one word by Mr. Jackson. So if someone is to say that, and I'm not inferring, Your Honor, but someone else might want to infer to say that this is a blatant Rule 14 violation, this should have been turned over, et cetera, et cetera. What happened the next day, one day later, that would have required Mr. Jackson in the middle of trial with an unorthodox situation, trying to figure out what to ask Dr. Wolf, under what parameters, under what constraints, et cetera, that he should have also had the thought, oh boy, I got this in at 2:59 p.m. on a Sunday. I better hurry up and communicate with the Commonwealth and go provide that to him so I comply with Rule 14. I'd like to believe that I'm very diligent about my Rule 14 obligations, Your Honor. I'd like to believe I would have done it. I don't believe I would have even thought of it, came to my mind. We know what the standard is, but I want to underscore the connection in time between Mr. Jackson gets this and when Dr. Wolf is on the stand, because that's really the prejudice time period or potential, if you will, that occurred. Not even to bring in the voir dire that this could have been brought up, all these topics in the voir dire. Not that voir dire satisfies all Rule 14 obligations, but the reason I brought up Your Honor's Rule 14 remedy was it was the remedy, I think perfectly tailored to the situation, to basically say, I don't, as the court, understand, these folks haven't gotten what the court found was their proper discovery. We're saying we don't have, the information to turn over in terms of it. We got the report, and all we had is emails in March, right? That are, in my view, non-substantive. They're communications. They're Rule 14 material, no doubt, Your Honor. But the question is, what's the prejudice from not getting those emails in light of the voir dire that Your Honor ordered? We'll get to those under 3.3A1, but under Rule 14, they clearly are of no prejudice to the Commonwealth. So now we have the trial testimony of Dr. Wolf. I mentioned, Your Honor, about the nighttime visibility issue because much was made of that in the hearing 1 week ago.
Yeah, much ado about nothing.
If Your Honor could please turn to page 3665, starting at line 22 at the bottom.
Nice name change. Bobby Alessi's butter. Thanks for the 5.
Question. Mr. Jackson, this is direct. Mr. Jackson is eliciting this testimony.
Yep.
Remember the comment, I don't know if you want to bring this up. Mr. Jackson now is eliciting this topic. And how many of those 1,000, I know you don't have a number specifically, but how many of those 1,000 would you say involve pedestrians as well? Answer, several hundred. As I mentioned earlier, you know, a great deal of my work is in the field of lighting and visibility. So there is a direct correlation between time of day and pedestrian incidents. Here's the key sentence. We see a rise in the evening and night hours just due to drivers having a difficult ability to try to perceive and recognize individuals. So I certainly see a lot of pedestrian collisions in my casework.
Elicited not only during direct, but also during voir dire. There's no prejudice. Brennan made much ado about nothing. And yes, this is very Shakespearean, isn't it? Are we in the middle of a Shakespearean tragedy? You decide.
Discussed. Now to some very important communications on direct. If I could ask Your Honor to turn to 3669, please.
Snark tank on fire today.
Line 9. This is again by Mr. Jackson. At the time you did your expert review, Dr. Wolf, and your consultation, you and I had never met. Answer, that's correct. 100% true. You did not know who I was. I did not. 100% correct. You had never met Ms. Little? No, that's correct. Mr. Yannetti? No, fact. As a matter of fact, you had never heard of this case. That's correct.
Lady Macbeth, Nina for the win.
Page 3670. Line 10. Question, when did your analysis and conclusions, well, let me ask it this way. You finalized your report, you and your team, correct? Answer, correct. Question, and that report is contained in a multi-page document that was submitted following your analysis and your opinions and conclusions, right? Answer, correct. The defense didn't have anything to do with that. That's correct. True statement. You had never met us, didn't know who we were when we did this, correct. Now, if you could continue on, Your Honor, to, I believe, if I could be so officious and say, this may be some of the most key aspects of the testimony for Your Honor's inquiry. 6, question. All right, it goes without saying, I'm going to ask it anyway. You haven't been paid by the defense. Answer, you have not paid us anything. No. 100% correct.
Right.
And you don't work for us. That's correct. There was no engagement. There was no engagement letter signed. There was no retainer. Those discussions that were started on March 20th were paused with a March 22nd email, and they never were re-engaged. They were never re-engaged. They got to eventually get them on the stand, but there was no retainer. There was no terms of the engagement. To the best of my knowledge and my review of all these facts and discussions with counsel. So then the next, that's correct. Question. As a matter of fact, I've never asked you specific questions about your testing before today. That's correct. Mr. Wolf sent in questions that he proposed Mr. Jackson asked, but that's why I underscored so many times the fact it came from Dr. Wolf to Mr. Jackson. It's not Mr. Jackson asking questions in that document. It's Dr. Wolf sending them in. And Your Honor, I'm going to speculate if I could, and I'm not going to do this often in my presentation, but I do know a fact, and I do know, and a fact I know secondhand. If we put ourselves in Dr. Wolf's position, we think it's odd for attorneys. Imagine him. He's about to sit on the stand in one of the most visible cases in the country.
Yeah.
He is an experienced expert. He's used to interacting with attorneys. He is not having the level of interaction and preparation anywhere near what he's used to having. But he's got to go on the stand with his professional reputation, and he's nervous.
Yeah.
He's nervous.
And he hasn't been prepped. That's a great point. That is a great, I never even thought about that. And if you're interested to see what the online trolls have done to Dr. Wolf and his family since Hank Brennan's little speech a week ago last Tuesday, I've pinned the link into the chat, and it may horrify you.
So my speculation, he sends in the direct to try to get some degree of comfort.
So with all due respect, please don't speculate. Let's move on to the merits, okay?
I will
You
not.
can use this maybe at argument at some point, but let's just focus
At
on what
some
we
I will-
point?
I
Like
will do
what?
that, Your
When?
Honor.
At some point? Are we going to go to the
If you
grievance
know
committee?
for certain that's the case, that's fine.
I will
He
tell you.
doesn't know for
and
certain
first
because
of
they're
all, I
not allowed
appreciate-
to talk to them, Your Honor. Is this a trick question? Because they just found out that their contract was over like beginning of February. The feds told them their contract was over last whenever, June, end of June, July, something like that. The date's important. I have it in my notes. I'm going to look.
what you said, and I won't speculate anymore. I said I was going to make an exception for this, but here's the fact that I do.
No more, because you said you might do it more than once. So no more speculating. But if you know for a
But
fact
Hank
that
Brennan
that's
can get up and not only speculate, but outright lie to you and the worldwide audience. And that's totally cool. That is totally cool. If you don't spank Hanky when he gets up there for lying to you in open court, my head might pop off. You're going to spank him for speculating when he clearly says to you, I am about to speculate. Brennan's entire case is speculation and outright lies. But you want to school Alessi? Okay, touche. Let's go.
true, I'll hear it. So no more.
Make an exception for this, but here's the fact that I do.
No more, because you said you might do it more than once. So no more speculating. But if you know for a fact that that's true, I'll hear it.
Your Honor, first of all, completely understood, no more speculation. There will be no more speculation until we get to February 18th, what I think is really important.
Okay.
Because the Commonwealth on the 18th speculated a lot. And I
Okay.
think the only way to fairly.
So let's go back to this, okay?
speculate
You'll
they
get to
lied.
February 18th. Do you know for certain that that's what Dr. Wolf was thinking?
Here, I will tell you the basis of it, in fact. I've spoken with Mr. Jackson, and Mr. Jackson said that Dr. Wolf was anxious about the fact that he had to get on the stand without having the typical level of preparation and knowing. That is Mr. Jackson's sense of Dr. Wolf's situation at the time the direct was sent. So can I say for certain? No. Can even Mr. Jackson say for certain? No. That's the sense, though, that was
Because we haven't spoken to him
extant at that particular time.
in
Okay.
preparation for the
So
hearing.
we then go down to the next question. But I want to come back to that question on 12. As a matter of fact, I've never asked you specific questions you're testing before. That is correct. That's an accurate statement, Your Honor. That's an accurate statement. 15, your work product, the report that you provided was provided both to the defense as well as the Commonwealth. Is that right? That's my understanding. Yes. And you were equally available to both sides in terms of them reaching out. Correct. Yes. And I called you ultimately after receiving your report and asked if you join us and testify. Correct? That's correct. Why do I point that out? Because it's not only my sense when I said earlier that and I don't think this is disputed, the Commonwealth had equal opportunity to contact ARCCA. That was Dr. Wolf's sense as well. So that is the direct testimony of Dr. Wolf. And I want to just speak to the findings because on page 3676 to 3677, because the findings never changed one iota from the report ARCCA issued in February to Dr. Wolf's testimony. There's been a lot of talk about potential cause and effect of the interaction Mr. Jackson had with Dr. Wolf before he testified. And the key emphasis, and I think should be the key concern of everyone, certainly was the concern of the US Attorney's Office in the federal investigation. They didn't want those findings altered in any way. And the US Attorney's Office basically said, we don't want any more additional testing. We don't want anything. You're going to get these findings and you're going to deal with the findings that they have. So what were those findings? Bottom of 3676, line 25, did you perform an accident reconstruction? Specifically focused on determining whether or not damage to the Lexus was consistent with hitting Mr. O'Keefe. Answer, yes, I think that's a fair characterization. And reversing that, was your accident reconstruction also focused on whether or not the injuries to Mr. O'Keefe were the result of being hit by a vehicle? So it's important to know, in terms of, you know, whatever the interactions were and whatever the effect of the interactions were, is that the findings always stayed the same. And what was elucidated at trial, what was presented to your court, was not anything whatsoever different from what was established in cement in that report in February of 2024. So now we go to, and of course, you know, the findings of ARCCA being that the vehicle did not come into Ms. Reed's SUV did not come in contact with Mr. O'Keefe, and the injuries that Mr. O'Keefe incurred were not the result of an interaction with a motor vehicle.
Bam.
So now we go, Your Honor, to the tab 7, which is the invoice.
Okay, if your mind has been wandering, pay attention now. We are at tab 7. We are talking about the invoice for $23,950 that Mr. Brennan thought was his smoking gun, or one of them at the last hearing.
I am going to be very precise and point out some items, hopefully for an efficacious purpose. It says at the top, ARCCA invoice date, July 12, 2024. Of course, by then the trial is over.
Bam.
Your Honor, correctly.
The date of the invoice, July 12th, 2024. Did Mr. Brennan bring that up at the hearing? Did he say that that's when it was dated after the trial? And remember, these documents were given to Mr. Brennan. We call him that because he misspelled his name one day on one of his own ducking motions. It was turned over to him February 13th. There's the little "Hello, my name is Hank Brennan" sign in the right-hand corner, upper right-hand corner of your screen, because that's the way he starts his affidavits. "Hello, my name is Hank Brennan," like he's wearing a name tag at a sales conference. Take that back, because Mr. Brennan forgot to mention that at the hearing. And it sat out there for a week. And you know what he says is, a lie unchecked becomes the truth. Let's listen.
Hopefully for an efficacious purpose. It says at the top, ARCCA invoice date, July 12, 2024.
It's got the date right on it. July 12th, 2020. It's got the ducking date right on the ducking document. Are you ducking kidding me? We say that because rubber ducks are a big thing. And there was a 36-page police report by the Massachusetts State Police for a guy who was putting little rubber duckies around town with little stickers on the bottom that said, "Colin did it," and IYKYK. And he was prosecuted for witness intimidation in the Selective Persecution County of Norfolk. It was right there. I'm going to play that again for the people in the back. Oh, he said the emails were not dated, not the bill. But the way he made it seem was like this bill was a smoking gun that had never been turned over before the first trial. Okay, let's hear that. Let's listen to that again. If you're ahead in another stream, please do not spoil anything.
I'm going to be very precise and point out some items, hopefully for an efficacious purpose. It says at the top, ARCCA invoice date, July 12, 2024. Of course, by then the trial is over. Your Honor correctly noted in your preparatory statements about these line items that are in it. We don't run from one word or line in this invoice.
Yep. I hope it
But
goes
it's
line by line.
important to understand the facts behind this. The last discussion that any member of the defense team recalls having about any compensation at all was back in March, and it wasn't even any discussion about particulars, etc. It was just the defense feeling that they were going to be calling these witnesses. And there was the question of, is there going to be, and I had that as required in there for a reason, because they didn't know. It was just trying to understand this very unorthodox relationship because of the US Attorney's Office, their constraints. The defense position is that there was absolutely no meeting of the minds that ARCCA was going to be compensated by the defense. It wouldn't have been a surprise if that would have been demanded of the defense, but those were paused. Those discussions were paused. And again, that's the recollection of the defense. And to be clear, Your Honor, as Your Honor knows,
Michelle says Brennan says it wasn't dated. Now you're refreshing my recollection. Did the judge ask Brennan at the hearing, what's the date of the invoice? Did he say it's undated? He did say the email was undated. So I don't want to spread misinformation.
not a participant in the
So I'm not
first
sure.
trial. I'm
Right.
not speaking with firsthand knowledge on any of this. But I have conducted as thorough an investigation of these facts and marshaling of them as I think I can possibly do. So here's the punchline, Your Honor, with the invoice.
Punchline. We're here for the punchline. Tell
Came
us.
out of the blue.
Wait, sorry.
It came out of the blue.
Came out of the blue. They just sent them an invoice. Pay our bill. There was no discussion about an invoice. There was no discussion about payment. They just submitted an invoice. Is my memory exhausted? My memory is exhausted. It came out of the blue. They just sent an invoice. Maybe they'll pay it. They just sent an invoice.
It gets sent to Mr. Jackson's office in July. I can't reveal attorney-client communications, but I can tell you there's one person that was more shocked than most about the invoice coming in and the amount. So what happened? And this is, Your Honor, objective. These are recollections, information. The defense team called Mr. Adam Deitch at the US Attorney's Office. What is this?
He's naming names.
Can we pay it? We supposed to pay it? I encourage Your Honor to communicate with the US Attorney's Office about, did this conversation really occur? What was the substance of the conversation?
What is this?
Because as I understand it, one of the questions of Mr. Deitch was, can we pay this? Are we going to be in violation of some expectation of yours? We want to do this the right thing. Mr. Deitch said, yes, you can pay it. Why would the call go into Mr. Deitch if there was a prior agreement that they would be paid for anything?
Name drop.
There would be no reason for the call.
Right.
Did they pay it?
Yes, that was just the point I was going to get to.
And when was that?
The best of my understanding was very close in time to when it occurred. So I understand the date of this invoice, not understand, the date of the invoice is July 12th. And I think I can get you
I'm sure they know when they paid it. And you know what?
exact dates.
There is no
here.
promise, there is no promise, reward, or inducement because it was never discussed before their testimony. They were sent a bill out of the blue after the trial was over. There was a discussion with this Mr. Deitch at the US Attorney's Office. Should we pay this? What is this? Can we pay this? And they said, yes, you can pay it. And then they paid it. And Hank Brennan is the one who should be under some sort of ethical investigation here, my friends, in my opinion.
Mr. Jackson's firm, not Mr. Jackson, but a staff member, and I want to be careful of attorney-client communication, so I'm not going to talk about the subject, but communicated to Ms. Reed that this invoice had come in.
Yeah, we
And
need your money.
I believe that communication was toward the end of July, maybe I'm going to roughly estimate the 24th.
Karen, we need you to give us
And
$12,950.
then there was a communication,
whatever it is, $23,000.
of course, with Mr. Deitch.
I got to take that back because I was talking over him and I hate. That's why I usually pause it. Hey, Karen, we need you to pay us $23,950 for the ARCCA guys because, you know, they just sent us a bill. The U.S. attorney says we have to pay it, so we're going to pay it. We need the money.
Communication, of course, with Mr. Deitch. And after Mr. Deitch said, yes, it's permissible to pay that, I believe the payment was made very shortly thereafter, maybe within a week.
When was that? Within a week, within that July
After the trial
24th
was
date?
ducking
Get you an
over,
exact
what does it
answer.
I would
matter?
like that.
Sure.
The bill's not dated until after the trial, so they couldn't pay the invoice until they got the invoice. And then they had the conversation with he should have that at as part of his binder, like the proof of payment. It should be in there. Much ado about nothing, a comedy of errors. You're here for it. Lady Macbeth is on the bench.
I'm going to attempt to get an exact. If I can't, I think I can get a good approximation.
He didn't think it would matter because it was after the trial's over and they've already turned all this stuff over to the Commonwealth for this trial. And Karen's the one pulling it up on her computer.
Your Honor, I understand a check was sent to ARCCA on July 25th.
Thank you.
You're welcome.
And it was probably Karen's check. And she probably just looked up
So
her banking records.
there's no doubt the invoice was paid. But the story is not solely about was the invoice paid. The important part of the story, what the facts, is it came out of the blue.
Right.
And I don't expect anybody to take my characterization 100%, but that's my full understanding. But the call to repeat to Mr. Deitch is, to me, the corroboration of that very point. And it's an important one. It's an important question. And it's important, very important question. But it's an important fact point as well that call was made. So in terms of the next tab, which I've been alluding to during
Okay, so this is the one I said I needed to take a recess to read
I was just going
that.
to say the same thing.
All right,
This
so-
is now that point.
All right, why don't we take a 15-minute recess?
All right, hang on. I want to see who's in the courtroom. Oh, is that Jennifer McCabe? Wait, who's in the courtroom? Who do we see? I Spy. Let's play I Spy. We may be able to get to real time, but let's see who's there. I don't know, but I heard that's Carl Dougal, who I think was is Boston cop. He's a friend of, I think he was a friend of John's, right? Hang on.
You are muted.
Hard to make him out. Can't see. Well, so far, Alessi is on fire. It is going swimmingly. That invoice came out of the blue, and regardless, Your Honor.
Downstairs. I was waiting till the mask.
We didn't know if we could pay it, so we called the U.S. Attorney's Office because we were like, what is that? And we called this guy, Deitch, at the US Attorney's Office, and he said, yeah, you could pay it. Go ahead, pay it. And then they paid it. July 25th of 2024, long after the mistrial was declared on July 1st of 2024. Brennan lied in open court to a worldwide audience when he told us and them and everyone that that bill was not dated. If anybody can get me a timestamp on where he said that at the last hearing, I'd love to play that just to refresh my own recollection, because my memory is exhausted at this point. Go to the chat. Shout out to Allie. Thank you, Allie. $50 super chat coming in from the whole world. Calls me Hank. Thank you so much for your generosity, as always. Says, good morning, peeps. Let's see what duckery abounds from Norfolk today. Praying for Karen Reed. Thanks for all you do for us, Melanie. Thank you so much for your super generous super chat. South Carolina is watching. Thanks for the 10. Says, thanks for being here for us. Hope the Commonwealth is held accountable. We'll see. Is she going to spank Hanky? Is she going to give Hanky a spanky? We're going to see, because we now know he lied to a worldwide audience in open court and let that lie unchecked. Left it unchecked. Left that lie. Let it hang out there for a week. A lie unchecked becomes the truth. He said that. If you Google who the original person is that is attributed to that quote, you might find it curious that he would choose that quote exactly. Cheryl Pohl, thank you so much for your 50. Says, thanks for all you do, Melanie. Praying for good things for Karen today for my birthday. Happy birthday. Happy birthday, Cheryl Pohl. Everyone say happy birthday to Cheryl. And Karen's birthday is tomorrow. That is right. Happy birthday to Karen tomorrow. This would be a great birthday present if it goes her way today. Thank you so much, Cheryl. You're very generous. Madam Roz says, Helena Rafferty, the chief of police, has left the courthouse. She was just there to escort the O'Keefes into the courtroom and get some PR buzz. Helena has left the courthouse. Thank you. Thank you, Madam Roz, for your 5 and for letting us know. Lori Lake, thanks for tuning in from Canada, and says, you do have emotions. Somebody does have emotions, rage and frustration against the ducking people. Thank you. Thank you, Lori, for your Canadian super chat and for always being very generous to this channel. Julia and Lewis are here from South Africa. They've been watching for a very long time. Long time, first time. Thank you so much for your super chat. It's not your first super chat. I'm just kidding. But that's the thing people used to say when they call the radio. Long time listener, first time caller. Back in the day, we had to actually call the radio station to get them to play a song that we wanted them to play. Some of you might want to know what I'm talking about. Lots of love to Julie and Lewis from South Africa. This is a worldwide story. Ms. Mojo Horizon is here. She's married to Jim Morrison, and she says, Dirty Bench Judge, thank you so much for your 10. Appreciate you. Storm Dancer says, still don't get why she has no concerns whatsoever when the Commonwealth lies, shows BS, and wants to control and put their nose into everything Karen Reed's counsel is doing or has, so they can counter it with more BS. I think that's pretty much a rhetorical question, and I think you know the answer. Look the other way. Look the other way. It's not important. Nothing to see here. Selective persecution. And those of you who've been with me that for the year plus that I've been covering this case, started covering this case in January of 2024 with you. We've been through every document we could get our hands on, every police report, every investigative report, all the pretrial motions, pretrial hearings. You know the duckery that has gone on here in Norfolk County, Massachusetts. You know. Brooke says, I'm not saying it's true, but what if he lied? What can Bev do? What happens? If she finds that it's an ethical violation, she could revoke his pro hoc vice status to practice law in the state of Massachusetts. With him would go Elizabeth Little, because they're with the same firm. And technically, she would be able to also remove David Yannetti, but that is why Mr. Alessi made it very clear that David Yannetti didn't know that this stuff was going on. He was in his own bubble. He wasn't aware of any of this stuff. So even if you do find that Alan Jackson was unethical and you revoke his privilege to practice in Massachusetts and take him off this case, you can't remove David Yannetti because he wasn't aware of what was going on. He wasn't copied on any of the emails. However, in my opinion, I do not think she has grounds to revoke his pro hoc status. I don't think she has grounds for it based on everything that we've heard. Is she going to rule from the bench today? I don't know. Sounded like she said something earlier that made it sound like this might happen another day. Still, we may have to go on. Who knows? It is right now on the East Coast, 12:34 p.m. This is usually around the time she likes to take lunch. She may have other hearings at 2:00. Is she going to continue this for another day? Is she going to give Hanky Brennan a lunch break so that he has time to now prepare his BS? Or is he going to get up and walk it back and say, Your Honor, I'm really sorry? Is he going to fall on the sword? Is he going to eat crow and say, I'm really sorry I misled you last time, but it wasn't on purpose? We'll see. Michael Pepper, thank you. But Alessi's not finished. She just went back there to review something that he gave her so that she could be ready. Michael Pepper says, Michael and Yvette from Denton, Texas, want to say that we love the work that you do. I love you guys even more. All of my heart. Thank you so much for your 20. Lindsay Tyler, Melanie, why is she making so much bigger of a deal out of this than a video produced in the middle of trial that was inverted and video not even produced until after the trial? Well, because Hank Brennan made such a big deal about it. And he got up there and blatantly outright accused an attorney, Alan Jackson, who is not admitted to practice in Massachusetts, and he has the privilege of being admitted for the sole purpose of this case. Hank Brennan got up there and made it seem like this was a big ethical violation, Your Honor. What are you going to do about it? Wink, wink, nod, say no more, say no more. She didn't give Alan Jackson a chance to respond to it. They had a week to prepare, and I've never seen a more prepared attorney than Bobby Alessi with his binders, his tabs, and his copy for the judge. And why is she making a big deal out of this? More so than the inverted video trial? Because there seems to be no rules of evidence in Massachusetts. It's kind of like she's the gatekeeper. She can let in whatever she wants. No big whoop. Inverted video, no metadata. Psh, who needs that? We don't need that. We don't need an accurate record, because all we hear about here is a fair trial for the Commonwealth, as Hank Brennan likes to point out in all of his recent papers. The Commonwealth deserves a fair trial. Piney Woods Long Crime, thanks for your 20. Says, absolutely love Mr. Alessi's style. LFG, free Karen Reed. Thank you so much, Piney Woods. Lisa says, Karen just told Channel 7 that she does not believe that the federal investigation is closed. She said, quote, from the horse's mouth. That's interesting. That's interesting, Lisa. Thank you so much, because the news broke yesterday. At least Boston 25 broke the news from unnamed sources that the federal investigation was over, that there will be no charges brought as a result of the federal investigation. But they were saying the federal investigation into the Karen Reed trial, it's the federal investigation was investigating the investigation of the death of police officer John O'Keefe. They're misreporting on it by saying it was an investigation into the Karen Reed is guilty camp. And that's not what it is or was. Boston 25 yesterday reported that their sources told them that the federal investigation is over and no charges are going to be brought. But that's interesting that you said that, Karen said that on the air. I don't know who she told it to, but hopefully it was Ted Daniel so that he can correct his reporting. Jody Mitchell, thanks for the 10. The trolls on the anti-free Karen Reed side are going to need some dictionaries to understand the words that Alessi is saying. A Pink Swan gifted 5 memberships. Thank you so much for your very generous gifting, and for the 5 members that were randomly selected by YouTube. Welcome. Bernie Heaven says, congratulations on your viewing figures, Melanie. You were going through the documents for this case way before other streamers jumped on. Thank you. Always. Thank you, Bernie. Thank you, Bernie, so very much. I appreciate you. Jen C says, love for you and Karen from Jenna and Brian in Massachusetts. Is it Gloucester? You're gonna have to print. You're gonna have to get my pronunciation right on this. Is it Gloucester? Because I know it's Worcester. I know it's Quincy. I know someone will correct me. You're telling me to turn up my volume? I have it modulated with the court so that you don't have to. Can you hear me, guys? Gloucester. Gloucester. Well, you say Gloucester, Gloss. Gloucester. Yes, you could hear me, or yes, I need to turn it up. I'm not a cupcake. Can't make everybody happy. Thank you. Everyone else says it's perfect. So whoever that other person is, maybe, I don't know, take off your earbuds, put in your earbuds. I don't know. Witch in the Wardrobe. I started this. I put it up earlier, but I love your name. I love that you changed your name to the Witch in the Wardrobe, because we are in Narnia, and that's a Lion, Witch, and the Wardrobe reference. So you get it. Says from Canada, Brennan's binder that bangs on podiums has entered the closet with me. Its rings are unhinged. Well done, girl. Well done. You guys are on fire today. It's Gloucester, okay? So Jenna and Brian are from Gloucester. Thank you so very much for spelling that out phonetically for me. I'm a New Yorker. What do I know? Vanessa, thanks so much for the 10. It's amazing that the defense's every action and spoken word is under a microscope right now. But the Commonwealth can lie, provide incorrect evidence or no evidence, and continue without question. Oh, she's coming back. Thanks, Vanessa. Be a super chat.
Proceed, court is back in session.
May I proceed back to the podium, Your Honor?
Please.
Would you like to remain seated?
You can
Thank
go
you.
back.
Oh, but you never told Brennan to go to the podium. Huh.
May I continue, Your Honor?
Please.
Thank you.
Please.
So, Your Honor, to blend and quickly summarize what we've gone through I'm using the table of contents of the notebook. We've spoken about the March 20 and March 22nd email from Mr. Wolf to Mr. Jackson. We talked about June 10th and statements of counsel. We've talked about comments of Your Honor. June 18th, we've talked about briefly the voir dire of Dr. Wolf and the opportunities the parties had there. We talked about the June 22nd and June 23rd's emails from Dr. Wolf to Mr. Jackson and the proximity of those emails to the restart of the trial on the 24th. The 24th is the trial transcript of Dr. Wolf. July 12th, the date of the invoice. As Your Honor well knows, we got you when that invoice was paid. And now with all of that, what I am going to do, Your Honor, hopefully productively, with no speculation.
Okay, so you don't have to tell me what you're going to do. Just go ahead and do it.
So I will just go ahead and do it, Your Honor.
Shut the duck up. Why do you gotta be so rude to the guy?
Now to the transcript. And as I go through, I start on page 53.
Okay.
Line 19. And this is Attorney Brennan. Your Honor, my purpose is not to deprive the defense of an expert. I'm going to stop there. That statement is I will carry forward about the Commonwealth's statement that they're not seeking to deprive the defendant of ARCCA as a witness was made 5 times. I counted them and we'll go through each one and number them. Or deprive the defense of an ARCCA expert in this case. Very important, because my perspective, what was put in the firing line on February 18th was the ARCCA experts, albeit indirectly. So now we go to page 54, and this is going to be in some points a line by line because the words matter. Line 5, and this is again is Attorney Brennan.
Mm-hmm.
Well, what the government worries about is that there is other things that are relevant, like compensation, promise, reward, inducement, whether there's collaboration between one side or the other, and that expert witness that they don't know about and can't ask about.
Edward points out that, read between the lines, he's insinuating that Alan Jackson suborned perjury and or lied to the court.
Stop there. That they don't know about? Really? Don't know about the ARCCA experts? February 12th report? A voir dire? Knowing the purpose of the voir dire was we wanted to have these witnesses testify. And then the next statement, and can't ask about? Really? Can't ask about? Voir dire the opportunity.
Yep.
Next statement, that there's some bias or favoritism that the expert might have towards one side for whatever reason. I don't know what's meant by favoritism, but having worked with experts almost every week, you call an expert to testify. I don't know if I would call it bias, but I don't think it's a stretch to say that if an expert's going to come in and give opinions helpful to your client, that that expert is biased. But this expert was not engendered by the defense. It was engendered by the US Attorney's Office in their federal investigation.
And the Commonwealth could have called them, but they didn't. You know why? Because they're harmful to the Commonwealth's case. Duh.
Next, on line 12. So that if that information is not disclosed, really? It was on February 12th of 2025. Now I'm going to get to this because, and this is not speculation, this is fact, the entire buildup of February 18th was on the false foundation.
Yes.
That the Commonwealth had gotten all the information that they were going to talk about until Your Honor's break.
Right.
From the federal government and not the defense, which was completely false. So this is a buildup.
Yes.
It's all in.
And what was the date again that the defense?
It was an entire monologue that Hank Brennan practiced in his mirror, like he was going in on a Shakespearean play. And his whole buildup was all about this big lie and the fact that the defense was that it was turned over by the feds, not the defense. Listen, and now she's like, what was the date that the defense turned that stuff over? Listen, we're going to take it back a second. We've talked about this a lot, so I don't want to beat it to death, but there's a lot of new people here, I'm sure, because we got almost 15,000 people here. The entire buildup, that whole monologue was all about the smoking gun, which was, we got this from the feds. The defense didn't turn this over. Listen.
From the federal government and not the defense.
Right.
That was on the entire buildup of February 18th was on the false foundation that the Commonwealth had gotten all the information that they were going to talk about until Your Honor's break from the federal government and not the defense, which was completely false. So this is a buildup. It's all in.
And what was the date again that the defense provided it? The Friday night before our hearing, was it?
It was, I will tell you this, I'm going to have to think out loud.
Now it matters if it was a weekend. It was a Friday night. So, you know, maybe Mr. Brennan was at the beach house on the Cape and he didn't know. He was down the Cape. But are you going to take into consideration Daniel Wolf's email with his direct examination outline was sent on a Sunday, the day before he was going to testify, as if Alan Jackson was waiting for that? Really? On the Friday? Wow. Just wow.
I'm going to answer it. I think it was February 12th that it was provided of 2025, but it's important to state why that date. Please recall, Your Honor, that the Commonwealth had not yet issued its certificate of compliance with discovery. And I know I don't need to tell Your Honor the rest, you know it better than I do, about counsel's obligation to turn over discovery, et cetera, et cetera. So I don't.
Here's why that's important, okay? Because under the Massachusetts rules, the defense's turn to begin turning over automatic discovery under Rule 14, their time does not begin to run until the Commonwealth files what is called a certificate of compliance, which is an indication that they are done turning over all of their evidence. And then, and only then, does the defense's obligation time start to run. It is also important to note that even after they filed this certificate of compliance, they were still turning over more evidence as recently as yesterday, I think this past Friday. And maybe even more today. Who knows? So there you go. Hank lied, plain and simple. This was all a big smokescreen. No smoking gun, just a smokescreen.
Don't know if the Commonwealth on the 18th genuinely didn't know that it came from the defense as opposed to the Commonwealth. But what's very, very clear are the statements that I'm going to go through that were all built upon the foundation that they learned about this all from the federal government and that the defense had not turned over anything, which is completely false.
Okay.
So let's go through each word because
Completely
it's
false.
really important. When there are claims made that the defense has not turned over something and there are words used like ambush and duping, it's important to understand and get behind those verbs as to what the facts are. So the next. So if the information is not disclosed, then it's not only an impediment, it creates a position where there's an unfair examination. Really? Voir dire occurred? It's not the ARCCA witnesses that I have the issue with. That's number 2 of 5. The Commonwealth is not saying we have an issue with ARCCA. And why do I keep repeating this? Because my conclusion is going to be ARCCA should be unscathed. ARCCA should be available to the defense. And I'm going to get to more of that in a moment. So it says it's not the ARCCA witnesses that I have the issue with. It's the issue, the fact that I don't have adequate discovery. Those words, I don't have. The Commonwealth had for 5 days the very discovery that was being discussed that the Commonwealth didn't have. If the defense is going to be a proponent of those witnesses, they have obligations, Rule 14 obligations for basic discovery. I agree with that. I agree completely with that. And we complied on the 12th. And it's for this trial that matters, Your Honor. Your Honor has commented before that this is a new trial. This is a second trial. I've tried unsuccessfully sometimes to talk about the baseline with the Daubert issues, and Your Honor has rightly commented, well, Mr. Alessi, this is a new trial. Point taken.
Genius. Using her own words against her, as he has in every single motion that he has filed in his name. She has said it a million times. Well, this is a new trial, you know, new rules on the gatekeeper.
Now, I wasn't at the last trial, but I've read the transcripts. That's an important point, Your Honor. Mr. Brennan has said before that he, earlier in these pretrial proceedings, that he hadn't had a chance to watch, hadn't had a chance. And believe me, I can empathize with Attorney Brennan on that. It's a lot to digest. He and I are both coming into this second trial new. So I appreciated the comments he had made before, but his comment here is I've read the transcripts and I'm going to assume that for the very important topics he was talking about, he had read the transcripts. But again, that would be something that only Attorney Brennan would know. But it's an important point to point out. That was the representation. But I've read the transcripts. And then he goes on and on page 55, he repeats what we went through about June 10th and what counsel for the defense had said. So I'm not going to cover that. He's just reading what I took head on before the break. And so we then turn to the continuation of the buildup, which is at the bottom of page 55, Attorney Brennan. Now, I have some familiarity with the federal government. Seemed to me, based on my limited experience, there was much more to the story. And the story is about interactions with the defense counsel. That's what was talked about above. So I called the federal government. There's no statement here. There's much more to the story. And I've got the discovery that the defense provided that told the complete story. So there was, and I'll tell you my impression from what is stated here is that counsel made these representations, but the Commonwealth couldn't evaluate them because they didn't have information. So they went to the federal government. So I called the federal government and I tried to encourage them to provide full discovery so that the experts could testify. It's another statement so ARCCA could testify. I was resigned to a TUI letter. I've been down that road many times. It's a dark road that never sees the light of day.
dark.
So I filed a TUI letter, comprehensive TUI letter. And it was delayed. And over a long period of time with requests and deadlines, I finally received a response that was unresponsive. This is talking about discovery and information about ARCCA that was already in the possession of the Commonwealth. And it was striking that it was noted it was unresponsive just when I read the materials. I don't know which materials Attorney Brennan is talking about. I'm going to give Attorney Brennan on this one the benefit of the doubt that he's not talking about the discovery materials that we had provided, because I think fairly read in context, that's not what he was referring to, but I don't know what's being referred. It's not the point I want to make. And Attorney McLaughlin actually identified them. They didn't respond to our request, so Attorney McLaughlin wrote back, and then we got new materials, just some. Got them from the federal government. It's not a statement that he got them from the defense, which is a fact. And then we got new materials, but a qualifier, just some. But these materials were the very reason why the defense should not be able to call witnesses without giving full discovery. We had given full discovery. We had given it. Having not been at the last trial and reading the transcripts, I only have a flavor for the last trial. So there is email correspondence between the defense, not only the federal government, but some ARCCA, the witnesses themselves, and recent requests for. So he's saying, this is what I got from the feds. And what do I discover when I got this information from the feds, when he really got it from the defense? There's email correspondence between the defense, but not only the defense and the federal government, but the ARCCA witnesses. And then he goes on. But if we look back earlier in the relationship, what we see back in March 22nd, 2024 is that there are conversations between the defense, Attorney Jackson and Daniel Wolf, who's one of these ARCCA witnesses. And then he goes on and he reads the email. But the clear import of the point here is that the Commonwealth is saying right here that this is when I discovered these emails. This is how I got them, not from the defense, but the federal government. And we know now that that's incorrect. Then we proceed down to page 57. The Commonwealth, as I understand it, was not aware of any promise, rewards, or inducements or payment. They relied on a reciprocal discovery order of this court for that information. That's a misdirection. That's a misdirection. There was no promise, reward.
Misdirection is being kind.
Or inducements or payments before all of those documents that the Commonwealth is referring to here. That didn't come until the invoice came in July. And it wasn't even a promise. It was pursuant to the conversation of Assistant U.S. Attorney Deutsch that, yeah, you guys got to pay it, and it's okay to pay it. So next, on page 57, line 11, he reads, response, hi, Alan. Subsequent to our conversation on Wednesday, this is, I think he's reading from the March 22nd, but one of the disquieting aspects of this February 18th discussion is it's not chronological, doesn't have dates. So it's kind of hard to follow, but it certainly gave the impression, clearly, not the impression, it was stated that these came from the government, and I'm going to get to it when Your Honor was asking very apt questions about dates. But this is a very interesting paragraph. Hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked me, are there any further conversations? Did we receive additional information from their office regarding how our involvement will move forward? Your Honor, I'm going to please ask you to turn back to tab 1 of my notebook. Because this was a purported quote of the March 22nd email. it's really not close to what the email says.
Thanks, Mandy.
It's not totally incorrect, but here's what I'm going to do, Your Honor. I'm going to assume that the court reporter's transcription was not accurate and that Mr. Brennan accurately, because I'm going to give Attorney Brennan the benefit of the doubt, because I can tell you that I've had my statements in court not completely correctly transcribed by a court reporter. And unfortunately, sometimes it's been on some key things. I don't think this is key at all, but I just note it. But it says, Mr. Brennan goes on, now it's the opinion that troubles me. It's relationship, and the Commonwealth should have an even playing field. That's number 4 of the time he's not having any trouble with the ARCCA experts. Saturday, June 22nd, Daniel Wolf wrote, Alan, I spent some time this morning putting together a brief outline of my qualifications, blah, blah. And this is just a repeat of what we have already heard. Here now comes the important points. Page 58, line 2. Now, this isn't information provided by the defense in reciprocal discovery. Oh my. This isn't information. She's talking about all these emails. This isn't information provided by defense in reciprocal discovery. This is information provided by the federal government after numerous requests, TURI requests, and an insistence, the best I can to get as much information as I can. It's incorrect statement number 2, and it's an important one.
Right. It's a lie.
Down below, unfortunately, it gets even more incorrect. Defendant provided an outline of questions and answers for the direct examination. Please put this in context, Your Honor. The Commonwealth appears to be believing that they got the information from the federal government, not the defendant. So they've got the outline, and they're now accusing the defense of having essentially drafted the outline.
Lie number 2.
Defendant provided an outline of the question and answers for direct examination.
Lie number 2.
My, that's not a fact, but if that were true, that would be very bad.
So what I'm going to do, I had no idea it's this late. So it's 1 o'clock. We're going to break for lunch. We'll start back up at 2.
Are you kidding me?
Right.
Are you
Do
ducking
you
kidding me?
think, I have no idea how much longer you're going to be, Mr. Alessi. Do you have an idea? And I'm not rushing you. Do you have an idea? Because we do have the other motions. If we can't get to them today, we'll spend those 2 days next week with them.
I'm going to answer your question. I think I can conclude in 45 minutes because I have to get to the law, the 3.3A. I have to.
I'm not rushing you. I just wanted a
That's
time
my
frame.
best answer, and I will say this, Your Honor. I share your interest. I'm presenting some of these motions, and I have a strong desire not to be back here for that. So I share the goal, believe me.
Okay, so we'll see everybody at 2 o'clock.
He doesn't want to come back.
You are muted.
He was only up to line number 2. Wow, just wow. I didn't realize what time it is, but we're going to have to come back at how much longer are you going to be? How many more lies do you think he's going to point out? Wow, just wow. Just as the truth bombs are dropping about all the lies that Mr. Brennan told. Last Tuesday, in open court to a worldwide audience that stood unchecked for an entire week. Wow, just wow. Let's get back to the chat because the court's on break. They're going to be on break for close to an hour. Maybe time for you guys to get a drink, get something to eat, get a little snack. Yeah, it's only been 2 hours. They started at 11. I don't even remember if they started on time. How much longer are you going to be? Not really rushing you or anything. Don't worry. No big whoop. And he said, I have other motions to argue in front of you today. And quite frankly, I don't want to come back here. So I'd like to get them done today too, Judge. And there's that. Piney Woods, thanks for the 10, says Mr. Alessi is giving what every trial lawyer hopes their argument comes across. Y'all are watching a masterclass in lawyering. Bravo, sir. I agree, Piney Woods. I agree. Lady Zelda Kelly is here. If he were my pastor, I would be baptized tomorrow. Love watching him. He's captivating. Thank you so much for your super chat. Good time for everyone to remember to smash the like button because we've had about 15,000 plus people in here for the entire morning, and that would be a nice thing to do. Greg says, Brennan is this close to crawling under his desk. Thank you for your super chat. I've turned over a lot less. We were duped. Love your username. Says, you don't need to answer until after the hearing. When Alessi is done, do you think the Commonwealth will get sanctioned or will she look the other way? Well, I don't know that she's going to rule on anything today, but I imagine that if she wants to kick Alan off the case, she'd probably want to do it like immediately. So maybe she would. Do I think she has grounds to based on this? No. Brennan lied to a worldwide audience, outright lied. And Alessi was far nicer than I would be because he gave him the benefit of the doubt. He said, Your Honor, maybe this wasn't transcribed properly, or maybe he just made a mistake. But the buildup, we talked about the buildup a lot. And his whole buildup was all about getting to the smoking gun that the feds turned all this over. The defense didn't even give this to us. Cat's me out. Thanks for your super chat. Ches says Alessi is fantastically keeping Bev in her lane. Yep. No shrinking violet. I kept this for the name change. Great name change. Thank you for your super chat. Michelle, thanks for the 5. Are all the corrupt people in the courtroom? You know who I mean. I don't know. I couldn't see any of the people that you may be talking about, in your opinion, in the courthouse or courtroom, but you can let me know. Abacus Finch, thank you for the 10, says, Auntie Bev asked Brennan point blank, what date was the invoice? And he said it was undated. There you go. Even though the date clearly in the upper left-hand corner was July 12th, 2024. It was sent to the defense out of the blue. They didn't know it was coming. That was after the trial was over. And they called the US Attorney's Office, spoke to Mr. Deach, and said, what is this? Are we allowed to pay this? And they said, yes. And Mr. Alessi said, Your Honor, I would suggest that you please call Mr. Deach at the US Attorney's Office. Confirm this conversation. And I wonder if during the timeout she took earlier, if she went and made that phone call, or if she's going to make that phone call now. And wouldn't you hope that she would find it important enough to do it? And don't you think, knowing that Alessi brings receipts and does his homework, that he probably called Mr. Deach and gave him a heads up and said, listen, we have a hearing on this today. It's really important because we're worried that this judge thinks that we misrepresented stuff and that one of the attorneys might have their pro hoc status pulled. And so if there's any way that you could be around a phone today, it would be really great in case the judge wants to call you. Pretty sure he probably did that. Al Dente, thanks for the 5, says ARCCA hired by the feds. Hope the FBI investigate the threats, intimidation. Some are very threatening and require consequences. You mean the threats that were made to the family of ARCCA, of Dr. Wolf? Yeah. BC says, I love how Alessi delivered the lore with his gentle voice. He did. The lore. He was the lore. Well done. Thanks for the super chat. Attorney Wannabe. If, God forbid, the judge removes AJ from Karen Reed's team as punishment, can he still work with her behind the scenes? Probably not. Probably not. If it's for an alleged ethical violation, I would say no. BC, did the invoice payment and the contract ending correlate? That's a great question. And I think he said in his motion, the contract did end like around the end of July. And so we're going to have to go back and look at that. Please turn up your volume. Okay, can you guys still not hear me? All right, I'm turning up my volume now. So if you would turn your volume up, I don't want to blow out people's ears, but you know, complainer's going to complain. Great question, BC. We're going to have to look it up. Aussie Steve, thanks for the super chat. Hanky is well and truly ducked. This is historic. Free Karen finally. Thank you, Aussie Steve, for tuning in from Australia. The world is watching. Sarah Boone's left kidney is here from Australia as well and says the DOJ should reimburse them. They had approved purchase orders. They'd approved a purchase order to ARCCA for $26,000 for expert witness services, June 12th, 24 to 6/11/25. Found on, yeah, somebody had a copy of an invoice. I don't know. That could have been a balance due to them from what they had already done. I can't really opine on that. I know people were sending me copies of this invoice that the DOJ paid. I don't know what it's for, so I can't really hypothesize about that. OnlyFans says the Boston 25 dropped another 36-minute Karen interview. Maybe we can watch that over the break. The whole world calls me Hank. Thanks for coming in with a 20. Says, I got it figured out. The distraction to Hank lying in court is the fake disclosure yesterday that the feds have closed the investigation. Hank is supposed to announce it in court today. Yeah, he's supposed to. We'll see if he does. Happy 38 years to you on Thursday. Arctic Fox, happy birthday. Thank you for your super chat. Barbara, thanks for the 20. Says, just getting here. Had a doctor's appointment. I watch earlier later. Thank you for covering this. Can't believe the media is covering. This is something. Channel 5 Boston. Thanks for your covering and explaining. Appreciate you, Barbara. Thank you so much for your super chat. Law and Crime Stream 2/18/24. Okay, we will look at that and see. I forget what I asked the timestamp for. Whether or not he said right, the invoice was dated. We'll take a look at that. Jazzy, can Bev remove Brennan as special prosecutor? That is a great question that I'm not sure of the answer to. Does a motion need to be made to remove a special prosecutor? Or is she allowed to do that sua sponte? That's a great question. Don't know the answer. Nightclubs. Did Yannetti argue Bettero? Just jumped on? Nope, not yet. Don't know if that's going to happen today because Mr. Alessi still has at least 45 minutes on his argument. Then we got to hear from Brennan, and then Alessi is here, so I think they're going to argue the Daubert motion on one of the experts that was filed last week. Not the guy not the weatherman. It escapes me right now, but there was another Daubert expert motion that Alessi was supposed to argue last Tuesday. Java Time, thanks for the 5. Today's your son's 27th birthday. Happy birthday to your son. Time is a thief to us parents. I'm wrapping his gift and live, and this live is my gift today. Oh, thank you so much. So glad I could gift you Java Time, and happy birthday to your son. Spoonful of snark. Here's a difficult truth. Evil never believes it's evil. As humans, we can convince ourselves our actions are right and justified. Well done. And isn't that so true? Evil never believes that it's evil. Yeah, I'm going to have to pontificate on that a bit. Melissa Besford, thank you for tuning in from Australia. Says, loving watching Alessi right now. Thanks for your knowledge, opinion, and expertise as always. Oh, I love hanging out with you guys. Hank's Trappakeepa. Thanks for your super sticker. Desert Quill. Today, can or should the defense ask for sanctions for the lies that Brennan told last week that brought this continued financial abuse of Karen Reed? That would probably have to be made in a separate motion. Good question, though. Thank you. Lori Lake from Canada. Generalizing here, do other Massachusetts judges behave similarly to Beb? I am a New York attorney, so I cannot opine about other Massachusetts judges, but the Massachusetts attorneys that have spoken out seem to say that this is nothing out of the ordinary. That's what I've heard. But maybe Massachusetts attorneys are too afraid to speak up because they may have to appear in front of her. Commander Ed wanted to know, what are the chances Bev called the U.S. Attorney's Office during the break? Great point. Thank you, Pug and Spice, for your super sticker. Thank you so very much. I appreciate you. Morning, afternoon headshot. Thanks for your 10. Says, with the understanding that the feds are investigating public corruption, not Karen Reed and murder. They likely concluded that Karen Reed is factually innocent. This is evidence, but not the bulk of the case. Thank you very much for your super chat. Edward says, do we get breathless, grave concern statements about the Commonwealth? We get a recess, suspended hearing. Well, yeah. Yeah, she took lunch. This is at 12:50 before she decided to break for lunch when you sent that. And then he says the multiple flip back and forth of that binder was a cold, cold move, Mr. Alessi. Haha. Thanks, Edward Kirkpatrick, for all your super chats today. Alessi's righteous indignation. Love your name. Says Bev got the shakes, needs lunch. Thank you for your super chat. Massachusetts lunch law says PTSD healer. Thank you, Piney Woods Law and Crime, for the 10. I require that Bev apologizes to the defense and specifically to Mr. Jackson. She acted terribly to the defense and slandered them in open court. She must make a statement. We'll see. I agree, but we'll see. We know how it goes here in the courtroom of Beverly Cannone. Desert Quill says, educated guess on how Brennan feels right now. I opined last week or Saturday. When was it that I had to come on and do the talk down stream, and then my stream cut out because I was on vacation and, internet and StreamYard issues. I think it was Saturday. And I said, I think that he may have egg on his face on Tuesday because, Alan Jackson brings receipts. And at that time, we didn't know that it was going to be argued by Alessi, but Alessi brings receipts too. Who is there? Who can see Hank's face? Thanks, and more of Alessi. I don't know. Track worker says, bias Bev, hoping everybody's sleepy and won't notice the lies. Thanks for your super chat. Smudge the Cat is a new member. Thank you. Kyle, thanks for the 5. I love his, I'm giving Mr. Brennan the benefit of the doubt. Maybe he was mistranscribed. Yeah. Subtle as it is so egregious, it couldn't be on purpose. Right. Exactly. We know how to read between the lines here. Mudrocker, thanks for the 10. Would kicking Alan Jackson off raise a possible appellate issue of denying Reed counsel of choice without a valid justification? It may. It depends on what her reasoning is. It's a great point. That's a great point. Thanks, Mudrucker, for your super chat. Fairy Raven Emma is here from Ireland. Cameraman, zoom in on Brennan, please. I know. Why is it that they have no hesitancy to zoom in on Karen all the time? But why can't we see Brennan's face? I would have loved to see that too, Emma. I'm with you there. Hard plastic and static mannequin. Wish I could send Alessi this super chat. He deserves donations for his pro bono. Yeah. Thank you so much. He believes in this case so much that he's working for free. Thank you for your super chat. Pam says, will Alessi mention the trolls attacking the wolf? I don't know. We'll see. He's got 45 minutes left, I think, in his argument. So good point. Sandy B says, so sick of Bev's attitude to quit. Embarrassing and calling my special prosecutor a liar. Such blatant bias. If you had any doubt, a lot of us are trying to give her the benefit of the doubt as a judge. And I think that train may be coming soon to a screeching halt, right? Norma F., thank you so much for your 5. 46 years ago in labor at this time, this is just as painful. Well, happy birthday to one of your children. Happy birthday. And when we were talking about Shakespeare, Alan Jackson's jar of nickels came in. And that is a great username too, because Alan Jackson said the other day something like, if I had a nickel for every time, and look at you, changing your name, dost thou shalt not leave in such hasty abandon. And says, is attributing that to Alessi and puts a fire emoji after it. I want to take a look at the hearing because I want to go back and we want to see what exactly Alessi said. Somebody was kind enough to send me the timestamp. So let's go back to that hearing and see if he actually did say that that invoice was undated, because lying in open court as an officer of the court is a problem. As you can see, because of the way that this judge had such grave concerns about the allegations that Mr. Hank Brennan was making, not so surreptitiously, about Alan Jackson. You know it. You were there. We've been watching it together. All right, let's see. Okay, so thank you very much for sending that to me. We have Law and Crime. 1 hour and 13. Thank you so much, Rainy Day, for sending this to me. 1:13:30. Right. Let's share it. Let's take a listen. We like receipts here too, you know? Thank you, Rainy Day, for sharing this.
Information from the material I reviewed, so it wasn't necessary. Need to show the jury it doesn't matter in this case.
What's the date of that?
It's not dated. It's
Well,
not dated.
that's the email he's talking about now, though.
The TUI request is a recent February response, but they send random documents. There's no real accounting. Now,
Right. He says the feds
I'm not saying that
send random
undermines-
documents for the TUI request. There's not an accounting. So he's still going on to say that the feds turned this over to me. Because the feds are the ones who respond to a TUI request.
The conclusions of ARCCA or not. I'm not saying they're not qualified witnesses, but it certainly shows some bias. I've turned over a lot less in this case than this.
Pat yourself on the back.
Another comment. Would it be fair to say because you had a lot of nighttime visibility work, your cases frequently involve pedestrians? Yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. Statistically speaking, most pedestrian fatalities occur during the evening and night hours. That would have been nice to have.
You did have it.
Specialty in the area of lighting and human factors
You did have it during voir dire. Maybe you should have watched it.
has resulted in a lot of my cases involving pedestrians. Pretty important stuff in this case. And then he comments, if you don't want me to say this, that's fine. That's fine. Shh. Don't tell them. Have you qualified as an expert in court before? Yes. I realize my testimony, I said it 20 times when you asked how many I've been qualified. I misinterpreted the question. My fault. 11 trials, 7 depositions. Not sure if you want me to clear that up.
I want the
I don't know if it was ever cleared up. And then a bill from ARCCA to the defense for $23,925. That's not trample. That's not trial by ambush.
What is tramble? What is tramble? That's not tramble. Okay, he says an invoice. Does she ask him the date? Let's listen.
That's getting duped.
That's getting duped.
So I didn't know any of this, but I've tried a few cases. I've been around the federal court a little bit. I know how it works. Sometimes parties pick sides. It creates an imbalance and unfairness, and then it allows the ability to one side to use ghosts.
Ghosts.
Create illusions and shields and say something's there and something's happening, a federal investigation and this person, and then this happens. I don't care if the ARCCA witnesses testify at trial.
You don't care.
I don't care about their opinions.
Of course you do.
But I care that it's unfair, imbalanced, and hidden. And the Commonwealth, like the defense, is entitled to discovery. So if they can produce the discovery, I'd welcome ARCCA.
All right, I'm going to take a recess before the.
All right, she takes a recess. She doesn't even ask for the date of the invoice. She doesn't even ask. She doesn't even ask. So there's that. Tramble may refer to a verb meaning to wash. Microdot shared what Karen said about the feds closing the investigation on X. All right, let's take a look. We also have a new video that we can watch from Boston 25, the part 3 of the Ted Daniel interview. Hang on. All right, it's the video of Karen going into the courthouse. Okay, hang on. If this is cut out later, it's because whoever's video this is not allowing me to play it. Microdot's posted someone else's video, so I would prefer not to have to cut this out, but if I do, I do. And then the chat goes away. So here's what happened outside of court.
I feel great. Are you encouraged or discouraged by the decision by the feds that they're not continuing to investigate?
I don't know that I believe that.
You don't believe it?
No, I do not. I have good reason not to.
You not believe that?
Yeah. Good luck, Karen. From the horse's mouth.
Oh, wow. She's smiling.
Karen, how you feeling?
And she has good
I feel
reason to
great.
believe that the federal investigation is not over, and she heard it from the horse's mouth. Well, there you go. There you go. That's interesting. What say you? From the horse's mouth. And then Microdots said, yeah, no one is. This is Steve Cooper. I guess he's a reporter for, I'm not sure who, on Channel 7 News. And he titles it Breaking Karen Reed heading into court moments ago told me she isn't so convinced. Reports the feds have closed their investigation and no law enforcement members are facing any charges in connection with the handling of the case. Hashtag 7 News. Now that is a mic drop. Yeah, it is. She looked really happy, right? Okay, you want to watch that 36-minute interview? Let me know if you guys want to watch it. I have it pulled up. Thank you, Chastity, for gifting a membership. So sweet of you. Salty became a new member. Welcome. Why did AJ say they didn't pay ARCCA? That was before they paid ARCCA. They just got a bill in the mail after the trial was over. All of the conversations in front of the judge were held before they testified. That's when all of these conversations that Hank Brennan was accusing him of happened in court. On the stand, Daniel Wolf said, no, you haven't paid me anything. They drop mailed them an invoice on July 12th after the trial was over. Check was sent to them July 25th of 2024, and they called the U.S. Attorney's Office and said, are we supposed to pay this? What is this? Why are they sending us a bill? The U.S. Attorney's Office says, pay it. And Alessi said to the judge, here's the guy's name. Call him. Please confirm. Hank has kangaroo loose in top field in his head. Thank you, Margaret, for hanging around for 8 months, for your comments. Somebody jumps in and says, what did I miss? I don't know, the entire morning. Some really fire argument by Mr. Alessi. Will prosecutors require Karen Reed to turn over her information from the horse's mouth? Ooh, that remains to be seen. Thank you, Casey, for your Cash App. Says, enjoy a matcha latte on me. Thank you so very much. Lori sends a Venmo and says, thought you might need a drink after this one. Thanks. Love your coverage. Thank you, Lori. I appreciate you so much. Gail, thank you for the Venmo, for thanking me. Thank you so much. Yes, Sandra, thank you for the Venmo. I have mentioned that Aussie Insider has done some videos lately that she's done a lot of research on regarding judicial immunity and regarding the habeas petition. So if you haven't watched that stuff, you may want to watch that stuff later. Thank you so much for your Venmo. Jay has bought a matcha latte. Thank you so much for thanking me. We are on break right now until 2 p.m. So in the meantime, thank you, Mark, for your Venmo. Says you're the best. Appreciate you. Shauna says you're my go-to for all of these hearings. Thanks for all you do to make this understandable for us. Thank you so much, Shauna, for your very generous Venmo. I appreciate you. Kimberly, thank you for your Venmo. Gail, thank you. Says, love your show and content. Today is going to be a wild ride. That was earlier. Thank you so much. And Michelle, thanks for buying me a matcha latte. She says, I love your show. I tell everyone about you. And if they want real info to watch and subscribe to you, I also would like to add, for the first time, I have a pit in my stomach for Karen. This kangaroo court is so aggravating that my head pops off. All these motions that have been denied by the judge, and you know she's speaking with Marcy, in my opinion. There you go. Did you hear they are moving the pro-Karen Reed people away from the courthouse? No, I did not hear that. Did they put up the buffer zone again today? I didn't hear that yet. Thank you, Justin, also for your Venmo. It says that he says the Serenity Prayer every morning. for Karen Reed, and that's very, very, very sweet of you. All right. Let us now take a look at why am I so dark? I don't know. I got to figure out the white balance on this camera. It's a new camera, and I don't know. For some reason, the controls aren't coming up. Somebody actually sent me an email. Thank you so much to the photographer who sent me an email and said, listen, on your new camera, you got to fix the white balance. I'm like, I have no idea how to do that. No idea how to do that. All right, let's take a look at this. We have time. We can probably just finish this before they come, right before they come back from break. So let's do it. This is the exclusive new video from Ted Daniel, his part 2, his Karen Reed interview. Hold on, because I got to figure out where their volume button is. Okay, hang on.
How many nights do you think that you stayed at?
It says this is new, so here it is. It's new, allegedly.
How many nights do you think that you stayed at a hotel since this legal saga began?
Since the legal saga began, well, trial was every bit of 10 weeks, and then a week or so leading up to it. So that's 100 days, 90 plus days. And then every hearing, at least one day. And that's just not having a license and being out in the suburbs. Now I don't have my house anymore. So I'm always in transition of where I'm staying. So, and when Alan and Liza come in, and now Bob, and if it's one of our experts, time is of the essence. And I like to be involved in everything. So I certainly don't want my legal team convening and I'm not there. You miss one day of this case on this legal team and you're behind. We just got a discovery dump today. This tends to happen right before a hearing. We get discovery. I wonder if part of that is preempting us saying in court in an open forum that we're still waiting on this, this, and this. So then we get it. And then but we haven't had time to really distill it before we're back in court, but we just got a dump today. And it's nice because the lawyers are coming in and we're kind of all combing through it. We'll sit down tonight and go through it. We'll have time again tomorrow to go through it.
One of her bail conditions is that she's not allowed to drive. KCL, good question. No license? Does she not have a driver's license? Nope. No, she doesn't.
So staying with them helps foster this logistically.
During this time, when there is no trial, we see you in court once every, 3 months? But what's going on when we're not seeing you? This is it, right?
This is it. I work on the case every day.
Wait, was it February of 2023 when they took her license, or February of 2022 when she first was arrested? I don't want to spread misinformation, but I think it was a condition. It was like part of her bail conditions. She had to pay like $80,000 bail or $100,000 bail.
When I wake up, I'll take a few breaks. I'll have dinner with friends or with my family or both. But the hearing is, those are easy days. I mean, they're easy for me. I don't have to do anything, but it's all the days in between. We've gotten, now this is the second trial. So for any given witness, there's the initial police reports, or in some cases, no police reports. We've got the state grand jury, then we've had a federal grand jury, and now a trial, and then any interim police reports that involve some of these witnesses. So it's layers of statements, and the inconsistencies are just seemingly endless. So there's always work to do, and it's like finding a needle in a haystack, that the report may look at a first glance to read the same, but then you read it 2 or 3 times and it starts to sink in. You know, we were just looking at a police report, my father and I, a couple mornings ago, an early police report from January 29th by Michael Lank with the Canton PD. And I've read this so many times that I don't know if I've become desensitized to it, but he says to Matt McCabe when he goes into 34 Fairview, if John got in a fight the night before. And I always read that as if...
And that's documented?
That's documented in the Canton police report from that day, 3 years ago.
Hold on.
Nearly to the hour.
I want to hear that again. Hold on. Matt McCabe said what now?
There's the initial police reports, or in some cases, no police reports. We've got the state grand jury. Then we've had a federal grand jury, and now a trial, and then any interim police reports that involve some of these witnesses. So it's layers of statements, and the inconsistencies are just seemingly endless. So there's always work to do, and it's like finding a needle in a haystack, that the report may look at a first glance to read the same, but then you read it 2 or 3 times and it starts to sink in. You know, we were just looking at a police report, my father and I, a couple mornings ago, early police report from January 29th by Michael Lank with the Canton PD. And I've read this so many times that I don't know if I've become desensitized to it, but he says to Matt McCabe when he goes into 34 Fairview, if John got in a fight the night before.
Oh,
And
Lank asked Matt McCabe if he got into a fight the night before. Why? Because he looked like he went 10 rounds with Mike Tyson.
I always read that as
And that's
if
documented?
that's documented in the Canton police report from that day, 3 years ago, nearly to the hour to right now. But now that I read it, I'm like, of course he's being asked if he knew of John getting into a fisticuffs, because John looks like he was.
Right.
And those are things that I read in the moment when I was arrested and then arraigned on February 2nd. And I don't quite know the contours of what I'm dealing with. I first think that
John.
this is just mistaken. I was hysterical. I was drinking. And
Lank asked Matt if John had been in a fight the night before. And it's in his report. Now she's going to explain why she said what she said. Hold on.
in the moment when I was arrested and then arraigned on February 2nd, and I don't quite know the contours of what I'm dealing with. I first think that this is just mistaken. I was hysterical. I was drinking, and they've just got the wrong person. And then piece by piece, it came together. Like they got the right person. I'm the wrong person, but for them, I was the right person. Now, 3 years later, looking at a police report that I got on February, actually, David came and brought it to the holding cell at the Stoughton District Courthouse on February 2nd, right before I was arraigned. You see something every time that you just can't see without repetition. Your eyes like preempt what you're gonna, what the next word is, what the next sentence, and it doesn't have the same meaning to you today on January 29th, 2025 that it did in 2022.
So are you going through all the police reports that you've looked at prior and all the statements? You're going through everything again?
You got to go through everything again, because every time you get something new, it's not what is this on its face in my case, it's what's changed. What are they saying now versus what did they say 6 months ago, 12, 18 months ago? So you're always doing, I mean, I've got some things in a spreadsheet, that's how my mind has always worked, but some things you just have to read. You've got to go through the court minutes, go through the transcripts. But a police report today, you know, we'll read something. Liza and I were on the phone on the way up here, and it's, wait a minute, what did this witness say, or what did this responding officer say back on February 10th, 2022? Well, now he's saying this. So you've got to always compare and see what's changed.
Do you feel like you've gotten more astute doing this now for 3 years?
I feel I understand now how it's gonna, I understand better how it's gonna play in court. I think of things I was texting David constantly in the early days of this. I'd find something and I think, well, can't we go talk to this person? And they'll say it didn't happen that way. And now I know better how tough it is to get, especially in my case, how tough it is to get something admitted. Even going into trial with my seasoned attorneys, there were things we thought we could show, like an exhibit, for example, like one witness, Christina Hanley, the key part of her forensic report at the MSP lab, and she's just a scientist, a civilian, but the glass on the bumper that was photographed on the bumper does not match the cocktail glass, does not match the cocktail glass. So that means it's from another piece of glass. So that had to have been two breaking events. There's the glass that was found around John's body, the base, I think it was Lank that pulled it out, with his gloves on, or maybe it was Buchnick, the base of the cocktail glass. That is scientifically proven by the state police, Christina Hanley, not to be the glass that was on the bumper.
On the bumper. But I think the jury was left in the first trial with the impression that it was the glass.
Yes, because it's so confusing. Nothing's referred to as the cocktail glass or the bumper glass or the lawn glass. It's 7-1 item 5
right.
or item A, or 7-12 items A, B, C, D, and E. And then there's more glass found by Proctor, and that's 7-13 item A. And when you have the scientist who, my guess is worried that we're trying to impeach her when we're in fact not, we just want her to present the report. And this is, you know, I don't know when she testified, but it's mid-trial, it's 2 p.m, it's 80 degrees outside, and you see jurors' eyes glass over, and I know what's coming. I know what that report is, and it doesn't come out cleanly. So we were thinking going into trial, we could summarize what she was saying using her own acronyms and abbreviations. Here's 712, here's 713, no match, something like that. And that exhibit was denied. So we were learning on the fly things we
get her story out.
Sidebar, correct? Because I don't remember.
It happened at sidebar.
Okay. So this is a very familiar spot in Boston for you. This is your old life.
This is my old life that I go by probably once a week. I took the train in and out of South Station every day to where I lived in Mansfield. And I'd come out the back, and this is where I worked for 15 years, Fidelity at 245 Summer Street. And
equity analyst was your title.
I was equity research. My role was a sector specialist, and it was in this building at 245.
Do you still stay in contact with any of the people you worked
I
with?
do. I would say about half of my donations have come from former colleagues at Fidelity. Half of what you're aware of that you can see has come from former Fidelity colleagues. So it's funny, Ted. I was sent home from Fidelity, from that building, I want to say the second week in February 2020, the pandemic. And I remember talking to someone on the subway. I took like a 2 p.m. train back to Mansfield. And I was talking to someone else who had been sent home from a job, a different facility.
Because of COVID.
Because of COVID. And we were saying, well, we'll be back in a week, right? 2 weeks. Little did I know, I'd reconnect with someone I had dated nearly 20 years earlier in 2004. I'd be working from home for 2 years, and then he would be tragically killed, murdered. And I've been framed for it. And I never would set foot in that building again. So it was a pandemic, and then I was suspended from Fidelity officially as soon as I was indicted.
Is that their policy?
I would think so. I would think so, that it means there's been some due process.
Is there hard feelings about that? Or could you even have kept your job even if you wanted
I would not be capable of having that responsibility to shareholders and trying to save my own life. I was bitter at first, but I understand it. I just had such strong, tender feelings and I still do, for Fidelity. I would have stayed there forever. I was very happy there. But as former coworkers have reached out, have donated incredibly generously, I feel like, all right, it's the company is the people, and they've been there for me. And
do you miss that?
I miss working every day. I miss just being ordinary and not feeling like people are looking at me everywhere I go.
Does that happen?
It does. I don't know that everyone is, but I know people approach me everywhere I go, and I have to imagine there's people who aren't approaching me that recognize me. But I've come to terms with the fact, Ted, that this is what my purpose is in my life. It wasn't working at Fidelity. It wasn't teaching a night class at Bentley. Those jobs are replaceable. Someone else is doing the job. Someone else is teaching. Someone else is the dean at Bentley now that my father's gone. And we're here to shed light on the corruption that exists in this state. And I feel humbled by it in some ways. It's a nightmare, and I wish it never happened. But I also feel that I can handle this, and I don't feel weaker as it goes. I feel stronger. And the public support is a big, the restoration of my reputation, which was a big loss, has re-energized me, has energized me, rejuvenated me. But this is what I'm here for. And I get messages constantly mainly from people I've never met and from people that are suffering. And it's a lot of women that have either had like a physical loss of a spouse or a child, or an illness similar to mine, or with a colostomy bag, or have been the victim of police harassment, or some type of unfairness with the criminal justice system. And there's a lot of suffering in this world. Mine is just very visible, but I do feel honored isn't the right word, but I'm humbled by it. And I feel like this is your purpose. And a lot of people have purposes thrust on them that they didn't really want.
So people will stop you on these streets. What do they say to you?
A lot of times, so I just went to the cobbler to get shoes that I'm going to wear to court this week that I wore out during trial. And the cobbler on Tremont Street and someone in the shop said to me, just very respectfully, hang in there. And a lot of people are pulling for you. I hear that probably the most, if I could generalize the sentiment. We're pulling for you, hang in there. I was walking through the Common when the weather was warmer in the fall with an old friend from Fidelity, and someone just was running, some guy maybe about 25, 30 years old, running through the Common, and he waited until he passed me. And this was about 5 o'clock. There were people everywhere, and he just yelled, "Free Karen Reed." People will yell that in a busy area, but it's constant. And it's heartwarming to me that this is my old stomping grounds. I used to live here in the building on the other side of this park lane. That was my first apartment. I met my best girlfriend there, and then I started working at Fidelity.
Were you in your 20s when you all started?
I was in my 20s when I started at Fidelity. I'd been somewhere before that, but this area is comfortable to me. And there was a year that was kind of in hibernation where the general public did not know the truth of what had happened.
Right.
So I didn't know when I went out, what are people thinking? I would go check my mail or bring my garbage barrels in at night. I'd wait until nighttime, and then I'd go out to the street on Gilbert Street, where I used to live in Mansfield, and I just didn't want anyone looking at me or wondering or judging. And now I can only go out when I have energy and I'm ready to engage and I'm receptive to it. I mean, if we're having a rough day with the case or something personal, I can't just go out and be anonymous and just sit and.
Because someone will approach you.
Someone will approach, but it always feels good.
Yep.
And it makes me think, right, these are common people. These are the jurors.
Yep.
And I've had one experience with someone saying something negative to me. And I've had, I don't know, countless, during trial, every time we went somewhere on an average night or an average lunch outing, 20 people. In the summer during trial in this neighborhood, we'd have 15 to 20 people just to go out for lunch for an hour. We'd get stopped that many times. It does feel good. The contrast with what it was like before this, before people knew, it does feel good. It's just takes a lot out of you.
Have you always been high energy and sort of on the move, or have you had to sort of reach deep?
I've always worked well under pressure. I've had other challenges in my life, and I always feel stronger after I overcome them. What I've had to learn to do is keep things in perspective, not let the evil that's entered my life take over how I feel about people in general. And that's another reason when I'm out in a busy area, it's like, right, this is humanity. It's just, there's a few powerful people who don't have good intentions that have a lot of control over my life right now. But yeah, I've been I would say, yeah, high energy. I mean, I was sick for a while, so
Yep.
Notwithstanding that period, but I don't usually crumble under stress.
In your day-to-day, sort of since the first trial ended, would you say that, do you get any free time? Like if you're going to decompress, like what's that going to be? What's that? Do you like listening to music? Do you have shows, books? Where do you find that sort of, where do you get that rejuvenation from?
I feel the best when I'm working on the case. if I have a dinner planned with someone, and inevitably the conversation at the dinner table always turns to the case, or someone comes over and wants to talk about the case. I do have shows. I try to make it a policy, Ted, unless something is really pressing that comes up at night. I try by 8 or 9 o'clock to put some thoughtless TV on, a reality show or a movie, something fictional that I've wanted to see, just to help me sleep. And, you know, the first year, the first 6 months, a year of this hell, I had nightmares. I dreamed about John. I dreamed about finding him. I had this recurring dream that he survived, but didn't know what happened to him. I've not had that dream in a long time. But I found I've got to try to force my brain to shut off, and then it becomes muscle memory. Then by 10 or 11 o'clock at night, once you practice, in my experience anyway, once you practice a routine enough, it becomes easier.
When does the day start? If it ends around 8 o'clock at night, are you working from 8 a.m. to 8 p.m. typically?
Yeah, I mean, there's breaks. I'll take breaks. I'll do stuff. Until recently, I lived in my house. I would do projects. I'd wallpaper, or paint, or work in my yard, just for health reasons, just to get fresh air, get sun on my face.
Do you ever running, or do you?
Yeah, I actually sold my treadmill to my neighbor when I moved, so I don't really run anymore. I try to lift weights every day for at least, 20 or 30 minutes. It just.
Is that also therapeutic?
Yeah, it is. It is. I listen to music all the time.
Who do you like?
U2 is my favorite.
Okay.
But I love anything. I love classic rock, alt rock. Seems all my friends are getting into country or have been.
Yeah.
And it's an acquired taste. I'm trying.
Yeah. No, I haven't jumped on that bandwagon yet.
I can't. I've been told my music all sounds the same, so I don't like telling other people that, but I kind of have to tell country music fans that this all sounds the same to me.
Have you been able to survive the last 3 years without falling into a depression, or have you and come out? Are you still in it?
No, I haven't, Ted. I felt grief at the loss of John, and I've never been with someone so intimately, and then they're just gone from the earth. It's not like other relationships I've had where at least they're there. You may pass them on the street, or you may text them. The day after he died on January 30th, David told me I needed to hire a private investigator, and I did right away. And on January 30th, he drove to my parents. It was still snowing the day after John was killed. My PI picked me up and he said, "We need to go retrace your steps."
You did that on the 30th?
I did it on the 30th. And it was one of the worst days of my life. No disrespect to my PI, who I love. And I'm sure he was equally uncomfortable, but I could barely even get ready to leave. I'd just cleaned up for the first time. I'd still, up until that point, still had John's blood in my hair. I didn't have any clothes because I didn't think I wasn't going back to John's house. And we retraced my steps, and I drove by John's house, and there had to have been 20 cars, maybe more, wrapped around the block. And I felt like I was looking in on my life from the sky. That window, all my things are in there. I was just in there with him, and now I'm gone, and he's gone, and he's never going back. And they're mourning him, and I'm not there. And so those first few months, I think I started to get my sea legs. My two best friends, my best friend and her husband came, and we rented an Airbnb in Newport for 3 days at the end of March. It was cold. It was raining the whole time. We had dinner, and then we just went back and talked about the case. And it was very emotional, just a lot of emotions from all of us. And they had spent a lot of time with John. And David reached out to me while I was down in Newport, and he said, "We've got some discovery." And we hadn't gotten anything but the initial police report.
This is March 20.
This is late March 2022. I was reading the discovery, and they were implying in this report from Michael Proctor that I had deleted ring footage from John's house. That was the first time. It almost jolted me, Ted, back to you've got to start fighting. They're coming for you. This is not a case of they misconstrued my behavior or were told things that weren't accurate about me that morning. This was, oh, now they've got me deleting things. This is nefarious. What they're accusing me of is nefarious behavior, and the way they're doing it is nefarious. And I realized then when they drove me back to my house in Mansfield, this is getting even more serious than it already was. And I had my routine dealing with the grief, and it was, I woke up every morning, I prayed. I missed the kids very much at first, and my dad would come.
John's niece and
nephew. My dad would come over almost every day, and the O'Keefes had taken out a stay away order almost immediately, within like 48 or 72 hours. So it wasn't even an option to reach out to them. It was like they were gone too. And my dad picked up my rosary beads, which were on an end table in my living room. And he said, when you think about them and you feel helpless that you can't reach out to, you just pray for them. That's all you can do. So that was part of my morning routine. I would read, I would pray, because I was up very early. And then I started to get into this routine of working on the case from like 10 a.m. to whenever it started to get dark. And I'd call one of the attorneys, or I'd call someone in my family or one of my friends, like, this doesn't sound right. This doesn't look right. These times aren't right. These names aren't right. And then it's been a steady, I get really charged by, I feel like I'm fighting. I'm covering ground and I'm doing something constructive. I can't litigate this. I don't know legally how to maneuver, but I can at least help provide my attorneys with the materials they need to put together a motion or a cross-examination. I can do that dirty work.
How much of the day-to-day decisions are Karen Reed?
I have a strong vote in the decisions. I will always defer to Alan and David and Liza. They know best. They have the experience. But the longer this goes, I have more confidence in my decisions. Things I've suspected were happening or that are going to happen have happened. And I think that's because this is my only experience in this arena, and it's been very negative. And the motives of players in this on behalf of law enforcement are disingenuous, to put it mildly. And I think David and Alan have a wider sample with wider outcomes than I do. They've worked with honest cops, honest DAs. So I'm much more pessimistic right now. And therefore, I just happen to be better calibrated than they are.
It sounds to me like maybe it wasn't a seminal moment, but there was a time that, the grief was so heavy, and it's almost like you felt you were getting backed into a corner by what you were seeing in like the filings and the accusations, that kind of.
I think I channeled the grief into something constructive. And then somewhere in the middle of it all, I think I know that the lowest point of this whole thing for me, apart from 6 a.m. on January 29th, was getting rearrested. And now I wasn't expecting it. I wasn't physically expecting it. I wasn't mentally or emotionally. And then legally, I didn't even know you could be upcharged. I didn't even know that was a thing. I was expecting to be indicted because of, ham sandwiches, but I wasn't expecting to be indicted for intentionally doing this now. And so somewhere in the middle of all that, there's no time. There's no space to mourn anymore. Think about your previous life. It's like they've held me back at the starting blocks, and they've had this massive head start. I've got to catch up, and I've just got to put my head down and work. And it's been like that ever since. I mean, even if I get away, if I go see friends in Florida, I stay and work on the case, and then they pick me up for dinner, and we go out for 3 hours. And then it's, I'm getting some vitamin D and some sunlight, but other than that, it's the case. And that's how I feel best. I'll be so happy when it's over, but until I'm acquitted, this is the only thing that calms me down. I feel good going to bed at night knowing I've put in a solid chunk of time, that if I have to sift through these lies and this knot of lies, I'll just undo it thread by thread, and I'll take whatever you want to dish out.
how many pieces of paper have you put your hands on in this case?
I've worked a lot online.
All
A lot
of
of
them.
it is in Dropbox, and that was necessitated by being in this car and getting a call from like the whole ride up here. I was talking to Liza, and we just got Discovery, and there's not time, and it's not really efficient to print out whatever we got today, 200 pages, and digest it. But I can flip through my phone or my laptop. So, but if I were to convert it to paper, Ted, at this point, it's probably around like 10,000, I'd say, on top of videos, hundreds of Ring videos, hours of video from the waterfall, from CF McCarthy's, voicemails, phone records, even that, you know, we downloaded Jen McCabe's gray key extraction, and we were in the physical analyzer for Celebrate. It's, you don't even know where to start. Do I look at when was her phone unlocked? When was it vertical versus horizontal? Was there a temperature change in the phone? Was there an elevation change? When was the phone unlocked?
That's how granular you're getting?
Yeah, because you just don't know what's, like John's phone, for example, when it was locked, when it was in, when the backlight was on, when did he read his last text? And Jen, for example, we went through all her location data. Well, Rick Green did, but then Rick gives us access to Celebrate, so I can go through it myself. It wasn't until trial started, the jury was impaneled, and Rick called us and said, you know, on a whim, I started looking at Jen's location data for the days immediately following January 29th. And does this address mean anything to you? And it was Michael Lank's address.
Remember that came up in trial.
And that came up at
Oh,
trial.
yeah.
And then they tried to preempt it by this police report that we got after Jen took the stand, after she's already gone, saying, yeah, Jen was there. I don't know what her story was, trading cupcake recipes with Lank's wife. Once again, at a lead investigator's house
Cupcake
on this
recipes.
case, but he wasn't there. She was talking to the wife, which is a story.
Right. And
Cupcake recipes have entered the chat. She's talking about that visit to Lank's house. Let's hear that. I want to hear that again.
Access to Celebrate, so I can go through it myself. It wasn't until trial started, the jury was impaneled, and Rick called us and said, you know, on a whim, I started looking at Jen's location data for the days immediately following January 29th. And does this address mean anything to you? And it was Michael Lank's address.
remember that came up in trial.
And that came up at trial. And then they tried to preempt it by this police report that we got after Jen took the stand, after she's already gone, saying, yeah, Jen was there. I don't know what her story was, trading cupcake recipes with Lank's wife. Once again, at a lead investigator's house on this case, but he wasn't there. She was talking
Right.
to the wife, which is a story. That
Right. And she
might
said she
sound
never got
familiar.
out of the car.
Said she never got out of the car. This was, I think, the date at Lank's house was January 30th. It was still snowing that day.
The
It's
day
freezing,
after.
but she doesn't get out. They sit, and she said, I think she said it could have been a half hour. They're just sitting in the driveway, which doesn't make much common sense. But that location data had to be parsed from all her location data that comes in latitude and longitude coordinates with like 6 decimal places. And if you see
Right.
negative 42.873566, it doesn't mean anything to you. You've got to then translate it to a map using another software. And then a lot of it's all around her house. And then maybe it's at the grocery store. And
Did that come from the feds?
that Jen's phone, Jen turned in herself. But
Would anybody in chat eat a cupcake that Jen McCabe cooked? Let me know.
it's so tedious. And that was a big data point
Yep.
that she was at his house. And we didn't find it until 2 years into this. There's always more to find. So it's not as if I'm retreading tracks, trying to find something I might have missed. There's always more ground to cover. And now that the case is so public and people are so supportive, now it's trying to digest these tips and which ones are fake, first of all.
So people send you tips.
We get tips constantly. A lot go directly to David and or Alan. Some come over Facebook. Some go to the administrators of the social media pages.
What is the normal procedure? Your attorneys will meet, several days, the night before? Like
Whatever they can afford to do.
Yeah, Alan Jackson's coming in tonight for a Friday hearing. And so are you essentially war rooming until that hearing?
Yeah, we'll war room. We have a few tips we want to follow up on. Alan
More
tries
tips?
to jam the schedule. If there's somebody that wants to meet with us that might tell us something useful, we'll schedule it. We'll cram in as much as we can get in.
So you're still developing information?
Yeah.
The camera is
we
up
got
on Court
information
TV, but
today about John's phone.
it's on the fan right now. So no, they're not back yet. Am I a tiny bit behind? Maybe, but no.
That is exculpatory.
It's the first time you've seen it
From
because it just
outside
came
sources as
out.
well, not
From outside, yeah, no, from outside. But sometimes, Ted, it's the internal discovery that opens up another door, another rabbit hole we've got to go down that might make sense with something we've heard. It's constant triangulation of what do we know? What have we been given in discovery? Of that discovery, how much can we actually rely on? How much do we think is manufactured? And then does it dovetail with anything we've heard from people in the community?
Right.
I mean, if I could afford to,
It's good stuff,
I would
right?
have the lawyers and I'd have more PIs. My PI is great, but we throw everything at them, and we'd be trying to follow leads.
Is your
every
private
day.
does your private investigator work full time for you?
No.
So
no.
It's
He's
as
ad
it
hoc,
comes. So.
Yeah. Sometimes I won't speak to him for a month, but he's always following things.
If you're just coming back, this is a new interview. New part 3 of the interview with Ted Daniel that was just released. Court TV fan is back up, and that's it. So we're watching this. This is about 36 minutes long until court comes back.
Just give him a heads up, day's notice, and he's going to meet us tomorrow in the afternoon to track down a few things. A lot of it ends up being nothing, or it's something that's not admissible. A ton of it is hearsay, which is something I didn't know anything about going into this. Well, someone heard from someone else that parts of the basement were replaced or something was broken in the house, and can't go anywhere with it.
So does Robert Alessi then, does he take part in like this sort of day-to-day stuff, or is he more focused on sort of, like he was critical in the Dr. Russell?
Yeah.
So are portions of the case divvied up then to different people to work on?
Yeah. So ideally we would be full-time trial prep, or at least full-time for me. And when the lawyers are working on my case, it's trial prep. And now we've gotten this curveball for these job requests that it's, and we're expecting more. So we've gone through Dr. Russell on the dog bites. Now
The fan is on. Thank you. But the fan is on right now.
For people who would understand this,
Unless it's on a different channel. I have Court TV up.
What, 6 people testify in the first trial, and for the second trial, the prosecution is trying to prevent
most of them.
How many experts are they trying to prevent right now?
I don't know where they're going to go with ARCCA, but I think
so they did file.
Court is back on what? Okay, now they're moving the camera. Thank you. Don't worry, because
about ARCCA. They're trying to accuse us of a discovery violation that they don't have all the available information on ARCCA. I didn't hire ARCCA.
Right. And that information could only come from.
All right, we're gonna stop this. You can go back and watch it on Boston 25 later. There's only a couple more minutes left of it, but everybody's screaming that court's back. So hang on, we're gonna move over to there, and it's Court TV, so the volume may suck again. And if it does, Boston 25 doesn't have it up on YouTube. We'll have to modulate it again.
May it please the court, I first want to thank Your Honor for the generous amount of time you're according to me.
Go right ahead, sir.
Better?
And take your time, Mr. Alessi. I shouldn't have cut you off. I appreciate that, but take your time. This is important.
Thank you. So, Your Honor, I left off with page 58 of tab 8, which is last week's hearing. And what I want to do is to go to, because
I'm sorry.
I'm gonna
Why
go-
is everyone saying it's back? We're watching it. Are we not watching it? Hold on. We're watching it. Yeah?
backwards ever so slightly because it's an important segue to returning to page 58. So I referenced the court to page 57, line 11, where the Commonwealth
They're behind.
said, response in quotes, "Hi, Ellen, substance to our conversation on Wednesday, the U.S. attorneys," and he's quoting according to quote the, and it's good to have it, Your Honor, can be having tab 1, which is the March 22nd email, because I'm going to compare and contrast tab 1 to where I am on page 57. And Your Honor, I'm sure will recall that I dubbed tab 1 the pause email.
Yes, so I have them, and rather than me going from tab to tab, I'm going to use my copies. So go right ahead.
Perfect. So I'll just refer to them, Your Honor, as the date. Is that what's best for the court?
Yes.
Okay.
What he
So the
said.
March 22nd email, I've dubbed the pause email.
Yes.
And because of obvious reasons, and it's got the word pause in there. And the pause is a very, very important concept because the pause is the stopping of communications before really things even got underway. It was before there was even an agreement, an engagement, et cetera, et cetera. So compare that, please, to the quote, purported quote on page 57. 11, "Hi, Alan, subsequent to our conversations," he's quoting purportedly this email. "On Wednesday, the U.S. Attorney's Office asked me, are there any further conversations? Did we receive additional information from their office regarding how our involvement will move forward?" Your Honor, there's not one mention of the word pause in that quote. The word pause was left out of that quote. That is the foundation of that email. And it's not merely semantical.
Hold on. Let us rewind that. He's calling out Brennan again. I'm sorry if the captions drive you crazy, but we have people in the chat who are hard of hearing. And so we try to accommodate everyone. So I'm sorry, but I'm not.
Did we receive additional conversations? He's quoting 11, "Hi, Alan, subsequent to our conversations," he's quoting purportedly this email. "On Wednesday, the U.S. Attorney's Office asked me, are there any further conversations? Did we receive additional information from their office regarding how our involvement will move forward?" Your Honor, there's not one mention of the word pause in that quote. The word pause was left out of that quote. That is the foundation of that email. And it's not merely semantical, it's the cutting off of communications. And it's unfortunate that that pause was not quoted on page 57. Now back to page 60, excuse me, back to page 58. And this is where I left off. Line 2, now this is an information provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests, touring requests, and in assistance, the best I can to get as much information as I can. Defendant provided an outline of the questions and answers for direct examination. So this is where I left off. That's not correct. It was Dr. Wolf that provided the outline. It's really important when we're talking about a collaboration, et cetera, communications, that's not accurate. And Your Honor, what is important to note, Your Honor asked about when did the defense provide the discovery?
And you told me the 12th. Right?
And I want to correct that. I was off by a day. It was February 13th.
Okay.
Because it's important to try, I clearly understand to be as accurate as we can. I'm the one creating the standard that every word counts, every date counts, so I want to try my best. I may get some things wrong, but I want to try my best to get it. So what I did during the break is I went and asked for the email that sent that request. So it's the email from the defense to the Commonwealth providing the discovery.
Okay.
And the email is dated February 13, 2015 from, and I've got extra copies if the court wants it, if the Commonwealth wants it, from Evelyn Arellano, and she is an employee of the Worksman Jackson firm. And it's important to who it's addressed to. Two, the first name on it is Hank. That's the first name on it. To Hank, Mary Ellen, Adam, and 9 more. Good afternoon. The Dropbox link below contains ARCCA reciprocal discovery. Please let me know if you experience any issues accessing the files.
Okay. What time of day? Because if it's California time, it might be different than what we have here. But
It probably will be, but I don't know what time of the day. I'm going to ask the team if they can access what time of the day, because I don't know the answer to that as I stand here.
okay.
All right.
And so but suffice it to say that the hearing was on the 18th. So it wasn't like it was a Friday and then we're back in court on a Monday. My best recollection, the calendar will be the best evidence, is that this was toward the middle of the week, right? But in any event, let's say worst case scenario, it was dispatched at 9 o'clock at night, California time, which would be midnight Eastern time. And let's assume worst case, it's therefore in effect the 14th. That's 4 days before the 18th.
Well, it doesn't matter what time zone it was. It was 4 days, not hours.
Pardon me?
Do you have a time, Ms. Little?
Yes, one moment.
Thank you.
Really? Really?
And I'm understanding Your Honor would like me to pause until you get that.
If we can, because I'm looking at a
Absolutely.
calendar.
Yeah, she's looking at a calendar now because it's really
If you
meaningful.
don't, I thought
It's
you may have
4 days
moved. We can
ahead.
move on.
Oh, Jose Castro, I love that. Thank you.
Thank you.
It is that, may I ask Your Honor if that's Eastern time, 6:30?
Eastern Standard Time.
Thank you, Mr. McCall.
And Your Honor, it was a Thursday.
I'm sorry.
It was a Thursday.
Okay, thank you.
So
Mrs.
also,
McLaughlin has to correct.
in big bold letters, at least on the printout, the subject is Karen Reed ARCCA reciprocal discovery. It's not like it was buried what was being sent. I mean, this was a lot of things, but it's right there, ARCCA reciprocal discovery.
Mm-hmm.
Was it just these pages that we've been talking about, or was it a lot more discovery?
May I confirm with counsel? I think I know the answer.
It was just the pages, Your Honor.
Okay, thank you.
So it's not like ARCCA is amidst a sea of other topics, right? This is the driving force of the email. And so, Your Honor, the question, and I'm going to keep moving on, but the question becomes, and I'm going to ask it more than once, but hopefully not too much, how is it that the Commonwealth on the 18th understood incorrectly, I think it's undisputed it's incorrect, that they got these materials from the federal government?
Yeah.
We don't know the answer to that question, but I respectfully submit it's an important question. Was it an honest mistake?
And maybe, Your Honor, you should ask them that. Maybe you should ask them that, Your Honor, because now you care about detail. All of a sudden, you care about what time zone this email was sent in when it was sent 4 days before the hearing. Yeah. Mm-hmm.
Mistake. Was it just, as happens sometimes in lawyers working together, there's a lack of communication, there's a miscommunication? Is that the explanation? But I think truth and justice on these topics, since we're being so exacting and appropriately so,
Yeah.
we should have an answer to that question.
100% intentional, Your Honor.
So we move on to page, so there we have on page 58, we have another incorrect statement. We have two of them right up off the top, and then we continue on to page 59. Your Honor, understandably, says the court. What is the date of that? Mr. Brennan, It's not dated.
It's
When I
not
said date,
dated.
what was I talking about?
I
Email.
believe, Your Honor, you were talking about the outline.
Just give me a second.
And Your Honor, if I may, I want to give you the second, but the basis for that answer is page 58, line 7, where the statement is, and what follows is all about the outline.
Okay.
She wants the
So, Your
metadata
Honor,
of the email.
appropriately and understandably says, what's the date of that? Here's the answer Your Honor got. It's not dated. It's not dated. Now, let's please just go back to tab. We're talking about the outline.
No, we can't
Let's go
switch
back
streams. No,
to the
the
outline.
audio is better here. Maybe you're behind, but no.
And we can pick either one. I'll pick perhaps the most probative one. I'm not going to refer to the tab because Your Honor says you have these. This is the June 23rd email from Daniel Wolf.
There's about metadata now. Now she cares.
I'm just pausing to make sure
I
you.
have it.
Thank you.
It's what I refer to as a script, right? That's what you're referring to?
That's what Your Honor has referred to it as.
Yeah, so
Subject-
that itself is not, I understand it's with the email, but it's not dated.
Well, Your Honor, I was going to get to that, but there's context for that.
Okay, go ahead.
The context, you're correct. The outline itself is not dated. However, the attachment, keep in mind, we produced these materials.
Okay.
So we deal in e-discovery all the time. And when you look at the attachments, everybody relies upon the attachment line, especially if it's a Word document. So it's wolf_direct.docx. So you know this email has an attachment. We fortunately have a file named direct. Your Honor has referred to it as a script. There is no other document that was produced that comes anywhere near close to this being the direct. So I don't believe there's any reasonable basis other than the other email on the quals that came the day before, 2 days before, the day before June 22nd, which has the same attachment wolfquals.dcx.
Can I ask you a question just
Yes.
because I don't understand? So what I have separately is the.
Yeah,
script
because
and
you
then
don't
something
understand metadata because you don't even think it's important. But now you want to know the time zone. And now you're all about the metadata. Welcome, uncivil law. Uncivils are here. Uncivilians are here. They've rated us. There's Ted Daniels sitting in the back of his computer. We just watched his most recent part 3 interview with Karen Reed during the lunch break, and it was great. Really humanized her, in my opinion. I thought it was fantastic. Okay, the sound is fine. I'm not switching streams. This one has closed captions. The other one did not. And so I try and please everyone, but there will always be some people who are not happy. And that's just the way it is.
qualify the expert. Is this all one document?
No, Your Honor.
All right,
And
so
I appreciate the question.
What
So-
is the date of so you're saying what I refer to as the script was sent on the 23rd?
She's trying to save Hank.
What was the other one?
The other one was sent the day before on June 22nd.
Okay.
I'm just going to give the name that the email has. I think it's wolf_quals document. Okay? So there's 2 emails. One's just the quals. The other, I respectfully, Your Honor, I know what you're calling it. I'm just going to call it what it says. Sure. The title is direct. So it doesn't matter which one you're talking about. To me, it doesn't matter whether there's a date on the actual quals document or the direct document. We produced them in this fashion, and I believe the only reasonable conclusion is that the outline is what is sent under the June 23rd email. And Your Honor, the reason why I persist in this is because if Your Honor goes and looks at the, and this is important for the context, if you go back to the June 22nd email,
Okay.
the last sentence is, I will try to work on some direct examination questions tonight. So you know that when the direct comes in the next day, I think the only reasonable conclusion to make is that that direct outline was created after the 22nd or on the 22nd or after, and certainly by the 23rd. So that's what the Commonwealth had in terms of the information. So in conclusion on this point, but I think an important one, it's not dated, but here we go back to, Your Honor, the TURI request is a recent February response, but they, and I'm assuming the Commonwealth meant the federal government, send random documents. There's no real accounting. But there is an accounting on the face of the emails that I just went.
Hold that thought. I just have one other thought.
Yes, please.
We're talking about Saturday, June 22nd, what was sent as an attachment with the email, and Sunday, June 23rd. So this was before the witnesses testified, right?
That's
you are
correct.
saying that this was disclosed prior to the February 18th hearing, but was this disclosed prior to the witnesses' testimony?
The answer is no, Your Honor.
All right.
The
I
answer
just
is
wanted
no.
to be clear. That's how I see it. I just wanted to give you the opportunity to tell me if that's not accurate.
No, that's 100% accurate.
Okay.
And I'm going to get to that. To me, that's a Rule 14 issue, not a candor to the court issue.
Okay.
So now
He's saying it's a discovery violation, not an ethical violation. That's a very important distinction.
if we could please go back to page 59.
I'm there.
Thank you. There's no real accounting. Now, I'm not saying that undermines the conclusions of ARCCA. There's another okay, so to speak, with ARCCA. Or I'm not saying they're not qualified witnesses, but it certainly shows some bias. I went over a lot less than blah, 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 blah. Now, here's the next one. Another comment. He's quoting, would it be fair to say, because you had a lot of nighttime visibility work, your cases frequently involve pedestrians? Now, and then yes, unfortunately, there is a direct correlation between the time of day and pedestrian facilities. Statistically speaking, most pedestrian facilities occur during the evening.
Fatalities.
I'm sorry, thank you. Fatalities occur during the evening and night hours. End of quote. And then the Commonwealth adds a commentary. That would have been nice to have. They had it. They had that.
Yeah, they did.
What's the objective evidence that they had it? I go back to the voir dire. They had it 4 months ago. 4 months before last Tuesday.
Yeah.
They had it before we turned over the discovery. And what's the objective evidence that they had it? Is the voir dire of June 18, 2024 of Dr. Wolf that I referred to earlier, page 167, line 12. This is Dr. Wolf. Well, to give you an example of that, so I do a lot of nighttime visibility work where, for instance, let's say a pedestrian's coming down the roadway, et cetera, et cetera. But that's not the end of it. They had it twice. So if we go to the direct testimony of Dr. Wolf that I referenced earlier, this is my tab 6, but I'm going to stick with, it's the date of June 24, 2024 of Dr. Wolf. Page 36-65.
Okay.
Line 22. This is Dr. Wolf's answer. Several hundred, period. As I mentioned earlier, you know a great deal of my work is in the field of lighting and visibility. Here comes the key points. So there is a direct correlation between time of day and pedestrian incidents. We see a rise in the evening and night hours just due to drivers having a difficult ability to try to perceive and recognize individuals. So I certainly see a lot of pedestrian collisions in my casework.
Yep.
There it is.
I did see that.
So let's
Where's
go
the
back.
prejudice?
That's misstatement number 5. It would have been nice to have, I agree, it would have been, and you did.
Right.
Twice. Next. reading on the same page 16, he's quoted. So, my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. That's the end of the quote, and then the Commonwealth takes on with a commentary. Pretty important stuff in this case. I agree, and you had it twice. And then he comments, if you don't want me to say this, that's fine, that's fine. Then the commentary from the Commonwealth. Shh, and I went back and watched the video. Shh, don't tell them. I'm sorry? What do you mean don't tell them? You were told twice, in the voir dire, and in the direct, it was just unvarnished. And here's the important part, Your Honor, another important part. Mr. Jackson drew that out on direct. Not only was he not shushing or hiding, it was Mr. Jackson's question that drew that out. So here you have Dr. Wolf trying to figure out, is this something that we should say or not? And honorably, Mr. Jackson, no, we're going to hit it head on. Mr. Jackson draws it out, puts it right on the table. 4 months before February 18th.
Yep.
The whole world heard it live. Next, if you could, Your Honor, please go to page 60. I'm sorry. There's another point no, let's go if we could. I don't want to take the lesser significant ones. I want to focus because there's many of them. I want to get to the more significant ones. So then we have on page 60, line 2, and then a bill from ARCCA to the defense for $23,925. That's not a trial by ambush. That's getting duped.
Yep, he said that.
So I, Attorney Brennan, didn't know any of this. But I've tried a few cases. I've been around the federal court a bit. I know how it works. So what is the import of that statement? I didn't know any of this until I got it from the federal government. And we're talking about the invoice. No. You know about it because the defense, after the certificate of completion of discovery, in 6 weeks before the trial is starting, the defense affirmatively turns it over and does it not buried among several discovery documents, but essentially a tailored discovery response that's titled Karen Reed ARCCA Reciprocal Discovery.
What is he going to say?
That's not a very good way to try to cover up something. There is no statement about the date of the invoice on February the 18th. So people are left to wonder, when did it occur?
Right.
When was this bill stated?
Please
the date's important for that invoice. Then there's a lot of statements made. Sometimes parties pick sides. It creates blah, 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 blah. And then it allows the ability of one side to use ghosts. They create illusions and shields and say something's there and something's happening, a federal investigation, and this person, and then this happens.
Ghosts like in the inverted Sallyport video. Jody says Karen Reed is innocent in all time zones. Preach, girl, preach.
Your Honor, I think it's important for the defense to be allowed to speak to the very words that were used against us. Ghosts. Illusions, shields. That's what we're accused of. I choose to try to comport myself and practice a certain way and give people a little bit of the benefit of the doubt. But if we're going to be talking about ghosts, illusions, and shields, I don't think it's the defense that's creating ghosts, illusions, and shields here. The illusion, and it's more than an illusion, it's a statement of fact, is that all these documents came from the federal government. It's not an illusion. It's a statement of fact. Statement about federal investigations that were these are not ghosts. We're not creating it, but I'm not going to go any further on that topic. But the ghost word was used, in my view, the way I read it was, these topics we're making up. right? And we're hiding things, shield, right? We're shield, I interpret it as you're preventing us from getting this information, defense. And this is 5 days after we had provided it. Next line. Page 60, line 13. I don't care if the ARCCA witnesses testify at trial. Very pleased to hear that. I don't care about their opinions. I'm pleased to hear that too. But I care that it's unfair, imbalanced, and hidden.
Yep.
Hidden. And that is based upon the faulty premise that we didn't turn it over and the Commonwealth got it from the government. There's no other way to read it. And the Commonwealth, like the defense, is entitled to discovery. I agree with that. The Commonwealth is entitled to discovery, and you got it 5 days before February 18th. Now comes to the court. All right, I'm going to take a recess. And I certainly, Your Honor, am not going to be so officious as to even delve into why Your Honor wanted to take a recess.
Yeah, please do, though.
But
Come
I will
on.
tell you what I thought and what I believe occurred. Your Honor listened to a completely counterfactual rendition of some of the most important issues of the day and, frankly, of the moment in this trial. That's right. And the reason I got a little bit of an inkling is because what happened when the court came back. So what I concluded, after all of this, and the court saying the break is, after all of these inaccuracies and piling on of inaccuracy after inaccuracy, there's a cause and effect in my mind between the several and serial inaccuracies, the break right in the middle, and then the court comes back. And I understand, I don't really, and I'm going to get to this, see the justice in terms of this presentation to the facts. And that's what we're going to be talking about, facts and representation. So here's what the court says. After hearing all of this, and I want to underscore something, Your Honor, and I'm not going to get too lofty with due process and notice, but it's important to hit some of these points. All of these topics that were raised were not in a motion. They were not in an affidavit.
Right. We said that.
And I've had this issue before with other motions under what's required in an affidavit. None of
In this case?
Yeah.
No, I'm talking
generally.
What he said in court is not in writing.
Other cases, Your Honor. With there not being an affidavit, right, where someone's got to be very, very careful about what they say. But in this information that Your Honor had to be subjected to was not in anything that we had notice of, these topics. We had no notice that this was coming. There was no affidavit that someone had to swear to that all of these facts were correct.
That's right.
And
Preach.
Your Honor takes the break. So we didn't get an opportunity to stand up and say, what I'm being given the very fulsome opportunity to say today. So Your Honor comes back. All right. So the Commonwealth just provided the court with information. And I don't even want to repeat these words because it almost pounds on to the prejudice to the defendant. But Your Honor well knows what Your Honor said. But it certainly had the words in there that were very, very difficult on the defense. And you say, so for that reason, right? So the Commonwealth just provided the court with information that causes me, and then it goes on. So it's clear that Your Honor was relying upon that information, which was only given verbally, right? And you say, so for that reason, I'm going to suspend today so that we meet again, and then the rest will be back in here.
Yep.
Unfortunately, that's not the end of the prejudice.
No.
So what happens
Hung out there for a week.
All of a sudden, and Your Honor basically said, and this is all so key. So you said, I'll see you in a week from today. And then Your Honor continued on page 61, line 12. And where Mr. Brennan, where the federal authorities have been kind enough in the past to allow me to have copies of everything.
Yeah.
Would you be kind enough to call over there and check?
You said to Brennan, Call the feds and get them to send me all the stuff you just referred to. He's on fire. Go, man, go.
With whomever you were dealing with, so to see if I can, in fact, get a copy of everything that you just read.
Yep.
It was only then when the specter, not specter, the reality hits that you're looking for the backup for what's being said.
Yep.
Up to this point, Your Honor's understanding, all of this came from the feds and the defendant didn't turn it over. So what does the Commonwealth do then? Does the Commonwealth stand up and say, whoa, wait a minute, I made a mistake. And Lord knows I've made mistakes before. They didn't stand up and say,
I want to correct the record.
A very significant mistake. My whole predicate for my whole presentation was I had to even fight the feds to get this information. Lo and behold, I got it, and I've been duped and I've been ambushed. Rather than saying that, and you know what, I don't even know if I would have had the courage to say it in open court. I might have asked for a sidebar and come up and said,
the courage, because he knows it was so out of line what he did. He said, I might have not have even had the courage to say this in open court. I might have came sidebar because this is embarrassing. Not only is it embarrassing, it's an outright lies to the court. I wouldn't have I would be embarrassed to get up and say this in open court.
But that didn't happen. So what did happen? The Commonwealth says I can, and there's a brief chronology I think Your Honor should be aware of. So the defense is still not able to get up, but the Commonwealth is continuing on. If I could add that right now, it will take me less than a minute. The court, okay. So the Commonwealth goes on, says the chronology is December 4th. We sent another TUI request, 2024. January 6th, we filed our notice of intention to exclude ARCCA experts. January 30th, 2025, the United States Attorney's Office sent a response to both ours and the defense request. Without any prompting on February 6th, 2025, the defense and the prosecution received an email from the US Attorney's Office saying that the contract had ended with the ARCCA experts and that if either party wanted to engage, the original materials are still protected. This was a change in position about whether the party could be impeached. On February 11th, we filed a motion to exclude. February 13th, the defense provided us the emails that I read.
The defense.
Buried in a chronology.
Buried the lead. Said that.
And in the middle of the sentence is, the defense provided us with the emails. I think I said, I'm going to repeat that. I think I said, the federal government, it was the defense. February 13th, they sent.
His entire argument was predicated on that. I think I said it was the feds. I call ducking BS.
Us the emails in the direct examination outline. I think I said that was the whole basis for the entire presentation, was that the Commonwealth had to fight, needed the feds to get that.
That's right.
And then it goes on. We reached out to the federal government, but you know what was not said in lines 9 through 14? What was not corrected? It wasn't corrected that the invoice came from the defense.
Right.
Just emails.
Oh, yes.
I thought it meant everything, but.
Oh,
I don't
it doesn't matter what you thought you meant.
Be drawn, Your Honor. You didn't say.
It doesn't matter what you thought it meant, Your Honor, because here you are calling them out for like ethical violations, like you want to pull his pro hoc status, and you thought it meant. Is she kidding me right now? Is she kidding me right now? I need some Twilight Zone emojis in the chat because my head is going to pop off. I'm rewinding this a little bit.
Just emails.
I thought it meant everything, but.
Oh.
I don't understand how that conclusion can be drawn, Your Honor. You didn't say the defense provided us with all of the entire production. The defense provided us the emails that I read. There was no email with the invoice. The invoice was discussed as a separate item, and I can go back to it. When the Commonwealth was talking about it, they never connected it to the emails. So then we reached out to the
because I received a copy of it.
It doesn't matter.
I think it's because I received a copy of everything that had been referenced.
That's not the point.
Yes, but I'm going to get to the point about the importance of correcting.
She's unbelievable.
Because 3.38.
You had any doubt
Everybody
If you had any
focuses on the
doubt
first sentence.
of her bias towards the defense, if you had any doubt ever, if you were giving her any shred of benefit of the doubt, you can throw that shred out the ducking window right now. How dare she in open court? This is horrifically improper judicial behavior. We're supposed to assume what you assume. We would assume that you would know that he was lying the whole time. We would assume that you would have given us the opportunity to get up a week ago to correct the record when that ass got up and said, I just want to, I think you need to know some chronology. Didn't get up and say, I need to correct the record about the complete lies that I just told you about where I got this information. We're supposed to assume that you knew. This is disgraceful. Disgraceful. The world is watching in real time.
Of it.
Pardon me?
I think it's because I received a copy of everything that had been referenced.
After
Yes,
the
but
hearing.
I'm going to get to the point about the importance of correcting misstatements, because 3.3A1, everybody focuses on the first sentence, which is, thou shalt not make a false statement of fact to a court. The second part of 3.3A1 is you get the opportunity to correct, you got to correct a material. And I've got it in front of me, but I'm just paraphrasing.
He's going to get to that part.
But that's why I perseverate this
Yes.
on this, Your Honor, because I trust that the court's going to hold everybody to the same standard. And so I think there is a proper inquiry. I don't intend to be officious as to what the court should do, but if we're going to start looking at comments of defense counsel, I believe we have to look at all comments. And again, I'm going to go back to my own view is this. Being a lawyer in cases like this is hard. Being a judge in cases like this is hard. Mistakes are going to be made. So we go on into page 62, line 15. We reached out to the federal government again because I was curious about the change in position on February 6th that the contract was ended, but that parties could contact ARCCA. Obviously, the Commonwealth is in no position to contact ARCCA because that would naturally preclude the defense from retaining them. So we refrained and we will not reach out to them. This is really an interesting statement because you read it because that would naturally preclude the defense from retaining them, yet at the same time, the Commonwealth, for the fourth time, has moved to strike our ability to use ARCCA.
Yep. So
then the court goes on, all right, so the information that was provided to you, not from the federal government, so Your Honor knew at that point, I don't believe Your Honor had any basis before that to believe that it had come from the defense. I'd like a copy of it before you leave the courthouse. So I hearken back, Your Honor, to what I conclude drove Your Honor to make those impactful statements about, on the top of page 61 was the presentation of the Commonwealth that I counted had 10 misstatements. 10. Before Your Honor caused the pause.
Mm-hmm.
So, coming to...
This is wild.
What happened then?
Can you see the steam coming out of my ears?
The Commonwealth, having not giving us notice that this was coming, these topics, not putting any of these statements in an affidavit, we didn't have the ability to stand up. But I will tell you this, Your Honor, I greatly appreciated the week that we got.
Yeah.
Because I do
got to
believe
count
that
to
Your
10.
Honor intended that counsel be given, defense counsel and defense, a fair opportunity to go look at this. And that's the way I'll speak for myself. That's the way I took it, and I appreciated that. Because that's allowed me to go spend the time that I spent to try to do my level best to give the court an accurate rendition of the fact, because as an officer of the court, I believe that is a sacrosanct duty.
Unlike
no
Brennan.
matter where the very issue is, what are counsel saying to the court that isn't accurate? I wanted to make sure I could do the best I can. Now, I may have made a mistake here or there, but I just want, and today, but I want to make sure that I recognize your honors giving us that week, and we've tried to take the best opportunity for it. So what happens? What happens after these 10 misdirections?
Misdirections, better. Misrepresentations.
The court's comments go viral.
That's right.
And
Viral.
I'm not saying this for drama's sake. I'm saying this for what has impacted the defense 6 weeks before trial starts, while jury notices are out in the mail. Those words, based upon the misdirections that your court had to endure, have gone through, and I'll just name a few headlines in the Globe, the Herald, every TV outlet, social media exploded. And these are not trivial issues. And more than that, the veracity of counsel has been called into question. There's commentary of everybody about what's going to happen to certain members of the counsel's team, and whether it's intended or collateral damage. We've got the ARCCA experts, which are key parts of our case. Their credibility is being pillared throughout the public domain. And this could have been avoided. Had there been an accurate recitation of what had occurred. In your honor,
and lies.
I don't know if this can be remedied.
You got to recuse yourself, Judge. Oh, go, Bobby, go.
But it surely shouldn't have been exacerbated.
Yep.
I would now like to move rather hopefully efficiently through the next step, which is to point to the Massachusetts rule and give the court my view, and I have to reference because Your Honor brought up
Again,
some.
you don't have to tell me what you're going to do, Mr. Alessi.
I'm sorry, I'll just go ahead and do it. My apologies. So now let's just turn to
Your Honor, I don't know if this can be remedied. There's the soundbite. You don't have to tell me what you're going to do. He's organized. Is that a bad thing? Hey, Paul. Point at your chin.
model rule.
Na 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 na. All together now. Na 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 na.
This applies to
Hey, goodbye.
every counsel in this room, of course. A lawyer shall not knowingly, so there's the adverb of the mens rea, knowingly, make a false statement of fact or law to a tribunal, or fail to correct a false statement of material fact or law previously made.
You mean like Brennan did?
Tribunal by the lawyer. So we all know the mens rea of knowingly. And this court knows it better than everybody, so I don't have to get into that. But in terms of make a false statement of fact or law to a tribunal, I don't see that on behalf of the defense, and I'm going to get to the new item of February 6th, because we haven't covered that. Your Honor brought that up today. But certainly with regard to the representations that I've gone through and the statements that were made, especially on June 10th, they were 100% true and accurate at that time. Yep. They were 100% true and accurate, and that's why I went through the note. Or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. And there's no real time period that's given for the attorney. But here is something very important, Your Honor, and I'm going to parse the grammar because it's what you do in construing the statute. It says, or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. So the is a definite article. So it's like an adjective, it's a definite article. Lawyer is the noun. The lawyer refers to the lawyer who is perhaps made a false statement of fact or law to a tribunal. So it's sort of like you make a mistake and it happens, but you know, you got to correct them, right? And what they talk about is, what do you have to correct? You have to correct a false statement, so it has to be false.
Mm-hmm.
It has to be knowingly false of material fact or law. And material has been interpreted in the context of 3.3A1 to be a statement of fact or law that caused a court or adjudicator to have relied upon it for a determination. It's essentially what the case law talks about, that it's influenced the judge's decision. So let's go back and even let's assume hypothetically that on June 10th, there were misstatements made. It's not any misstatement. It has to be a failure to correct a material. You have to do it knowingly, and then you have to fail to correct a false statement of material fact. And in terms of what Your Honor had, it's the same lawyer that we're talking about in both clauses. And that is why I spoke about Mr. Yanetti's statements on the 10th, about what he knew, the fact that Mr. Jackson was handling the ARCCA experts. So it's important to be analyzing what lawyer is saying what and which lawyer is to be making correct to correct the statements. So I go to the analysis with regard to 3.3A1, and as I said, I'm keeping separate 3.3A1 from Rule 14 because they're different analyses, as the court knows. But I want to hit the one of the most important ones first. So there's not a false statement of fact or law to the tribunal, and I will stand here as long as Your Honor needs, if Your Honor feels differently based upon what I've said, or fail to correct a false statement of material fact. So what I'd like to do, Your Honor, is now go to what Your Honor brought up today, because I was prepared for the June 10th. I wasn't prepared for the February 6th.
Do you need time?
I don't. I have taken the time. I appreciate the offer. But I would like to draw
Do you need a break,
attention,
Judge?
Your Honor, because like I provided context on June 10th, I think context for February 6th is important.
Do you need to take a powder?
And so what I'd like to do is to go back earlier than what Your Honor quoted this morning, because I think the context is important.
All right, so I have that entire transcript, like I said.
Thank
What
you.
page are you at?
I am starting on page 40.
Is she getting annoyed that he's taking too long and making too much sense and making everyone look like a fool in the courtroom except for the defense team? Is she getting annoyed? Sounds like she's getting annoyed.
Okay.
I start with line 1. Mr. Brennan, correct. I had a conversation with one of the two prosecutors I spoke to, and the only means of trying to obtain information they suggested was through a TUI request. I don't think it's the Commonwealth's obligation to seek discovery, part of Rule 14, but I wanted to assist the best I could, so I made an assented to request, and they responded with a letter. I think you received a copy of it. Do you mind if I share it with? No, okay, I received it. I sent a TUI response, essentially rejecting all of my requests on multiple grounds. So to be fair to the Commonwealth, Your Honor, this is February 6th, and they haven't gotten our discovery, right? They're just still trying to get it from the government. They don't have it from us yet. The court, all right, can I get a copy of this? If not, I just need, and then Ms. Bugalton, you can retain that copy. Thank you. So I'm not going to stay here and read it right now, but all right, Mr. Brennan, of course. And so inevitably, I'm not making any motion right now, but I appreciate that as the proponent of the evidence, defense's obligation to give Rule 14 discovery. I do not think, even despite their testimony, they complied with Rule 14. And so the reason I forecast this was because I appreciate the April 1st trial date. If the defense, through no fault of their own, is unable to comply with the discovery, I think that we're entitled under Rule 14. I will at that point move to preclude the witnesses. So I think the important in this snapshot in time is all of the discussion that occurred on February 18th, and I'm going to underscore this. That presentation was not about the substance of what was in the email. The Commonwealth never had an issue with that. It was all about they had to get it from the federal government and we didn't turn it over. Your Honor obviously has read the February 18th transcript. You can draw your own conclusions. But on February 18th, they were not on the issue of anything other than they thought that they didn't get the material from us. So now we continue on. The court. Move to exclude the witnesses? Mr. Brennan, yes. The court. What do you say, Mr. Jackson? Mr. Jackson, I don't want the witnesses excluded. What do you want me to say? The court. I asked you all to try and work out something. The original protective order permitted that we can do in court anything that would rule. I expect you to say something a little more than that because, and Mr. Jackson, well, I'll wait to get this motion. The court, all right. Last time, Mr. Jackson, let me put it this way. The court, hold on a second. Last time we did voir dire of these witnesses, it seemed to me that that was the logical conclusion. I'd be able to get both sides discovered. We did that. That seems like a logical alternative to the exclusion, right? Your Honor knows what you're doing here. I guess we can wait and see if I exclude it on a motion to exclude. It just makes sense to me to set that up now rather than wait. I don't know when they do that, when the Commonwealth, based on their witness list, recalls them is that when you want to exclude it. So I sort of expected the defense would have some suggestion. If you don't, you don't. Mr. Jackson, and this is the key context. I can tell you this, the Commonwealth has exactly, this is an interesting and sort of different set of witnesses. The Commonwealth is saying that pursuant to Rule 14 and, exclusion and preclusion of a witness is a punitive sanction for Rule 14 violations. Ms. Reed has not violated anything. Why should she be penalized when the Commonwealth has the exact same batch of information that we have about these witnesses? And there's more context to that. I understand the import of these words so far. So I don't have any more information. I don't have any additional discovery. I didn't hire them. I didn't ask them to engage in additional protocols. So I've got nothing else to give to Mr. Brennan. He's got the same information I got and he got at the same time. What Mr. Jackson is referring to here is the disclosures from the US government, not the disclosures that were going to occur on February 12th and 13th when we would get the certificate. We had the certificate of completion of discovery. We had 30 days technically to turn it over, but it got turned over on the 12th. So then it continues on, is important, the court, if I don't exclude it with other side seeking a voir dire, we would not seek a voir dire because they're eminently qualified and there's no other discovery to give. They've provided, the federal authorities provided all the discovery that was intended to their analysis and testimony. So
the last time I smiled for this long in a row for this many hours was at a Grateful Dead show. Just so you know.
What we have in terms, Your Honor, this is important, and I'm going to go right back to 3.3a. We have Ms. Little handling all the discovery. Mr. Jackson is not sorting through discovery, knowing what we got, not recalling what is in the possession from March 22nd, not recalling all of those items. That was Ms. Little's responsibility. So what happens? What happens is Ms. Little handles the production, goes back and does the diligence that she always does, takes all that material, sends it over to the Commonwealth. On February 18th, the defense did not have the opportunity to address the issues that Mr. Brennan had brought up. But I now want to go to the statute and why it is important. Because the whole issue of discovery, the whole issue of batches of information was provided. And it was provided before, well before the 18th, before any of these issues came up. And Your Honor, respectfully, whatever the court may consider to have been an inaccurate statement, there is no knowing misstatement of fact. Mr. Jackson has never, I can tell you this from personal experience, I don't see him ever touch one item of discovery in terms of here's what we're going to collect, here's what we're going to turn over. Never have I seen it happen. I've spoken with him, he can speak for himself. That's not, so there's, even if you take any reading of February 6th, Mr. Jackson is focusing on and thinking the discovery is just what everybody has from the federal government. You've heard this many times. We can't produce more than the feds have, but we certainly, and I want to hit this head on, we certainly had
Hammer at
those
home.
March 22nd, March 22nd, we had those emails at the time that statement was made. We had those. We had the direct, we had the clause, not running away from that. But the question is, at the time Mr. Jackson made those statements, he's focusing on the government, and he's not knowingly saying in his mind, oh, well, I know we've got these emails from way back when. And so with regard to the shall not knowingly, there's no evidence of knowingly here, and I don't believe, respectfully, there can be an inference stated. When I looked at every single case where the court can look at the circumstances, so knowingly is not merely a subjective question of what an attorney has. The court is entitled to look at the circumstances in this. The case law says should make an objective determination on knowingly. But the cases, and I can give them to Your Honor, the cases are legion, that the court cannot draw an inference from no fact to conclude it was knowing. They got to have some basis, and I'll give you some examples. What happens is if, let's say somebody, one of the leading cases is unfortunately a woman attorney who was in a bad divorce. She had financial statements, and she made misstatements in fact about the financial statements. And then the question became, did she knowingly know it? And what the court did, she said, no, I didn't know it, I didn't remember it, I was under psychological stress. And what the court did was they went and they looked at the circumstances and saw emails and conversations she had with her accountant, where she clearly knew about those statements, and she told the court she did. So there's an example of you've got to have circumstances that the court cannot just jump from a lawyer said this to it's knowingly without some basis. That's why the mens rea is there. So in turn, and that's the February 6th, respectfully, that's the only aspect, and I went through all the others, that even comes close to a false statement of fact by Mr. Yannetti or Mr. Jackson. In sum, Mr. Yannetti's statements on June 10th, all completely accurate, Mr. Jackson's eliciting of the direct testimony at trial when he asked, have I ever asked you specific, questions, etc., that's completely true because it was Dr. Wolf who sent the questions in. So we now are left with February 6th, and I've given you that construction of the statute. My last point, Your Honor, is going to go to the Rule 14, which is, and I'm going to spend a very short amount of time on this. Now that the Commonwealth knows that the discovery came from the defense, I want to go back to, please, the February 18th transcript, because I want to keep separate analytically the ARCCA from defense counsel, because obviously for Ms. Reed is obviously very concerned about her defense counsel and her choice of counsel, which is going to be my last legal point. Yeah. But in terms of what occurred, I want to go to and quote the Commonwealth on the transcript.
Cooked goose.
I'm on page 62. Line 18.
Chat is on fire. Snark Tank is on fire
Obviously,
today.
and by the way, this is toward the very end of the 18. Obviously, the Commonwealth is in no position to contact, et cetera, et cetera. And what does that relate to? If Your Honor would go back to page 60, line 13. And it's a repeat, but I didn't get to the point here. I don't care if the ARCCA witnesses testify at trial. I don't care about their opinions.
That's the point.
But I care that it's unfair, imbalanced, and hidden, and the Commonwealth, like the defense, is entitled to discovery. Key line. So if they can produce the discovery, I welcome ARCCA.
Right. He doesn't care if they testify or not.
You don't need to.
I'm sorry. Okay. So my point is, we produced the discovery. Why is there still an issue with ARCCA? These aren't my words. So I want to cover, before I get to the Sixth Amendment issues, the point that ARCCA should be allowed to testify. We've complied with our Rule 14 obligations. There's no prejudice. They have
not the point. They want to get rid of Jackson. That's what this is about. They don't care if ARCCA testifies. They want Jackson out of there. He's too formidable an opponent for Mr. Brennan. He's afraid of him. He's afraid of ARCCA too, but he's really afraid of Alan Jackson, and he wants Alan Jackson gone.
the discovery. They've obviously had from the government a long time everything about ARCCA. So I want to touch that base to make sure that either intended or collateral damage that ARCCA still gets to testify, because it's a key part of the defense here.
Thanks, Pauline, for 5 membership gifting.
Now to the Sixth Amendment.
Bring it. Thank you, Hoskins.
The United States Supreme Court has held repeatedly that a defendant's Sixth Amendment right to defense counsel of their choice is a root basis of the Sixth Amendment. Is it an absolute right? No, Your Honor. If counsel does something so egregious, does it correct it?
Like Hank.
The Sixth Amendment gives way to the need for the court to have candor, the need for the court to have decorum in the courtroom. So I understand that. My presentation today was as an advocate, of course, foremost, but also to provide all the information. So when Your Honor balances that sacrosanct Sixth Amendment right with whether or not there has been such a level of conduct that can be diluted or trumped. And I give Your Honor United States versus Gonzalez-Lopez, 548 U.S. 140, 2006. And in that case, there was violations of the local rule. And the court, and the court struck their counsel for that. And the U.S. Supreme
Counsel pro hoc vice, or was that?
I'm gonna get to that. The answer is the counsel. I want to be sure my answer.
She's looking for reasons. She's looking for reasons.
Yes, and I'm going to read.
There's a great Lyle Lovett song. Play it in the background. It's called "She's Already Made Up Her Mind." Lyle Lovett, great tune. It's going on the playlist. Tell me what you think.
My conclusion, because it doesn't say pro hoc vice, but I'm going to read you a part of it that says, during the hearing, however, the magistrate judge revoked Lowe's, that's the attorney, provisional acceptance. So I believe that's the parlance of pro hoc vice, but Your Honor, I'm pretty sure, but I'm not 100% sure. And then the following week, et cetera, and then the revocation occurred. And yes, it was. So the Supreme Court holding, government conceded that Gonzalez's Sixth Amendment right was violated below, where the court denied pro hoc vice admission based on perceived violations of a local court rule.
All right, so pro hoc vice was not permitted in, it wasn't a revocation of pro hoc vice, there's a difference.
There is a difference, and both occurred in this case.
Okay.
There was both. Good point, both. So So, Your Honor, and there are other cases when you have the Sixth Amendment, the fact that someone is pro hoc vice status is not the determining factor. The Sixth Amendment, in terms of legal dignity, is way up here, and then the pro hoc and the local rules are down here. It's only when the violations that undergird the pro hoc vice get repetitive, get more than repetitive, but go to things that are done that aren't corrected. And the issues that I've seen in my research, Your Honor, is that they have to be so, the violations have to drive so much to the core issues in the case. It's like suborning perjury, putting people on the stand when they know they're wrong. Literally having objective evidence that counsel had a document in their hands, almost literally at the same time they're telling the court they don't have it. It has to be that severity to trump the Sixth Amendment. And why is that, Your Honor? Because the court has alternative remedies for if they really think that is happening. And that is going to be my last point on the Sixth Amendment. The case law is replete with the trial court having to be careful that whatever they do, even if they believe there's a basis for some sanctions, that the court look to do them post-trial so that there is not for the trial the bleeding in of those issues into pretrial matters. And the case law, there's a mention of that all the time. It encourages the trial courts to make sure that they're very, very sensitive to that issue. I don't think the courts are being all that sensitive and empathetic to the lawyers, but I think what they're doing is appropriately trying to make sure the defendant gets a fair trial, right? And the defendant is not adversely affected by whatever the counsel may or may not have done. But I want to be very careful and clear, Your Honor. I'm not saying that is sort of like mitigation. I'm saying, importantly, the time I spent that there was not these violations. If any occurred, they were corrected. And on Rule 14, there's no prejudice. And therefore, I conclude, Your Honor, and I would urge the court. What happened on February 18th? There were some misstatements and they weren't cured. I don't want this to turn into, and I'm not making this argument. I'm not making an equivalence argument. I'm not saying, okay, now let's turn to the Commonwealth. To the contrary, Your Honor, and I hope I provided a factual and legal basis. I don't want any of this to continue. I don't want scrutiny of the Commonwealth statements on February 18th unless there's going to be continued scrutiny of the defense counsel. And I don't say this as a camouflage or a shield. We've got a lot to do between now and April 1st. The last thing I'm sure the court wants or anybody wants is to have something happen where that date can't be met because of whatever actions come out of this. My hope is that we all understand we made mistakes. Mistakes have been made clearly by both parties. And I would urge that the parties, not talking about the court, the parties take a breath, a deep breath, and focus on the matters that are important, which is how can we prepare to make sure that the presentations to the jury are candid, truthful, and most importantly, effective so that jury can make the best decision. There's a lot at stake here. The issues are momentous, and that is the focus of the defense. And I, again, conclude, but I would ask that I have, if anything said, if Your Honor has any concerns, I would really appreciate hearing them so I can take them on.
Right.
Mr. Jackson, Mr. Yernetti, any questions Your Honor has, I would greatly appreciate it. My presentation notwithstanding, if there's still concerns with the court, we will take them on as best we can, and certainly candidly. Thank you.
All right, I appreciate that. Before I give the Commonwealth an opportunity to respond, I need 10 minutes.
All right.
She's taking 10. We're a little behind, so that's kind of good. because, she doesn't like to go past 4. So it is currently court's on a short break. Live court is on a short break. It is currently 3:18. We know she doesn't like to go past 4. So far, this is fire. It's fire. It has to be so egregious in order to trump the 6th Amendment of a defendant's right to counsel of her choosing. Whatever the ethical violation is, has to be so egregious. And is it really so egregious that while he was prepping for the witness that he got an email the Sunday when he testified on the Monday, the outline that was provided by the witness and another email maybe wasn't turned over to the other side when all of this stuff was discussed during voir dire? I don't think so. I just don't think so. I just don't. She had to go get some Neosporin for their rashes. That's hilarious. Marie, this was a great comment. Thanks for your super chat. The best way to get a message across to a group is to first tell them what I'm going to say, then say it, and finally sum up what I said. Well done. That is the truth. Leslie the Annihilator. Thank you. Irish Wolfhound Mama. Thank you so much, Marie. It's Karen's birthday tomorrow. I feel Alessi's giving an early present to her, says Hannah Laura Willems. Thank you. Guys, Google the name, origin, meaning for Alessi. I think I put this up before. IW Law Poppy. Aussie Steve. I got my lighter out. Go Alessi, you're a legend. You're doing this for free. Bye-bye, Hanky and Bev. Free Karen Reed. She's already made up her mind, I think. I think this is a huge appellate issue. If she does revoke his pro hoc status, huge. Coach Mo says, beautiful smile, Melanie, and best day ever. Thank you. Great attorneys become great, not because of their power and prestige, but because of their ability to perform with integrity and preciseness and ability to present the facts with clarity. Thank you, Coach Mo, for the 20. Brennan is going to need a pillow to sit on after today, says Brian Miller. Thanks for your super chat. Auntie Bev's mugshot. Thanks for your 5. Maybe now she will step down. The receipts are there for the world to see how biased she is. Thank you. Greg coming in with a 5. Brennan can't win the case, so he needs Jackson Pro Hoc as a trophy just to come away with something. Interesting thought, Greg. Will Judge Bev spank Hank? Liz wants to know. I don't think so. Based on her questioning of Alessi, I don't think she is. And I'm floored by it. With all the shenanigans, tomfoolery, and ballyhoo that we have seen go on throughout the course of this case, starting on January 29th of 2022, when Michael Proctor knew he was going to pin it on the girl within 16 hours and was texting his buddies that night and called to tow that car before he even knew the condition of that taillight and then never took a picture of that taillight. The fix was in. The fix was in that day. Bev, put that on your red Solo cup and smoke it, says Nick Indy 78. Max Bang says the fear in this courtroom has shifted from the wrongly accused to those caught in corruption. Thank you, Max Bang, for your 10. Sherry says, is this a trap to get Bev to accuse if she throws AJ? They might make that motion again. It's definitely a good appellate issue. Ellen says, what a massive mistake to think AJ was their biggest problem. Enter Alessi, Bettero. Your problem is this ridiculous case, not the great lawyers litigating. Yes, well said. Well said. Dana says the bailiffs are distracting. They're in and out, passing notes to a man sitting behind the reeds on the side closest to the door and another guy in a suit lurking behind the door. I don't know. I didn't see any note passing, Dana. Thanks for pointing it out. I'll go back and look for it later. Bev's Bish Slap says, prayers for Karen. Alessi is fire. Thank you. I have grave concerns. Ha ha, says Moon Goddess. Freddie says Bev is corrupt. She's going to give Jackson the boot. That's the way it's looking to me. I don't know what Hank Brennan can possibly say to change her mind if her mind's already made up. Nightclub just jumped on. Why would she remove AJ? Because of these alleged misrepresentations to the court. I think I addressed this according to Hank wanted a mic drop moment. He just got it. St. Elmo's Fire says, I feel this argument will be used in first year's law school across the land. Way to prep. Yeah, way to prep. Bernie, I don't know why you were timed out. She says, I support your channel wholeheartedly. Always have timed out since lunch until now. I'm upset. Respectfully, Bernie, I don't know. Maybe the mods know. I don't time anybody out. AKA the cat lady. It might have been a mistake. Thanks for the 5. Could they appeal right away if she removes Jackson, or do they have to wait until the end of the trial? I think they could appeal right away. Remember, during the Delphi debacle, when Richard Allen's attorneys were removed, that appeal was heard. I don't know if it was before the trial, right? Was it before the trial? I think it was. Oh, yes, I think it was. So yes, my answer is yes. I think they could. It will delay it more. It certainly will not be heard on April 1st, this case, April Fool's Day. I think we need to send Hank some hydrogel bandages. Thank you, Glamasus, for your super chat. I appreciate you. What on earth can Hanky even say to this? I don't know, Jenna. I don't know. Vanessa, Judge Bev is relying on trial transcripts to understand what happened and ultimately assist her in making a decision, but the jury isn't allowed to for trial playback. Yeah, it is asked backwards. You're right. Great point. Thanks for the 10. Lindsay says the scale is so out of balance with Bev on the bench. Massachusetts Commission on Judicial Conduct. SOS, your assistance is needed. Stat. You ain't kidding. Well, they're still on break. So thank you to Susie for buying 5 matcha lattes. That is so very sweet of you, my dear. I appreciate you so much. Jen, thank you for buying me a matcha latte. Says keep up the good work. Well, thank all you guys for watching, because otherwise I would just be here screaming at the TV by myself. So it is very, very amazing to be with you. And also Tracy Walker bought 10 matcha lattes. Tracy, you're such a generous contributor to this channel. It has not gone unnoticed. Jamie, thank you very much for a very, very generous Venmo. Says, thank you, Melanie, for showing the world what classy looks like. Oh, that is so sweet. Thank you, Jamie, so much. I really, really, really appreciate it. I really appreciate it. We're on break. Angela, thank you. Says, awesome coverage on Venmo. Appreciate you. If you send a Venmo or a Cash App or buy me a coffee and you don't want me to say your name, just say Anon, please, before your comment. I'm happy to do that. And I do read questions that come through other channels, because if you don't know, you don't know, but YouTube takes 30% of super chats. So there are alternative ways to contribute to the channel. Connecticut Girl says Hank wants AJ gone because it will hurt Karen emotionally. That's a great point. Ina, what about Dr. Wolf's email regarding his testimony to AJ? Could let that out if you could leave that out if you want, etc. Yes, except that was brought out during direct examination. So it wasn't hidden. He did bring it out. He did not leave it out. So there's the prejudice, right? Jill says this has been absolutely riveting. Here they are. I'm going to need to leave in a few minutes to just make a quick bus run, but I will be back, so please never fear.
So before I hear from Commonwealth, Mr. Alessi, I am going to take you up on your offer to ask any questions, and I may have questions for both sides next week, but actually.
She's going to break for the day. Watch.
You said I could ask questions of other counsel. So while memories are fresh, I just want to assure the accuracy of what was just said. So I'm certainly not going to order counsel to answer my questions. You don't have to, but I am curious. So we're going to start with
Putting them on
the As an officer of the court, is there anything that you dispute that you just heard from Mr. Alessi? And what I'm particularly concerned about is what you knew or what you didn't know.
No, what he said was entirely accurate.
Okay. Mr. Jackson, same questions.
No, and I would simply elucidate with regard to the February 6th sidebar comment. As I look back at I didn't remember making the comment one way or the other. I didn't remember that sidebar.
I did.
I'm sure the court did after the transcript. I did as well after I looked at the transcript.
No.
Right. The context of that, what was in my brain when I said we don't have anything else to give, which when I reviewed the transcript, was very clearly the federal batch of information, what we refer to as the federal dump. I did not have in my head at all emails, communications, things of that nature, the small.
Invoices, payment.
No, nothing. Because the context of what Mr. Brennan was talking about, being frustrated about, were his TUI requests concerning the federal batch of information. And that's when I was making the additional statement. We don't have anything that they don't have concerning the federal information and the background information for the ARCCA experts. That was it.
Your Honor, if I could, this is. Nope, hold on.
No, I'm not going to let you
Ms.
speak,
Little,
Mr. Alessi.
It's just thrown on you that you're, that you're responsible for all discovery. But the same question, you, and again, you don't have to answer, but is there anything that you dispute in the accuracy of what Mr. Alessi told me about what you knew and what you didn't know and when?
No, Your Honor, I would just add that as soon as the court issued the order, I obviously was not in court that day, but as soon as the court issued the order that ARCCA reciprocal discovery be provided, I gathered those documents and I provided it. So that was the, I guess, prompt for going to look to see if we could satisfy the 10 things that were outlined by Mr. Brennan.
Okay, so I'm going to hear from the Commonwealth now. It does not look like we'll finish this today because we'll be ending around 4 o'clock.
What?
But I will hear
Ending at
you,
4.
Mr. Brennan.
So he's going to get a couple of minutes to talk. And I'm going to have to leave here. And I'll be back right around 4. So hang on for me because we got a lot to talk about.
Attorney Alessi ended his argument talking about the Sixth Amendment and discounting repeated or repetitive violations. When you consider the conduct of this case, you should consider the history of the case, including repetitive violations, week 1, 6 violations, protective order violations, and then discovery violations, representation violations. The defense in the first trial attempted and successfully did portray ARCCA witnesses as wholly independent, presented themselves as oblivious to the nuances of ARCCA, left the impression that there was no compensation, no bias, no collaboration.
There wasn't during that trial. It wasn't until after the trial was over. What part of that don't you understand? What part of that don't you understand? They drop mailed them a bill. They cold billed them. They didn't know the bill was coming. It was after the trial was over. You stupid ass.
In the second trial, and I'm going to get to the timing of that, but it ignores entirely withholding this information before the first trial. The defendant presumed innocent has a right to a fair trial, and so do the people of the Commonwealth.
Oh, the Commonwealth's fair trial. Here we go. I'm going to go. My head's going to pop off.
Posturing materials, that there was information that showed that ARCCA was not wholly independent. Information that was known to the defense, and for whatever reason, perhaps a strategic advantage was not provided to the Commonwealth, the court, nor the jury.
They didn't pay them any money. You asked them that.
Alessi talks about the Gonzalez case. In that case, there was one attorney to cross-examine a witness, which is protocol. Another attorney passed a note, a minor violation of a court procedure. That is like a raindrop in a hurricane. We
I'm
have
sorry, what?
a code of ethics and rules to ensure a fair trial for everyone.
You want to talk about ethics?
Coming in at the last hour and providing information when the avalanche started is not enough. This isn't just about Rule 14. My effort with the ARCCA witnesses from the beginning, and I've been clear and consistent, is not to preclude them. It is to get fair discovery that we're entitled to. I did not know before a few weeks ago what the defense had known. I did not know that there was conversations and efforts made between them and then inevitably compensation paid. I didn't know that, but I certainly suspected it.
There was no.
I saw Your Honor's questions before voir dire, during voir dire,
Agreed
after
to.
voir dire. I remember the conversations sidebar. And those questions were right to the point. And when we were sidebar, I specifically mentioned, I don't know about voir dire is
I'll be listening to this on my short car ride, but I'll be back real soon. So if you guys want to hang out and wait for me, if this, God forbid, ends, because we may need to rewind it and listen to this again before my head pops off, because yes, he's lying again. I'm just going to leave this up because I'm sure this will be accurate for the entire time that I'm shortly gone. But I'll be back. Never you fear. Melanie's here.
Inconsequential. I don't know what to ask. I can't send them back home to get their records or their emails or any billing. All of that was denounced. All of that was portrayed as baseless. But the court had questions. I had many of the same questions. It is not a surprise that we start to scratch off the tip of the iceberg. It is not complete. There is a murky relationship between the defense and the United States Attorney's Office relative to these ARCCA witnesses. And there is a very unclear relationship as we stand here right now between the history of interaction between the defense and these ARCCA witnesses. You can see from the emails, while there is some information provided, there are gaps. There are enormous gaps in time. The pause moment on March 24th and then reinitiating on May 5th, where ARCCA is actually billing the defense for their works before the voir dire. There had to have been communication between that time that rekindled this relationship. There are 2 requests that are mentioned in the emails. We didn't get all of those responses. And so we do not have an affidavit from either counsel or any of the counsels. We did not hear a word from any of them. According to Mr. Alessi, what you should do, what the court should do, is go to the federal government and ask
So
questions.
just to be clear, I am not having ex parte communications with anyone about this case. So I'm totally rejecting your request that I do that, Mr. Alessi.
It wasn't a request, Your Honor.
You suggested that I called.
No, I said if Your Honor wanted to do that. I didn't suggest that Your Honor.
I'll move on, but the point is, it is not incumbent on the court to provide the proof that the defense was given the opportunity to bring in today to clarify the record. Instead, it is the typical 101, blame everybody but themselves. There's no acknowledgement. There's no contrition. And there's no confidence that we are going to get all the materials that we're entitled to. To suggest that ARCCA's position did not change, it did change. Their opinions did change by the time they reached trial. It is not that the defense brought out that there was an expert in lighting or crashes happen at night. It is the bias, the relationship that is critical, and that was hidden from the court, the Commonwealth, and the jury. It is the bias and the leaning towards one side that was not disclosed. The first trial to disclose it last week or 10 days ago. So let me offer a quick history. It is true, when I first spoke to the court, I believed the documents provided by the federal government, and I did correct that record as soon as I learned before court ended for the day. January 30th, 2025, the United States Attorney's Office responded to one of my 2 requests. They provided billing, including ARCCA billing. There was billing for their reconstruction, but there was no billing provided for their preparation, voir dire preparation, travel expenses, trial testimony. That information was provided to both sides on January 30th, 2025. It seemed at that point that the federal government was being at least a little more responsive, although not correctly. No bills other than what the ARCCA experts did in putting together their demonstration and their accident reconstruction. February 11th, I filed on behalf of the Commonwealth a motion to exclude the ARCCA witnesses. On February 12th, the United States Attorney's Office gives us new emails. And those emails were between the defense and the United States Attorney's Office regarding their request to use ARCCA witnesses at trial. It's not a surprise that on February 13th, on the heels of these more productive disclosures by the federal government, we then received the disclosures from the defense, which are the emails regarding conversations between Attorney Jackson and Dr. Wolf, and the invoice for billing. Now, I did misspeak, I corrected it, but it is not the source of that information. It is the substance of that information which is critical and relevant. It is that information that should have been known to the court, the Commonwealth, and the jury at the first trial. And it is also that information when you compare it to the representations that have been made prior to trial by the defense that has import. Before, and I'm not going to belabor this and go through the comments, most of them again, but it is important before I get to the representations. The court does consider pro hoc vj. We have one licensed attorney in Massachusetts who's carrying 3 pro hoc vj attorneys with the request for a 4th to ride on that same license. There is a responsibility, respectfully, to Attorney Annetti, a fine attorney, an excellent attorney who I admire, but there's a responsibility so that there are not a number of pro hoc vj lawyers doing different things and then later plausible deniability. When we send emails, if I should miss one person on an email, I will receive an email telling me that make sure everybody gets every communication. I've been corrected or redirected many times when we've left somebody out on a communication. Pleadings are signed by all parties. They come through the bar card on that table. And so to try to parse or mince or put a slight on words to suggest that things are done independently and there's no responsibility for the defense when a representation is made that's inaccurate isn't enough. It doesn't assure that in the future it won't continue. Now, Mr. Alessi said there were rules of the road. This was before his time and mine, but I've read the discovery. There were no rules of the road. There was a protective order. And the protective order was clear that there was no discussion outside of court about the federal material. And there was nothing in the protective order or direction from the U.S. Attorney's Office that the Commonwealth had any right or privilege to contact any witnesses. Everything is done by the book, by regulation, through TUI requests.
So I have to say, I've never seen the protective order. I received a stack of discovery that the federal authorities were kind enough to get to me in advance of trial last time, because Mr. Jackson had told me he understood that I was operating from a place that I didn't have enough knowledge essentially of what was going on. So I received those 3,000 pages plus. I did not receive a protective order. I don't know that I'm entitled to it, but it would be helpful. I don't want to take it if I'm not entitled to it. I don't know what the parameters are.
Your Honor, we have a copy of the protective order. I did ask the counsel if there were any limitations to it, and I don't have a certain answer. What I'd like to do is
Call over
inquire.
there, please. Yes. All right, if I can have it, I'd like it. It would help guide me through this. If I can't have it, I'll just go with everything I've got.
May I have a moment to speak to counsel?
Sure.
Thank you, Ron.
I'll need to call the United States Attorney's Office and get an answer.
All right, I appreciate that. Sorry to interrupt.
And so the portrayal that there was a rules of the road, there was no such rules of the road. Neither Attorney Lally or McLaughlin ever contacted any witnesses directly because they understood that that was precluded. And so there was not an opportunity to call or discuss or have conversations, share direct examinations, or have emails with these witnesses. In fact, it's underscored, isn't it, by the emails that we received where Dr. Wolf replies on the 24th saying U.S. Attorney's Office essentially told them to hold off on communications. It doesn't seem like it would be a very clear rule of the road to have independent conversation with these witnesses and then be cautioned that that no longer was viable. And so inevitably, it was the understanding that nobody would be speaking to the witnesses. And I did see in the transcript, in the board here, where it was asked, were you available to the Commonwealth? And the witness said, yes. I don't know any basis whatsoever for the witness to suggest that there was any invitation to speak to them. And so what we have is we have witnesses that were wholly portrayed as independent. When we look at the testimony, it was represented many times in court, leaving the impression that the defense had no access and no special relationship with the ARCCA witnesses. On June 5th, 2024, day 26 of trial.
What date?
Day 26
You
of
know
trial.
that, but what date?
June 5th, 2024. Discussing scheduling and voir dire hearings. The defense said, I provided everything we have. I can't make up discovery. I mean, I got a report. And everybody in this group knows why I can't provide additional discovery for ARCCA. Everybody knows they've got what I've got. Your Honor asked, I haven't. If you can't, that's fine. So not everybody knows, and I make those decisions. Response, certainly. You're the one who needs to know, and I thought you knew. The federal authorities will not allow me to interview or ask for additional information from anybody in their world. So I have nothing. I've got a report. He's got the report. That's it. I'm going to start asking questions on the report. That's it. He can cross the report. So as many times as he says, I don't know what they're going to testify to. Yes, you do, because they're going to testify to the content of the report. And those are definitely questions I'm going to ask. So I've got clean hands.
All right, so you're reading from a transcript. As you know, there are dozens of transcripts. What's the volume number? There's day, I'm sorry. What's the volume number and the page number?
Day 26 of trial, page 248 to 250. I will get a volume number to the court.
That's okay.
This seems to directly contradict the theory that Attorney Alessi has been promoting today of the rules of the road. This does not suggest that ARCCA is open for business and private discussion and consultation and payment. It says the opposite. The federal authorities will not allow me to interview or ask for additional information from anybody in their world, so I have nothing. And so this presentation today by Attorney Alessi, suggesting somehow that this was open and notorious, is not backed up by the defense attorneys themselves. The June 10th hearing, we've already been through it. I won't repeat it, but those comments are important. I think what stands out about the prior hearings, and I say that I think that there's a murky relationship that we have not done more than scratch the surface of, is Your Honor may remember that the defense noticed 3 experts, including Mr. Klein. When we get to June 10th, Your Honor is asking, regarding the 3 experts from ARCCA, this is June 10th, 2024, trial transcript 28.
Hold on one second.
I believe it's page 12.
Okay.
And you were asking about the 3 experts from ARCCA. And you mentioned, notably, I can't tell who does what or what the basis of the opinion is. And when you look at the ARCCA report, there's no delineation on which of the 3 experts did what in that report. You can't tell what role each of them played from the report. And so if we only had the report, we wouldn't know which of those experts to call. And so when you continue questioning, you were told, well, you said, so I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand. And Mr. Yannetti said, that's essentially it. He gives some detail. As mentioned earlier, we've spoken to them only for purposes of coordinating their testimony and background. The important point for this particular point is that the defense inevitably calls 2 witnesses, Mr. Wolf and Mr. Rentschler. And when they only call Mr. Wolf and Mr. Rentschler, there must be a reason why. Because you can't tell from the report who did what. They noticed 3 experts. So there must be conversations with somebody explaining the witness's role or why only 2 of those 3 witnesses are important to the defense. And so it is clear from the absence of information, there are much more communications that are expected to be in existence that have not been provided. On June 18th, 2024, the voir dire hearing. The court asks, well, I thought that you would help.
I've got the transcript. What page you want? Do you know?
No, but I can.
If it's just your notes, that's okay.
I can pull it up. Page 4, line 11, the court asks, so the understanding of the voir dire is that this is for the Commonwealth's motion to exclude this testimony. All right, that's what we're here for, the Rule 14 violation. And Mr. Jackson says, is that the same with Dr. Wolf and Dr. Rensler? And the court says, well, I thought that would help both of you. The Commonwealth has nothing on that, and you say you haven't been able to even talk to them at all about this case. And the answer is that's correct.
My head has popped off. There's blood everywhere. It's like a Monty Python movie.
Refraining from my opinion and characterizations. Unlike the defense, I think that the transcript speaks for itself. I'll let it speak for itself. When we continue in the voir dire hearing, page 71.
Okay.
Line 4, importantly, were you hired by the defense in this case? No, sir. Before this morning, when you walked into court, had you and I ever met face to face? No.
There's Kelly. Kelly's not happy. Kelly Reed is not happy. This guy is lying through his teeth, and it's only a flesh wound. It's only a flesh wound.
No, sir. Now, this illustrates an important point. That is technically true. But what impression is that making to the court and to the Commonwealth? Is that a genuine impression consistent with reality? Line 20,
You're the one who needs
person
to
to my
find
left,
reality,
this-
sir.
the female to my left sitting here, have you ever seen her before? Nope. Do you know who she is? Yes. And so there is direct and indirect commentary, questions, presentations that reinforce that the defense and ARCCA are wholly independent from each other.
Because the witness knows who Karen Reed is, because he knows what trial he's testifying at, and because it is worldwide news at this point. Are you kidding me?
This is also consistent with their representations regarding payment. There are questions, voir dire, and at trial, about whether or not the witnesses were ever paid. It may be technically true they were not paid at the time they were asked the questions, but if there is an expectation of payment, it is a promise, reward, and inducement. It can show bias. There's nothing wrong with paying an expert. There's nothing wrong with going over a direct examination with an expert. There is nothing wrong with talking about particular questions with an expert. But when these experts are being portrayed a certain way, that they're independent, that there is no evidence, information about them.
They're independent because they already came to their opinions and conclusions before having any contact with the defense, and they did not change their impressions or opinions or conclusions at any point. Jackhole.
It's not a fair representation. It is not an honest representation.
You want to talk about honest?
Now, it wasn't until Your Honor asked today that we even knew that the defense paid this bill.
Call them in. Call in the ARCCA guys. Ask them if they ever discussed payment before they drop mailed them that invoice.
When you look at the bill, there's some things that stand out. There's a tax ID number, an invoice dated July 12, 2024. Addressed to.
Oh, now you know the date of the bill. Now you know the date of the bill. Now you know that the bill was dated July 12th of 2024, after 12 days after the trial was over. Now you know the date of the bill, sir.
Okay.
It's addressed to Attorney Jackson, and the position that the defense takes, Attorney Alessi takes today, is this came out of the blue that they had to pay. Apparently, everybody in the know knew the defense was paying for this expert, other than the defense. ARCCA experts knew. Dr. Wolf knew. Dr. Rentschler apparently knew. The federal government knew. When you look at the bill, there are things that stand out that are so notable that you can't go back and try to twist them or change them. Look at the first entry of May 1st, 2024. That is before June 10th. That is before the representations that there was no intention of compensation. Apparently, the witnesses they were going to call expected that they were going to be paid by the defense, or they wouldn't have been keeping track of their time back on May 1st, 2024.
They knew somebody was going to pay them, Hank. Somebody was going to pay them. Of course they keep track of their time. Every expert witness, every person who gets paid by the hour, every attorney who gets paid by the hour keeps track of their time. It's called timesheets. Everybody does it, including you at your $250 an hour.
Telephone call with Alan Jackson. And so the March 20th email asking for an engagement letter and a retainer. And then the 24th saying we need to take a step back because of the U.S. Attorney's Office.
22nd.
Now he's accusing them of lying again.
Obviously more communications because the relationship re-engages at least on or before May 1st, 2024.
He's allowed to speculate.
This is understand.
Okay, got it.
That they're going to be paid by the defense.
Rules for thee, but not for me. You could speculate all you want, Mr. Brennan, Mr. Brennan, whatever you're calling yourself today. Go right on about with your bad self. You're allowed to speculate. I'm not going to stop you.
And as I mentioned, the materials we got from the United States Attorney's Office on February 12th, there is no billing related to prep for voir dire, travel, trial, none. So the only people who were surprised that they were paying the witnesses apparently was the defense themselves. And then before that June 10th hearing, where the representations were made, there's a June 9, 2024 phone call. Another participated in telephone call with Alan. And then we see before the voir dire testimony, there is billing to the defense, which is now we know paid by the defense, prepared for voir dire testimony, June 17, 2024. What we don't know is, in the preparation, was there any conversation with the defense? Was there any emails? Were there any documents? Were there any outlines? Was there any discussion about the potential testimony, or is this solely the preparation of Dr. Rentschler?
Well, since you're going over his itemized bill, it would say that in there because it seems like they keep pretty good billing records, right?
On his own. On the same date, 3 hours billed by Dr. Wolf, prepared for testimony and hearing. Now, they felt inclined and comfortable billing the defense for. Was there any interaction or discussion between the parties? We don't know. This was the
It would be on the
time
bill.
that the court gave the defense an opportunity to bring in their product, their receipts, the emails, to elucidate, illustrate, demonstrate, prove what the relationship was. We don't have anything. We have nothing more than we did last week. On June 18, 2024, a round trip to Norfolk Superior Court by Dr. Rentschler, and also separately for his testimony, 8 hours billed, 12 hours for Dr. Wolf billed to the defense. June 21st, Dr. Rentschler prepares for his trial testimony, bills the defense, 5 hours. Again, we have no idea if that includes in any way.
Again, he was keeping track of his time. He didn't know who he was going to bill until after the trial was over. He kept track of his time. The bill was dated July 12th, which is after the trial was already over, and it's itemized accordingly.
Correspondence, communication, interaction with the defense. June 21st, Dr. Wolf, the same, prepares for trial, 6 hours. June 23rd, Dr. Wolf travels to Boston for trial, significant delays, and then Dr. Rentschler on the 24th, round trip, Norfolk Superior Court, 11 hours, 6.5 hours respectively, billed to the defense. Now, it's hard to believe these witnesses would put forward money and expenses and travel without some understanding that they were going to get paid. It is hard to believe this company, especially after receiving an email about engagement and retainer, especially after having conversations, collaborating on their potential testimony.
Collaborating.
It's hard to believe that they would come to Boston, spend their time and their own money to do this, to just simply send a bill later with no expectation of being paid. In fact, it's a very specific accounting of their time. And when one accounts for their time, it's because they need to have a contemporaneous record so they can get paid for that time.
Here's the thing, Hanky. The federal contract didn't expire till July 31st, 2024, because I looked it up. And you know how I know that, Hanky? Is because you have it in your motion papers. They were under contract with the federal government until July 31st of 2024. So somebody was going to pay it.
Also billing for wait time and travel, testimony at trial on June 24th, and then there's expenses for June 18th and June 24th. Specific expenses, $1,749, $1,932. So they are keeping very careful track of the bill that they send within 1 month of the defense that gets paid that Commonwealth and the court never knows about. Talking about correcting a record. And so this $23,925, we find out today, it was paid by the defense. We hear that there was a conversation with the federal government. We have no affidavit, we have no witness. We have no writing, no email, no correspondence, nothing to support.
She's not shaking now.
Or put in context the conversation, nothing. Nothing. And so when you look at the story on this bill and the timing of it and the details of it, we know that we are getting a fraction of the story.
No, not really.
It's not enough to blame the court, blame the Commonwealth, blame the U.S. Attorney's Office. There's some accountability.
They can't object really, but they could if they wanted to, but they're going to get a chance to respond to this, I would imagine.
Representations made in court. We also, at some point, are going to address the Commonwealth position of violations of 3.6. That's the motion. It's interesting that after the last court hearing, well-known reporter, very reputable reporter, Christine Rex asks.
Oh, she's so reputable. She's sitting right there. Look, here she is.
What I suggest more 3.6 activity. Quote, no, of course not. That was the position last week.
Wait, Christina Rex said what? Hold on. Oh, she asked Mr. Jackson if he paid a bill. And Mr. Jackson said to Christina Rex, no, of course not. Okay, now he's going to bring Christina Rex into it. Hold on a second. Listen.
Reporter Christine Rex asks, it's interesting that after the last court hearing, well-known reporter, very reputable reporter Christine Rex asks Mr. Jackson about paying the bill. And what I suggest more 3.6 activity, quote, no, of course not. That was the position last week.
What was the exact question from Christina Rex? Did you pay for their testimony? Put her up on the stand. She's in the courtroom. Put her up on the stand.
So what we're left with is we still don't know the relationship between the defense and ARCCA. We don't know about the impact it had on the first trial. There has been these
during
multiple
trial?
representations that ARCCA was independent. They had their opinions and they were exculpatory. ARCCA's opinions changed. There were 4 opinions. And if you look at the report, and I'm not going to read it for the sake of the press and the public, we'll have a trial and we'll edit that trial. But when you read the report, clearly the representations made about that report were extended at that trial. And the question is going to be, why? Why did they improve? Why did they?
Particular page you'd like to without site.
Oh, it's 4:04. Look at her going overtime.
If you look at the first page.
Yes.
Yeah,
You don't have to read any of it. You just tell me the paragraph.
Yeah, I think it's just the first paragraph that lays out their findings.
Thank you very much.
Well, thank you, Ms. McLaughlin, for chiming in for the first time ever. Second time today, though. A lie unchecked becomes the truth.
And actually, particularly note number 4, and both publicly, repetitively, but also at trial.
This will not be done today.
The parameters of that were extended substantially. There is a summary again.
The camera doesn't mind focusing on Karen and zooming in on her private conversations with her attorneys, but you know.
At the end of that report, substantially says the same thing. If you look at the last page.
I don't think we're behind on live
signed
court.
By all 3 of the experts, Mr. Wolf, Mr. Renshaw, and Mr. Klein, says essentially the same thing. So we'd be oblivious if we stood there
Like
and said
30
that
seconds, maybe?
the relationship between the defense and the experts, there's no relevance to bias or motive or desire to please, because clearly there is change, there's an expectation of payment, there's communication, and to suggest that an outline was provided so close to the testimony, therefore it shouldn't have been shared, it isn't just what's in that outline, it's the fact that they have the relationship. Attorney Jackson may have brought out that accidents happen often at night. It's not the point. The point that the ARCCA witness is willing to forego that information as a benefit to the defense. That is the heart of what is missing and what is hidden. And so there are a number of instances, 3 of them, in the outline where the ARCCA clearly is trying to accommodate the defense. And by representing to the court that there is no relationship, the hands are clean, they have no information, is not only not accurate, it is misleading and unfair. So we know there is more. The question is, will we get it before trial? I have another TUI letter going out this week. I don't know how long it will take to respond to it, and the TUI letter is not going to be thorough and complete. It's just not the way TUI works. And so we are in the same spot. Well, actually, we're in a better spot. We know now about the relationship. We know about potential bias. We know about the payments, but we don't know the full scope of it. And so we are entitled to that information. We don't know what conversations, communications the defense had with the ARCCA experts that the federal government doesn't know about.
Well, they just got up and told you.
Over the next few weeks, we're going to attempt to get more.
So now you're accusing them of even lying during this hearing too? Okay, let's see how this is going to go.
We will never have an accurate accounting unless it's compelled.
Gaslighting by Hank, courtesy of.
Your Honor's mentioned the sidebar.
Nothing severe.
The most recent one.
Okay.
Christina Rex is a reporter, a local reporter.
Overly critical of another attorney. I'm not.
Oh, you're not trying to be overly critical of another attorney? Really? That might be the funniest thing you've said all day. That might be the biggest lie of all.
It has been my effort to get Rule 14 material. It has been my effort not to exclude ARCCA witnesses. It has been my effort to try to achieve fair play. There's been no other way to compel any information other than to file motions in this case. And it is not incumbent on the government to fight for this information. We're entitled to it. We're entitled to it. And at this point, we have no confidence whatsoever, none, that we're going to receive the information that we deserve.
Oh, and he's done? He's done for the day?
Thank you. Mr. Alessi, very briefly, if you have something.
Yes, thank you, Your Honor. I'll be very brief. And I hope we get an opportunity to have one wholesome response, but I'm going to be very. Attorney Brennan focused a lot on the invoice. As I said, I work with experts all the time. The experts keep track of time. They had historically been paid by the government. There's another completely rational, more probable explanation that they have been retained by the government. They were being paid by the government. They maybe at a certain point didn't know who was going to pay their bills because they turned out they were going to be providing testimony. That is a whole different issue, what they expected to be paid and by whom from what the defense expected. So two things can be true. It can be at some point they thought they were going to get paid, but up to that point they were being paid by the government. And the entries, all that Mr. Brennan went through, particularly the early ones, there is zero evidence before the court on any basis that they expected on those dates of those entries that they were going to be paid by the defense. And it's very important because Attorney Brennan spent most of his time on that invoice. With regard to the comment he made, and this is the problem when we don't have notice, like I provided a notebook so everybody could see it. We don't have some of the things that Mr. Brennan was referring to.
No.
But he referred to all things, Mr. Jackson's response to a reporter. We're here talking about communications to the court.
Right.
But to be clear, the reporter asked, did you pay for testimony?
Thank you.
Did you pay for
Lied
testimony?
again,
Mr.
Your
Jackson,
Honor.
the court said, no, I paid for their time.
Did he say I paid for their time?
Pardon me?
Did he say I paid for their time?
No.
Mr. Jackson?
He just said, no, of course not.
Of course not. Did you pay these witnesses for their testimony? And I said, of course not. If the court were to ask me that question today, I would respond exactly the same way.
All right, so you just told that I paid for their time. That
No,
was not said, right?
That was not said, but I'm saying there's always some inference.
Oh, so you'll call him
about
out
these
in a
things
lie.
said that
You
was said, but-
stop what you're doing to call Alessi out in a lie, but you don't call Brennan out in any of the lies that he's ever told you ever in court. Are you kidding me?
That was his response, that was it. But it was the premise of Attorney Brennan was what Mr. Jackson said to the reporter was different from what you've heard in court today. And it wasn't. It's important to be accurate. The other things that I'm going to go through quickly is it kept stating that there had to be a belief that they were going to be paid by the defense. There is no evidence whatsoever for that because it didn't exist.
Right.
So now with regard quickly again to the other topics, Attorney Brennan talked about 3 witnesses, right? And he said he was, I believe I took it as clearly inferring 3 ARCCA. Your Honor can go back to the transcript. It was Dr. Russell was the 3rd one.
Oh, I thought it was the 3 ARCCA people. I
Yep.
will go back to the transcript.
Yes,
You can
please
go back
do.
to the transcript. Earlier on, there was a discussion, way early on.
Who is Mr. Klein?
He was a 3rd ARCCA expert.
Wait, I thought it was Von E. Who was Von E?
Involved for the government, right? And then he stopped, and we didn't retain him for testimony.
Okay.
And let me be clear on what I mean by retain. He didn't testify.
It's been a long day.
I understand. I'm trying to
Oh, I'm
answer
so
your
sorry that
question.
you're tired, Your Honor. But there's a woman on trial for murder, and you're trying to get rid of one of her attorneys. And I'm so sorry that it's been a long day and you're tired, but I don't really give a duck right now. Do you? Listen to that again. It's been a long day. Give me some sigh emojis in the chat, please.
Okay.
And let me be clear on what I mean by retain. He didn't testify.
It's been a long day.
I understand. I'm trying to answer your question, Your Honor.
I know, and I realize that you just said something that you want to explain. Go ahead and explain.
Right. So what I'm saying is, in terms of, I'm going to take back the retain. The point is, there were originally 3 ARCCA persons on the report that we got from the government, right? Rentschler Wolf, and Klein. We only went forward with the testimony of Rentschler and Wolf. And that's what I want to come to, Your Honor. The whole emphasis was that the Commonwealth had no notice that we were going to use these experts. Your Honor, the voir dire was the notice. And my point was, I didn't say that there was no bias. What I said was, once you decide you're going to use an expert, right, you're going to be having them testify. Anybody could claim that that testimony is biased. But the point is, Your Honor, that the allegation that somehow mysteriously this third person that was being discussed, and clearly the inference was that we were misrepresenting still about which ARCCA witnesses, because we weren't talking about the third. The third was Dr. Russell, and you'll see that in the transcript.
Okay, but when I said you expect something, whatever I said, you expect me to believe that you are calling 3 witnesses whom you've never spoken to. When I had that discussion with Ms. Giannetti, that's what I meant.
They hadn't spoken. There was an email and another email.
That was just ARCCA. That was nothing to do with Dr. Russell. But here's the important part. Attorney Brennan didn't read the rest of it. You're to believe.
Okay, so where are we? Are we the June 10th?
Yes, please, Your Honor. June 10th. That's exactly right. That's exactly right. It was June 10th. It's important. He stopped on
page 12.
Yes, thank you. So on June 10th, so you're to believe, this is line 19. So I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. Here's the response, and it's total. That's essentially it. We've spoken to them. So it's not like it wasn't disclosed there was a conversation.
Right.
It was. We've spoken to them only for the purposes of coordination of their testimony and their background.
Thank you.
We've not been able to interview them regarding their findings, which are outlined in detail in the reports. Your Honor, that's 100% true, because I
read that earlier.
Right, but
he's making a
Brennan
point.
Just mischaracterized it again, because that is 100% true. He made it seem like that was an untruthful statement, and I know Your Honor gets it. The other last 2 points, Your Honor. Attorney Brennan talked about that the ARCCA experts improved their testimony. My point, Your Honor, was their opinions never changed. Whether they improved is a characterization, but their opinions did not change. And that is very important. And the last point, Your Honor, goes to the discussion that Your Honor was having with the questioning of Ms. Little, Mr. Jackson. I want to be very clear on February 6th, and this is going to be my very last point. When Your Honor asked the questions on February 6th, and Mr. Jackson responded about the discovery, and I said to you that Ms. Little was the one handling the discovery. And I spoke with Ms. Little and I spoke with Mr. Jackson, and they're going to be completely available for any questions that follow up on this. I asked Ms. Little during the break. She wasn't here for that February 6th. She obviously didn't hear the sidebar. But I said, when you learned of what the Judge Cannone was asking about, I said, in your head, what was going on and what came to your head? Because I said Mr. Jackson didn't make any knowing misstatement because he had no recollection of any of those March emails. So I asked Ms. Little, who would, between the two of them, would, if there was any recollection. So during the break, I asked Ms. Little, I said, Ms. Little, when you heard, and got the order, because that's the first she knew of the inquiry, she gets the order, I said, when you got that and you saw that you had to turn over discovery, when you read that, did it come to your mind? Did it come to your mind that there are these March emails? And she said, no, I didn't recall them. I didn't remember their existence. And what I did was I knew we had to turn over discovery. I then went back, I rediscovered those emails, and that's how I had recalled it. That is important, Your Honor, because there has to be a knowing misstatement of fact for 3.3A. So not only did Mr. Jackson not know at the time Mr. Jackson made those statements and recalled those emails, neither did Ms. Little, who was the keeper of all the discovery. And that is my last point, and I will conclude this way, Your Honor. Attorney Brennan conflated Rule 14 issues with the 3.3A1 issues. They are completely separate. I am not here today, Your Honor, to take the position that the defense is in perfect compliance with Rule 14. We're not. But that's a whole different question, from whether the attorneys are in compliance with 3.3A.
Yep.
And I would urge Your Honor, as I know you will, to keep those distinctions as we go through the matter, because conflating them is not proper for the analysis. And my last is a citation of law, Your Honor. It was said that Gonzalez involved a very minor issue. Attorney Brennan is correct. There was a minor issue in Gonzalez, but the Supreme Court went through those things that could rise to it. And I'm going to give you another cite, Your Honor, which is United States versus Diazzi, that involved a lot of serious issues with regard to conduct of counsel. They were not pro hoc vice, but it's 807 Fed 2nd 12 First Circuit 1986, where Your Honor can read it as to what were happening. The attorney's conduct was deplorable, and yet the court held that you could not disqualify them because of the Sixth Amendment. And my last point, Your Honor, is when you do a Sixth Amendment analysis, whether or not the attorney at issue is pro hoc vice or not, is not weighty in the determination of balancing the Sixth Amendment. It is not. In the abstract, Your Honor, in civil cases, is it easier to knock out a pro hoc vice? That would be absolutely correct. But when it comes to a criminal case where a defendant, their choice of counsel, that is a much different analysis with the Sixth Amendment. So I will stop there, Your Honor, because you said it'd be brief. There would be more I would have to say, but those are the highlights for the moment.
Anything, Mr. Brennan?
Very briefly.
Oh, of course, very briefly. I throw this at the TV. I mean the screen over here.
My arguments to the court have always been focused on Rule 14. The verbal gymnastics that counsel engages in to use words like misrepresentation to distort reality is extraordinary. So let's use the defense words themselves. If you look at docket 505, which was signed in a pleading.
That was filed late, right? The
February
first Saturday or something.
February 16, 2025. This sums it up, really. And this is signed by Attorney Jackson, Attorney Alessi, Attorney Manetti.
Alessi. Notice how he keeps calling him Alessi. We all know his name is Alessi, but not him. He keeps calling him Alessi. And it's like Khaleesi. It's reminding me of Game of Thrones. Alessi Khaleesi. He is a dragon, and you should be afraid.
Was it signed by Ms. Little? It's not.
Ms. Little has only done the certificate of
Authored
service.
by- Okay.
She did not sign it. It was signed by Attorney Jackson, Alessi, and Manetti. And this is the defendant, Karen Reed's opposition to Commonwealth's motion to exclude employees of ARCCA LLC. And here's the representation they made. Not my words, not a misstatement, not a distortion. This is their words. Now comes the defendant, Karen Reed, Ms. Reed, and respectfully request that this honorable court deny the Commonwealth's motion to exclude the expert testimony of employees of ARCCA LLC named Daniel Wolf, PhD, and Andrew Lenchler, PhD. Here's the important part. The Commonwealth's motion to exclude these exculpatory expert witnesses who were not hired or paid for by the defense is not made in good faith and is a desperate, transparent attempt to keep exculpatory testimony of neutral expert witnesses from reaching the jury.
The sighing.
I know Attorney Alessi no longer likes the word retain, but that retain word I was in for it. There's a reason he said it. Their words, their motion. This is no different than the tone of representations made February, last June, May, and before. Thank you.
All right. So we're back here next week. I believe we're back here Tuesday, Wednesday, and perhaps Friday. Is that accurate?
Your Honor, may I speak to Wednesday, please?
That's what I have on my calendar. Tuesday, Wednesday, Friday.
As this court may know,
Mr. Jackson, myself, and Attorney Weinberg are scheduled to appear before the federal court
What
at
time?
9:30 in the morning.
Okay.
Could we possibly go there and then
Yes,
come here immediately afterwards?
sure,
Thank you, Your Honor.
sure. All right, but we'll see you here, Jim. We have these all scheduled at 9.
We do.
Okay. All right, so we'll see everybody here Tuesday at 9. We've blocked off the day for Tuesday, Wednesday, and of course I'll let you go to federal court first, and also Friday. All right, so see you next week.
Alessi is a New York attorney. Somebody asked if he's from Massachusetts. I just want to see the walk out here. See if anybody has anything to say. Any pats on the back. Paul's going to stop and say, "We're not done with you yet," like he did after one of the first trials. After the mistrial was declared, right? Yeah, we have court 3 days next week: Tuesday, Wednesday, Friday. Okay, why don't you guys zoom in on Alan Jackson? He looks happy. He doesn't look worried. And let's just listen to their conversations on the hot mic. Federal court is for the habeas petition. I don't think it's an argument. I think it is just a conference. And there's Brennan pushing up his glasses, and that's it. Wow, just wow. I missed a little bit of it because I was in the car and it wouldn't play. But I think I got the grift of it, the drift of it, the grift of it. And I think that Hank Brennan is an abomination. I'm going to go to the chat. Rich Schiffer is here. That is our rubber ducky guy. Well, congratulations on all of your charges being dismissed for your alleged witness intimidation by putting little rubber duckies around town. Superman Alessi, he says, thank you for your super chat. Paulina, that was unbelievable. There's nothing better to cover the removal of the lead investigator is to remove the lead attorney. Yeah. What a circus. Well, yeah, you're right. And that's what they want. I don't think they care about ARCCA. He said a million times, we don't care about ARCCA. They want to get rid of Alan Jackson. They just want to get rid of Alan Jackson. Hang on. I have to start here at the beginning. Procott says, I hope Karen's correct about the feds. If so, it is terrible that this got reported. Is it possible there are multiple investigations going on at the same time? Anything is possible. Anything is possible. I don't know the truth. I'm not privy to inside information. And so I don't know whether or not the federal investigation into the investigation of the murder of John O'Keefe is concluded or not. But she did say that to a reporter outside of court. Anomaly said, I love her even though I'm not gay. Not that there's anything wrong with that. And I always love a good Seinfeld reference. So thank you so very much for that. Danielle says, is this line of questioning from the judge normally, meaning she was asking them questions during the hearing? Yes. Yes, she can. She can ask questions. Have we seen her do this before specifically? I don't recall, but I think she has. So yeah, it's not completely out of the ordinary. Michelle says, have you ever seen a judge in your 30 plus years of practicing take so many breaks to get caught up on rulings and arguments like this? Yes. 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 We watch a lot of trials. There are some judges who never take a break and some judges who take a lot of breaks. She takes a lot of breaks, but it's 4:26. So she did work an extra 20 or so minutes past the 4 o'clock hour. So there's that. Greg says, in your career, have you ever seen a defense build an appellate case this strong? I didn't follow Delphi, so I don't know about that case. Well, nobody could watch the Delphi trial unless you were actually in the courtroom. There are many cases with many appellate issues that are very, very strong. So, could I think of one at the top of my head? No. But is it that unusual? No. But nothing in this case is normal. Nothing is normal. Right is left, left is right. Inverted is normal, but it's just a mirror image, but it's a fair and accurate representation of the Sally Port. But really, it's like you're looking in a mirror, and so things are flipped, but it's really accurate about what happened in there. That nothing is the way it should be. Am I right side up or upside down? I don't know anymore. I really don't know. Sandy B, so many appealable bases. What is wrong with the Commonwealth judicial system that they let this happen? They want this to happen. They don't want you to know the truth. They're not looking for justice. They're looking for a conviction. Come hell or high water, they want the conviction, because if they were looking for the truth, they wouldn't be fighting about the ARCCA experts. Is what Alan Jackson is accused of doing so egregious that he should be removed from the case? I don't think so. I don't have any idea what the judge is going to do, but it sounded to me like she'd already made up her mind that he's going and she's not going to stop it, that she's going to make it happen. That's my opinion. I don't know for sure, but she's already made up her mind. Is a really great tune that's going on my Karen Reed playlist for all of you. Oh, sweetie, no, says Christina Rex asked AJ if he paid ARCCA experts to testify at the first trial. AJ replied, no, of course not. No, thank you for pulling that up and listening. Lamassus repeats the same. Christina's question, did you pay ARCCA experts to testify in the first trial? Alan said, of course not. Hard plastic and static mannequin. Thank you, Adam Handful. Once again, she allows them to get off speculating and leave it unchecked for another week. Bev in her hair makes me sick. It is another week. Today's Tuesday. We're coming back next Tuesday. Will we see the motion to dismiss for egregious extraordinary governmental misconduct before that? I don't know. I know it was filed on Friday. We know that. Storm Dancer, there are worse things than changing an opinion, like perjury and covering for each other to cover a crime. Well done. Thank you so much. Edward says defense needs a motion for sanctions. Brennan's is going over the line again and again and again. He shows no signs of stopping. Nope. Kim, thanks for your super chat. Just like it's been a long day for Judge Bev. It's been a long ass case for these lawyers. She can't keep up for a day, but expects the defense to keep up with everything, email, etc. for 3 years. Well, and also she didn't start until 11, took an hour for lunch, and then went until 4:30. So really, how long was it? Did you hear anything about the federal case being over by Hank? No, you're right. Wasn't that that was going to be the big reveal today. It was going to be the big reveal. Move that bus. Remember that TV show where they remake somebody's home? They remodel their home for them. And at the end, they put a bus in front of it and they say, move that bus. That was the big reveal. Ted Daniels stole his thunder yesterday when he reported on it at Boston 25, saying that Hank Brennan is going to reveal this in court tomorrow. He was going to announce it. Well, no, he didn't. He didn't announce it. Thank you, Marie, for your Venmo. She says, I laughed when you said, hey, Paul. Hysterical. You're very funny. Thank you. Thank you. Shannon says, love me. Thank you for your Venmo. Allie says, never thought I'd ever say the words, I miss Lally. I know, we were saying that yesterday. Thoughts, the most egregious thing that you heard come out of Hank Brennan's mouth, because I missed a little bit of it when I was in the car because it wouldn't play. So tell me what you thinks. Tell me what you guys think was the most egregious thing to come out of Hank Brennan's mouth today. There's no way in hell this case is going ahead on April 1st, in my opinion. They zoomed in on Karen's phone. Not the first time they've done that. They've done it before and they were warned. They were warned not to do it in the last trial. We have to laugh or else it's insanity. I know. Sue says Alan Jackson has been admitted pro hac vice in the Massachusetts Federal District Court for Karen. March 5th is a hearing. Commonwealth response is due tomorrow. Well, it's not really the Commonwealth, though. It's Norfolk Superior Court is being sued in that proceeding. And I think the U.S. Attorney's Office of the Attorney General. So again, whoever the defendants are in that case, the respondents, their response is due tomorrow. Karen's response to that is due on Friday. Thank you for forwarding the documents. I appreciate you so very much. What a day. What a day. And it's not over yet. So we don't know. Decline. What is your professional opinion on Alan Jackson? I don't think he did anything that is so egregious that he should have his status pulled. I know what Bev wants to do. Does she have a legal reason to get rid of him? This is the distinction. Is it a discovery violation, what he did, or is it an ethical violation? Was there any real prejudice to the Commonwealth that he didn't turn over the introductory email from March And the response from Dr. Wolf, that was the pause email. Was it substantive? They had a voir dire. They were able to ask them all of the questions that they wanted to ask them. I have to go back and listen to the itemized billing again, because that bill was itemized. But again, they said it was sent to them out of the blue. Out of the blue. They didn't know this bill was coming. They picked up the phone. They called someone at the US Attorney's office. They said his name. His name is something like Deach. And they said to the judge, I suggest that you call him. Please call him. Please call him. What happens if she does get rid of him? Nothing. They proceed without him. The defense will proceed without him. But you have to balance her right to the attorney of her choice under the Sixth Amendment to be represented by the attorney of her choice with the prejudice to the Commonwealth. Was there any? Again, here we go again. It's like the inverted Sallyport video and all that other stuff. Hang on one second. Hold for a sec. See if Tom is outside the courthouse, if he got the chance to talk to anybody. I don't know if you guys. Anybody know if he's spoken to anybody? They'll appeal. If he is removed by this judge, they will appeal. They will appeal. It will likely stay the case until the appeal is heard. Yes, I imagine it will be appealed. It happened in Delphi, but again, we're in two different jurisdictions. So I do think they will appeal, and I do think that will stay the case until the appeal is heard. I don't know 100% if it would stay the case, but I imagine that it would, because that's the way it should be done. Let me fast forwarding Tom's stream. I don't think anybody has come out. Oh, here they come. Okay. Let's just see the walkout.
Karen, what are your thoughts on the federal investigation?
I'll give it to her if you want, but you gotta get the David, you're
If I'm wrong,
line from the attorney. How do you get a pan out?
I'm very proud of our case here. Very proud of her.
Do you feel confident that Al will stay on the case?
I do.
Thank you. Do you have any comment on the federal investigation ending?
I do not.
You opened up my eyes so much.
Any comment on the federal investigation ending? Oh, wait, this is the earlier
Morning.
one. Hold on.
Job and stuff.
Very proud of her.
Do you feel confident that Al will stay on the case?
I do.
Thank you. Do you have any comment on the federal investigation ending?
I do not.
You opened up my eyes so much that I can hear. My name's Cindy. Oh, you're
Karen, do you think your Sixth Amendment rights will be preserved here?
Back up, guys. Come on.
Should be.
Come on, boys. Back up. We got some room. Yeah. Come on. Let's go.
I hope
Come on.
Jonathan.
Media, let's go.
Are you worried that your defense will be removed?
Are you worried that your
Of
defense
course,
will
I'd be
what?
worried to lose any member of my defense team.
What would that mean?
It would mean an appeal.
Yep. The appeal's already being drafted, I think, says Fire on Acid. It's already in the works.
Yeah.
A lot of media there today.
Yeah,
Look at all
yeah,
that.
yeah.
Honey.
I think Tom CPU brought roses for the supporters and for Karen today. Thank you, Scott, for letting me know that. That was very sweet of him.
prosecution.
Oh, he actually bought
Not at
50
all.
roses
These lawyers, Jackson.
to give to
and Eddie
supporters.
Little, Attorney Alessi, they're men of integrity, men of honor. They have a North Star, they have a compass. And they've been so successful because they operate by guidelines and according to rules. They're men of ethics, men of character. So they're no different than my daughter. They know the truth. All right? Science, physics doesn't lie. All right? John
Aaron just
O'Keefe
said they
was
would
not
appeal.
hit by that car. Those injuries that he suffered were not
I know.
sustained by that vehicle.
You were feeling encouraged today or discouraged after everything you said?
When you've got a team like this, and when you've got the truth, when you're dealing with the truth, there's no recollection as to what was said, what wasn't said, what was overlooked. When you know the truth, it's just so weird for me. And these people, the people who are out here with us day in and day out, who are fighting for justice, they see it, they're disturbed by it, and they're looking to make a change, and they will make a change. I listened to a report earlier today. What you see here in Massachusetts is a result of a generally one political party rule. And we've seen changes of that come about just this last presidential election. We have seen areas of this state that were predominantly Democratic for years have turned. And what you have here in this state, and the reluctance of political leaders to put their foot down and step and make a statement about the wrong that's going on and continues to be perpetrated on Karen Reed, our daughter, and my family, and on the public, wasteful resources, is because people are simply of the same party will not break rank. So I'm telling you all, how you do this is you make change. You get out and you vote. And you vote for change and you vote for political parties. Different parties should have a balance of interest. That's important, right? So that you have different opinions, two political parties. That's a state that's purple, not red, not blue, but purple. I gotta go.
There you go. Amen. Thank God.
Mr. Reed is on fire. So apparently Tom CPU brought 50 roses for the supporters to give to Karen for her birthday tomorrow. She's not turning 50, is she? Bettero has been tweeting calming thoughts. Good speech, good speech. I guess they're done with their arguments. Is she going to have her decision ready by next Tuesday? It's going to be interesting. It's going to be interesting, and we're here for it. I think that Attorney Nan Gallagher, is going to be on the Glare tonight. Don't know what time that is. Let me look it up for you in case you guys want to go watch them, and you can get Nan's thoughts on this. And let me just take a look so I can give you an accurate time. That should be interesting. I'm sure I'll see you over there in the chat. I think it's scheduled for 6 o'clock. You have an hour to take a break, an hour and 20 minutes. I don't know what the hell this judge is going to do. I don't know. What about the other motions? Well, we're coming back next Tuesday. We'll see you next Tuesday, everyone. See you next Tuesday. The BS button is in full effect. So, we also have the Mr. Tiki chain, but I don't even know what's appropriate. I smiled the whole entire time that Alessi was talking today. And to the fact that Brennan was calling him Alessi was wild to me. Is this a discovery violation or an ethical violation? That's what the judge is going to need to decide. And based on the case law cited by Mr. Alessi, I would tend toward discovery violation. I don't see any prejudice. They have the opportunity to voir dire these witnesses. And so I don't know. Why is Brennan making this crap a big lie and a big deal? He wants Alan Jackson off the case. You heard him. I mean, he said that he doesn't care if ARCCA testifies. He doesn't care. He doesn't care if ARCCA testifies. It makes no difference to him. He doesn't care. He doesn't care. Mob lawyer, mob rule. Thank you, Scott. Oh, I'm going to have a stream with Runkle. I just don't know when. We've been talking about it. We're in the works. Thank you, Thomas, for your Venmo. I appreciate you so much. Just like I appreciate each and every one of you. I need to digest this a little bit. I'm hoping by tomorrow that we'll be able to see the motion to dismiss, and we will go live with that as soon as we have it. But so far it has not hit the docket today. I'm going to check it one more time while we're here. What a day. What a duckin' day. Hang on. Let's get into the docket and see if it has even been indexed, because it wasn't. Even though we know from the motion to impound portions of it that Ms. Little filed that it was filed on Friday. And the defense was kind enough to give the court a redacted copy and an unredacted copy. I don't like their system. It's very difficult to navigate. You got to scroll all the way down to the bottom, and then you got to go over here. And no, nothing yet. Nothing yet. Make sure that you hit the subscriber button below. It is free. Make sure you have your phone set to all notifications and the bell set to all notifications. And also make sure that tomorrow is Karen's birthday. Thank you. Because I often go live on a whim. As soon as I get documents, breaking news, and you want to make sure you have all notifications. You also want to make sure that their notifications are enabled on your phone for YouTube. Otherwise, you won't get them. We need to digest this a little bit. Everybody needs to take a step back and another step back and another step back. Thank you, Thinnish Chiffon, for your super chat. Thank you, Live, Laugh, Toaster Bath. Been switching back between you and Emily Baker because you are the queen divas of legal. Thank you so much. You're 5. I appreciate you. We had a healthy crowd in here today. We were almost 16,000 strong for most of the day, so it was a good day. For justice, maybe. Good day for people who are interested in this case. And I think Emily had maybe 24,000. So just between the two of us, there were 40,000 people watching the two of our streams at all times today. I don't know what Law and Crime had or what Court TV had, but that's a lot of people worldwide. Kim says, I will pay money if one of her lawyers calls him Brennan. Well done. Well done, my friends. She's not making a ruling today at all. Yeah, she is expected to make a ruling at some point. I don't know when. So my understanding from what we just saw today is that the arguments are over. Was there anything that she had continued with regard to this topic? I am not sure. I don't think so. I don't think she was asking for any. Can I ask Ali Mata? Yeah, I could ask Ali Mata. But again, different jurisdiction. They did some research on it, but in Indiana. The federal hearing is on the habeas, the writ of habeas corpus, which is a lateral appeal. They took the SJC appeal that was denied and they moved it to federal court because it involves a federal question. And so that hearing is next, I think Wednesday. Crosby was the expert I was thinking of. Thank you. The Crosby motion. The canine behavior. Saying Alessi's name wrong is disrespectful and Brennan is doing it on purpose. Somebody said they've known each other for years. Yes, I will talk to Ali. That sounds like a great idea for our show. And yeah, maybe we're going to break some records. We'll see. We'll see. You guys are amazing. Thank you for hanging out here with me all day. I really love spending time with you. And I really love that you choose to spend your time with me because there are a lot of places that you could go to watch this coverage. I know it. There are. And I do so appreciate that you came and chose to spend your day with me. Thank you to the moderators who keep it classy as always. And for their working double time, triple time, overtime. This is a very hard case to cover, especially when there's 16,000 people in the chat. I think that's a record for us. I think maybe during one day of the Karen Reed trial, we might have had 18,000. So that was huge. I love you. Oh, if I don't see you soon, I'm going to die. No, everyone go watch The Godfather and find that scene. And you're going to laugh every time you see it because it's the scene where Michael's on the phone in the kitchen and one of the guys is like, tell the pretty girl you love her, Michael. And then they're saying, I love you with all of my heart. If I don't see you soon, I'm going to die. All right. Do all the things that YouTube likes if you would. I mean, it helps a girl out. Hit the like button, comment respectfully. Try and just keep it together. Breathe deeply. Go watch The Glare and Nan Gallagher at 6. I'll see you over there in the chat. And as always, stay cool, stay kind, stay classy. It's not hard, really. Really, it is so not hard. You can do it. I know you can. Peace. Happy birthday, Karen. Yeah, if everyone gave $1 to the Karen Reed Fund, that'd be a lot of money. Be a lot of money. Thanks, you guys. I appreciate you so much. I'll see you tomorrow, probably. I'm sure. Bye. We ain't got no quit.